Friends, I just pressed the Let's Go Live button. We got a big one cooking today. Let's wait for the tubes to connect themselves before we jump into it. We got a little bit of business to attend to before the hearing itself starts. Of course, we're talking about Big Fani's evidentiary hearing closing arguments today. It's about to get hot in here. Let's make sure the tubes are connected. It looks like they are. That's tremendous news. That means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I'm a criminal defense attorney, and today we're talking about Fani Willis and the evidentiary hearing involving Nathan Wade, Terrence Bradley, Fulton County, the whole saga. We are back in court in Judge Scott McAfee's courtroom. He, of course, is presiding, and he's going to be hearing closing arguments, summation arguments in day 4 of this evidentiary hearing. And we want to flesh out a little bit what is coming down the pike here just 30 minutes from now. We're waiting for the courtroom to kick into session. You can see we got McAfee's channel here right up. He's up to 17,000 subscribers over there, which is pretty good there for a judge. A lot of people are interested in this, and you can see we've been covering this quite some time here. And we're excited to get into this because it is the big one. We want to hear what the arguments are and hear what the judge is going to do about this. Now, a lot of questions. Are we going to get an opinion today? Probably not. If I had to guess, he's going to want to take some time to articulate his reasoning behind the decision, and we'll probably see a written opinion later down the line. But he did intimate that maybe he'll have something to say at the conclusion of today's testimony, but there's still a lot of unknowns. We still are waiting to hear kind of what the scope of this closing argument is going to be, how much time each side has, and so on and so forth. So we're going to get into it very soon. Before we jump into it, there are some things that I want to talk about disqualification. What are we looking for here? What is the judge keeping his ears percolated to hear for? We're going to talk about credibility. We'll talk about this concept of perjury, which I think there's been a lot of here. And then we'll ask ourselves about a dismissal and whether or not we're going to get a dismissal in addition to the disqualification, because there's really two things that the defense is asking for here, and we'll talk about those. We also have this new affidavit, totally embarrassing, from Fani's office. They submitted this very recently, like in the last day or two, the 27th actually. It's their last ditch effort, and they brought out Wine Guy. All right, they went out to California where Fani and Nathan, where they were, frolicking around through the dewy hills of Napa Valley. And apparently they found some dude and they're like, hey, dude, do you remember Fani coming in here some time ago? And he's like, oh, yes, I definitely remember. Oh, and did she pay you cash? She paid you cash, right? He's like, yeah, she paid me cash. Is that what you want me to say? So then there's this affidavit that they filed as though that exonerates Fani and Nathan and Terrence and all their perjury and all the other things that we've covered here. So it's just wild. Now, we're going to get into that. We're going to read through the full thing and squeeze it in before the hearing starts, because I imagine we're going to hear some argument on this. I imagine Fani's office is going to come out and say, see, Judge, he paid in cash. She paid in cash. There's evidence of this. There are problems, though. This appears like it's maybe new evidence to support an underlying point. It's not impeachment evidence like the cell phone records were that showed, obviously, that Nathan Wade was going over to Fani Willis during those booty call events and was indicting his boss. So we're going to see what is cooking in here, my friends. We're very excited that you are here in with us. You're familiar with these parties, of course. Fani Willis here, Nathan Wade, her special prosecutor, and Judge McAfee giving the old side eye out of there. We're very curious what's going to happen here because we've got two areas that we're focused on, of course, the court of law, which is where we're going to be spending the day, but also the court of public opinion. And so there's a lot happening there as well. What is the electoral pressure going to be like upon these two people? Both McAfee and Fani are running for re-election this year, so they'll be on the ballot. And so there's questions about timing of decisions and timing of whether or not we'll get a ruling before some other election deadlines might happen, maybe to preclude the possibility of opposition, right? Somebody running against Fani or somebody running against Judge McAfee maybe will want the decision to come out after those deadlines pass so nobody can jump on the ticket. But we've got some other stuff to talk about. And so as we start out, What is Judge McAfee looking for in order to make a decision? What are some of the things that we've seen here that may lead him to go one way or the other? Well, at the very start of this saga, before we even heard any potential perjury from Fani or Nathan, we were asking ourselves about disqualification and disqualification alone, really. That was the first threshold issue. Are we going to disqualify Fani? And if so, is the basis for disqualifying her, is it so egregious that we also have to dismiss the case? Because dismissal is a very, very serious remedy that the courts are very disinclined to enact in a criminal case, because they say, well, you know, it's a major problem, right? The case is gone. Like, it does not come back unless there's an appeal process and it comes back. But generally, it's a very heavy-handed sanction. And so the judge, I think, is going to be very disinclined to do that here, unless the misconduct was so bad, of course, I think that it was here, that it justifies the actual dismissal in addition to the disqualification. Because it's hard to penalize a government prosecutor. You can't really fine them. What are they going to pay? Government money? You can't really sanction them. They're prosecutors. They don't really care. So what else do? You dismiss the case. That's the real serious sanction. But before we even get to any of that, which we'll talk about, these were the disqualification factors that we started to glean from the judge's questions. And we're still waiting for the judge to really, articulate what the standard that he believes is appropriate to us. And maybe we'll hear some of that today. But here were the three major prongs that we were asking ourselves. One, was there a relationship between Fani and Nathan? Clearly there was. They've already admitted to that, okay? They put it in writing that the relationship started in 2022. Now, that's going to be the subject of some potential perjury inquiry, but they admitted that, right? So that factor is done. The next factor that we're probably going to hear a lot about today is about cash and about a benefit, right? So, okay, if there was a relationship, was there a benefit to Fani in hiring Nathan Wade? Now, she says there absolutely was not, right? Fani says, I paid cash. This whole thing was even Stevens. I'm a strong, independent woman, and I don't need no man. And by the way, Nathan Wade's racist or bigoted, sexist against women, because he says that we're only good for making sandwiches. And so I gave him tons of cash, and it was all square everywhere we went. So she says there was no benefit. Now, the opposite argument there, of course, is that there was a benefit, Fani, because if you weren't paying Nathan, your lover and boyfriend, he wouldn't have had the funds to go on the cruise with you, to go to Belize with you, to take all these trips with you, because he didn't have the cash to do that. Now, Nathan says, yes, I did. I got a bunch of other cash from Terrence Bradley and my other colleagues, and I was flush in other areas. I didn't need Fani's cash. And he said, by the way, I also work for free. And I also had most of my time working on the Fani case, on the RICO case. So very squirrely testimony there about whether there was a benefit or not. I obviously think that there was a benefit. Fani would not be going on any of these trips if Nathan was not working for her. So she had the benefit of taking her boyfriend with her on these cruises, on these vacations. She had 2-hour meetings on Mondays with her anti-corruption team. They were indicting each other at 4 o'clock in the morning and all hours of the night, traveling around to each other's residences and so on. So there was a clear benefit of working with her boyfriend. And if Nathan Wade, here's the big crux, if Nathan Wade decided that this case needed to go away because there was not legitimacy here, well, then the case would have been dismissed and he would not have gotten any more money. So it's material because it was a pay for prosecution scandal, right? Fani was keeping him flush as long as he could keep this prosecution going. And part of the reason why they charged 19 RICO co-defendants is so that he could rack up a big fat bill. If it's one defendant or two defendants, you only have a couple of hearings for those defendants. But if you add 19, right, are you going to get more money working on 3 defendants or 19 defendants? It's obvious, right? So that's what was happening here. Fani was funneling this dude $1 million, okay, on paper it's 700 grand, but we know he got paid a bunch for 2024 already and the end of 2023. So it's like $1 million. Other prosecutors, not even anywhere close to that. Anna Cross, I think, got 150. John, the white guy who actually wrote the book on RICO, he's getting like 100 grand. Nathan Wade, 7 figures. So clearly, right, in my opinion, disqualification, the elements are met. And this is before even talking about these, whether these people are credible or not, just based on the facts. there was a benefit because they admitted to going on trips together. It was material to the case because they had 19 co-defendants, and if they would have dismissed the case, Nathan stops getting paid. He can't continue to bill. So we know that there was a financial benefit that was going to Nathan. They claim that it was all reimbursed and even Stevens, but they've got no records at all to show that. We're just supposed to take their words for it. Now, speaking about that, okay, so we've got clear evidence from their own admissions, and we can logically deduce that there was a pay for prosecution scam going on here, but they say there wasn't, right? They say, no, trust us. I'm Fani. I paid him a bunch of cash back and it was all above board. And Nathan says the same thing, right? So we got two witnesses that say, oh, she paid me in cash. Did you deposit it? No. Fani says, where'd you get the cash? I don't know, ATMs, debit cards. You know, like when I'd go to the grocery store, I'd take my $40 cash back. And apparently she had thousands of dollars. And, you know, and this is a confusing issue for me because I'm a white guy and what the hell do I know? But that's according to her. So we ask ourselves, and the judge is asking himself, believe me, about the credibility of everybody who took the stand. What was their demeanor like? What was their memory like? Okay, when we ask ourselves about Terrence Bradley, Mr. I don't recall, every 2 seconds on the stand, is that credible? This dude's a lawyer. He got a law license and has been representing even the government, right, in criminal cases there in Fulton County. And he can't remember anything? And he says, oh, this happened a long time ago. No, it didn't. It happened like 6 months ago. You were sending text messages directly to Ashley Merchant that says absolutely. So the reasonableness of their testimony, right, and how they were comporting themselves in the court of law. The judge is not a dummy. He also knows about this concept called pounding the table if you don't have the law or the facts. If you have the law, pound the law. Have the facts, pound the facts. Don't have either one of those, pound the table. That's exactly what Fani Willis was doing, screaming at us. Bah! It's a lie. It's a lie. And so on. So when we look at all of these things, right, we have credibility problems all throughout this case. And by the way, the government is also poking at people like Robin Yurdy. Robin Yurdy, of course, owned the condo, and she said that there was evidence that there was a relationship that started much sooner than when Fani said. And Fani, of course, in my opinion, is lying to the court about that. But this is a situation where they are trying to impeach her credibility. They're saying, well, Robin, you're just a scorned ex-employee. You're just somebody who got fired from Fani, and that's why you're so upset about this. You're trying to take her out. And so nobody can believe you at all. They're going after her for that credibility. They did the same thing with Terrence Bradley, right? Even though I thought he was a very favorable witness to the government, they called him a liar. They said, you're coming after Nathan Wade because of your assault claims, right? And she stabbed him in the throat and the back on that one, back during the last time he was on the stand prior to being recalled. So a lot of credibility problems through and through. I mean, all of Fulton County is kind of just a total mess. In the county attorney's office, rather, is just a giant mess. And a lot of this evidence came from them. And so the judge is going to have to be, you know, navigating this. And one concern that I have about the judge is he just says, everybody's not credible. You're all uncredible. You're all just whacked out, uncredible. You know, I don't know how this impacts the case. I don't see it's material to the case, but you should deal with this with the state bar. You should deal with this with the voters in November. And otherwise, you know, I'm just, you know, if this is how you want to comport your office, then this is how you comport your office. And in other words, he doesn't do what needs to be done in terms of dismissing the case. Like, oh, we'll let the jury decide or whatever. I'll let the jury measure the witness credibility, and then you can cross-examine them on the stand. I'm not going to make a decision, but we'll let the jury determine the credibility and just kind of give us an excuse as to why this whole charade could continue on. And then, of course, we have perjury. Now, I personally think this is all over this case. Of course, the people that were focused on predominantly here, I think there were, you know, Terrence Bradley's lying through and through, but he's kind of, you know, not necessarily a huge witness here in terms of the consequences of the lie. Like, okay, he's a liar. He'll have to deal with the bar, his conscience, his maker, his clients, and the rest of his future. But Fani and Wade are the big subject of this hearing, and we care about their lies predominantly. And I think that there are 3 examples of their lies that stand out, obviously. One, the biggest one, is the affidavit. They said their relationship started in 2022. It didn't. Robin Yurdy says it started way before that. I think she said 2019, and she may have even confirmed the relationship starting at the judicial conference. I'm not sure about that, but Terrence Bradley definitely did. Okay, Bradley, in his text message, he said, did the relationship start sooner? He says, absolutely. That wasn't like 3 years ago. Okay, that was very recently. He says absolutely until he got turned. So Nathan and Fani, they signed off on an affidavit that said their relationship started in 2022. Now, you know, they're very squirrely with their words. They use loosey-goosey language because they're trying to get out of malfeasance, but they might try to parse this and say it wasn't a relationship, okay? We were just doing the hibbity-dibbity, and that doesn't mean late-night phone calls and all the other things. But unfortunately, there were a bunch of late-night phone calls and the hibbity-dibbity and Saturday phone calls as well. So it's all boyfriend-girlfriend type stuff is happening, right? So the relationship did not start in 2022. You're going to do the old hibbity-dibbity on a one-nighter or whatever, or maybe that's not a relationship. But if you're doing the hibbity repeatedly and you're having phone calls and you're having, I just got home safe, sweetheart, sleep well tonight, sweet dreams, I love you, all that type, that's boyfriend, girlfriend stuff, okay? The good morning text, the good night text, yeah, it's a lot. So we all know, right? That's relationship stuff, and that's exactly what they were doing. So they lied to the court in their affidavit. The relationship clearly started before they said it did. That's dishonest. And so all of their other allegations that I paid cash, that I got reimbursed, whatever, nobody believes it because they lied at the outset. Now, Nathan Wade, he also, in my opinion, lied during his divorce interrogatories. He said that I wasn't married. Even though he's a lawyer, he knows he was technically married. He meant I wasn't happily married, okay? And I didn't consider myself married and all that. You know, Nathan, what that interrogatory was asking. You're a lawyer. You know that you were supposed to put in there your other relationships, but you didn't want to because it was not honest. It was not above board. It was a scam relationship because you were getting paid and grifting off the Fulton County taxpayers to prosecute defendants. Not appropriate. So he put in his divorce interrogatories that there were no relationships. Then he updated those to say, oops, there was a relationship. And he invoked essentially the Fifth Amendment, his right against incriminating himself or causing undue attention to himself. And so he lied in that, right? He's a lawyer. He knows what he was doing. He knows they were asking about the hibbity, not only asking about things. He didn't get to qualify it as unhappily married. Okay, liar. Now, Fani did the same thing too. Remember in her gift disclosure forms, she's a public servant, so-called, a public figure. She has to disclose where she's getting gifts and benefits from. Anything over $100, she was supposed to disclose. They went to Belize. They went to Napa Valley. They went to on multiple cruises all over the place. I still think they wanted to go to Norway on the Norwegian cruises, but point is, all over the place, right? Lots of gifts. She, in her signed disclosure, said none. None, 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 none. Liars through and through. And so that escalates all of this. Now you take this perjury charge and you add this into this whole analysis, right? Perjury into disqualification. It was originally about disqualification until they lied. Then this whole thing got way worse. Now they're in a different world of hurt. And so does that parlay into a dismissal now? Because that's the only appropriate sanction that can be imposed upon the government. You can't fine Fani. She should pay with government money? You can dip into the government funds? That hurts the citizens. So unless you dismiss the case, Fulton County is not going to learn from this mistake. They're just going to say, I guess this behavior is appropriate. And so the sanction against the government is a dismissal. That's the only remedy that hits them. They go, they have to, it really hurts, right? That's what is appropriate. So we'll see. Now we're going to see if the judge gives us a standard or if he's going to apply a sanction to the misconduct, which would, of course, be in the form of a dismissal. And all of that is coming up. And so we're going to see what the judge does. I think if he does not disqualify her, it is not going to be a good look for Fulton County at all. It's going to be a real travesty of justice because this misconduct is evident on its face. And the judge should adhere to the law and to do the right thing here. Now, Fani is scrambling. And of course, we're getting ready for the evidentiary hearing to start any minute now with closing arguments. And we're going to see if the court has the live feed up. Not yet. We're going to check it back here in a little bit and see when that boots up. But let's take a look at this affidavit. Fani's last-ditch effort to try to get a victory in her disqualification case is not coming out with a bang. In fact, it's a whimper. It's pretty pathetic. You can see this got filed right before the closing arguments in the evidentiary hearing. It is in the Fulton County Superior Court, state of Georgia, And the case, of course, is against the 19 co-defendants, including Trump. Here is what Fani's office sent in. This is Adam Abbate, that dude who could not sit down when he needed to back during the hearing. He submitted this one just before closings. He said, all right, Your Honor, Judge McAfee, here's the notice of our proposed supplemental exhibit. Wow. Remember, Trump's team submitted a supplemental exhibit, and it was in the form of an affidavit, and it was in the form of cell phone records that showed that Nathan Wade had been colluding with Fani Willis at her condo on multiple occasions. And they flipped out about that. They said, you can't bring that in. Well, of course, they're bringing that in to impeach Nathan Wade's testimony, right? Nathan Wade's testimony was that I did not go over there a bunch. They said, yeah, you did. He's the subject of this. And so that was for impeachment evidence. Now, they did not call this witness in. So this guy is just an affidavit, which feels to me like new evidence. It's not meant to impeach anybody. It's meant to corroborate someone. And so it's new evidence to support it. But either way you splice this, just in terms of what is it as evidence and does it come in or not, it's pathetic any way you splice it. Here's why. They say, all right, comes now Fulton County and Adam and Fani. And we have a supplemental exhibit 1. Here is what this exhibit is. It's an affidavit from this guy. This guy's name is Stanley Herbert Brody. And I've heard different reports on this guy. What is his background, right? Is he a MAGA Republican or not? And they say that in April or May, okay, Brody, Stanley, May 2023, Brody was working at Acumen Wine Gallery in Napa, California. Okay, he's the wine guy. And that Brody, the wine guy, greeted and met with Willis and Wade when they were at the wine gallery. Well, that's nice. So again, they're telling us more about their trips and their vacations. And I thought this was wild when Fani was doing it. Fani was like, oh no, we went on like a 3-course thing. We had champagne, we had lobster, we had steak. Then we went out, we had some more steak, some more lobster, and I love Grey Goose. She's walking us through all this. We're like, okay, hope you had a good time while everybody else was working in Fulton County. But anyways, so wine guy says, I greeted them when they showed up, and that Brody exchanged pleasantries. Oh, hi, Big Fani. What kind of wine would you like? And she's like, well, I'm kind of a Grey Goose person, but I guess I'll take it. She says, I need my glasses, some water, and my documents, and some wine. So they tasted wine, and they discussed his profession with DA Willis and Wade. Now, Willis paid the bill. Okay, so this wine guy says paid the bill for tasting with $400 in cash. All right, so now Fani has evidence. She's like, see, I told you I paid in cash all the time. Here's evidence. So she goes and finds one dude who she paid cash. Now, the affidavit is attached as a supplemental exhibit, says he's available to come and testify. And if you don't accept his affidavit, we ask that he be permitted to testify today at 1 p.m. at the hearing. So they're going to drag out wine guy. All right, here's what wine guy says. He says, all right, affidavit of Stanley Herbert Brody says, this guy personally appeared before me. The undersigned officer who administers oath swears the following is true. So wine guy, he says, my name is Stanley Herbert Brody. I'm over 18 years of age and I'm under no legal disability, and I'm competent to attest to the matters stated herein on this affidavit. He says, I'm a real estate broker and a salesperson involved in the sales of wineries and vineyards in Napa Valley. That's Pelosi territory. I have been engaged in the business of wineries for 43 years. And I was formerly involved in Acumen Wine Gallery's business located in Napa. Now, sometime during the dates of April to May, question mark on that one, why don't you know the dates? At approximately 3 to 4 p.m., I greeted and I met with Mr. Nathan J. Wade and Miss Fani Willis at the wine gallery. So we don't know what date it was. Was there a receipt there? Did he report that as income? Now, during my encounter with Mr. Wade and Miss Willis, we exchanged pleasantries. We spoke about different wine selections. We tasted the wine, and we discussed our professions. This encounter lasted for approximately 2.5 hours. Beautiful. Now, at the conclusion of the tasting, I retrieved the bill and presented it to Mr. Wade and to Miss Willis. Miss Willis asked for the receipt. Hopefully she has that. She reached into her purse and she grabbed a big fat stack of cash. And she had paid with approximately $400 in cash. She added a very generous tip. This total included 2 bottles of wine and 1 tasting, and so they were feeling pretty good there. And so Stanley submits this. Stanley Herbert Brody, sworn and subscribed to me. They're in California and sent in and served upon everybody. So it's just like so pathetic. Okay, so are they going to give us one of these for all of their trips? Because we know they went to Belize, so this is only Napa Valley. Did they go out one time? Are they going to go out to every restaurant and confirm that it was even Stevens across the board, or no? Like, we're supposed to just extrapolate from this one random wine guy that this was the standard in every case and that is not a benefit. So the idea being, right, if she paid in cash, it was even Stevens. And so Fani did not get a benefit. And that goes back up to our original prong here, where there is a benefit. Relationship was already admitted. And was it material to the case, right? Is it a pay for prosecution? So Fani gives us one example amongst many, and we're just supposed to extrapolate that shows that there was no benefit provided to Fani, when obviously that's not true. They did go to Napa Valley together with her boyfriend, right? And he paid for a bunch of this stuff all over the place, and she paid it all back in cash. Of course, none of it is traceable. There's no records about any of it. And Fani, it sounds like, she does have a receipt, okay? He gave her a receipt. She says that she doesn't have any records of a lot of this stuff, but he gave her the receipt because Fani asked for it right there. So hopefully Fani can dig that out, because I don't think we've ever seen that. So apparently she walks around with just a big, purse full of cash. And that's the last minute, last ditch attempt. And honestly, it's like pathetic. It's like, oh my gosh, you just went out and you found some rando person to come in here and draft this affidavit for you. That's all you got. Good luck. All right. So we'll see if they bring it up. She paid cash one time. See, Judge, everything's perfectly appropriate. And we're going to do a refresh on the screen to see if we have court in session. And we do, my friends.
We filed something last Friday.
Oh, okay.
Like at 12:45.
We can hear some conversation.
I'd have to look my email. I'm not sure what it is. Well, you didn't file it. Somebody may have filed it for me.
Okay, I don't know if we have Fani in the house. I don't think so. Looks like we're going around the table. That looks like it's Adam Abbate. That's the other prosecutor. That's Nathan Wade down here. I don't think that's Fani. Right here. Is that Fani? I don't think that's Fani. So we got Ashley Merchant, John Merchant. I think we see a Steve Sadow over here on the left as well. And so we're just about a minute away from the judge coming in, my friends. And there was a conversation. I was trying to see if we could hear what they were talking about, but now it's all just kind of chatter. Yeah, so here's a great question from CR Hyatt. Says, we have not seen this one back. So CR, what's up? Says, did they boot Anna Cross after her push for the assault against Bradley? Yeah, good question. We don't see Anna Cross, right? And we had, I think Sandy on our locals was also commenting about this. What happened to Anna Cross? Where'd she go? We thought that she was supposed to be here. She was the one who was very animated and led a lot of the cross exam during the last session. But Anna Cross has not been around. And in fact, we've seen, I think, several new filings that have not come from Anna Cross. So we don't know if there's a little bit of disunity there, whether or not she has voluntarily removed herself or whether she's been asked to leave. Of course, she went after Terrence Bradley pretty aggressively on the stand. And so it's a great question. We have not seen her. Let's go. We see some good questions. What's up, Bruce? Hey, Bruce Wayne's here. Hey, Batman's in the house. Good to see you. Yeah, at the very least, hey, Cielo says, at the very least, this is a good comment, at the very least, they have proven that they are liars and there's a reason for bias. Yeah, I think that's right. Let's see here. We got some other comments. Yeah, Kenneth says this one. Says, Anna Cross is still missing in action. I believe she recused herself after realizing that Fani lied to her. Could be a possibility, right? She walks in there. She goes, what? You told me all this. And like, again, that might be why Anna obliterated Terrence, is because she got made to be called a liar. And we've got some activity. Looks like the clerks are coming out. So maybe Anna was just furious because remember Anna was saying that there was no basis for Terrence Bradley to testify because there was no conversation happening at all. And I thought that was the judge. Yeah, and Denise says maybe Fani wanted her gone. Don't know. Or she felt like she got blindsided and she saw those text messages and she realized Bradley is lying. And so she had to destroy him to save her own skin. Could be. Yeah, someone else says Anna's bailing. She's like, yikes, this is bad. Gonzo. What's up? Hey, yeah, Stephen M says maybe Anna removed herself because one of them had ethics. Nerd is asking, what stream are you watching? This is Judge McAfee's stream.
Well, that makes me question.
So I think we prefer the multicams.
All right.
All right. All right. All right.
Circuit is now assessed. The Honorable Judge Scott McAfee is presiding. Now come to
Thank you.
order.
Please be seated.
All right. Thank you, Judge. Good morning. Good afternoon. It's go time, my friends. Grateful you're joining us here.
All right, we are back on the record with 23 SC
A4.
188947. Beginning with the state, if I could have counsel for today identify themselves for the record.
Adam Abbate from the state.
All right.
Adam Abbate.
Good afternoon, Your Honor. Steve Sadow and Jennifer Little for President Trump.
Trump's attorney, Steve Sadow in the house.
Understood. Thank you, Mr. Sadow.
Afternoon, Your Honor. Richard Rice and Kristen Olowitz for Mr. Cheeley, and Mr. Cheeley waives his presence.
Going to get a
All right, on
bunch of
behalf of Mr.
appearances.
Giuliani.
Alan Stotson on behalf of Mayor Giuliani, who waives his presence.
Thank you. On behalf of Mr. Meadows.
Your Honor, Jim Durham on behalf of Mr. Meadows, he waives his appearance.
On behalf of Mr. Clark.
Harry MacDougald, Your Honor. Mr. Clark waives his appearance.
On behalf of Mr. Roman.
Good morning, Judge. Ashley Merchant and John Merchant on behalf of Mr. Roman, and he waives his presence.
What's up,
On behalf of
Ashley?
Mr. Schaefer.
Good morning, Your Honor. Good afternoon, Your Honor. Gillen, Anthony Lake, and Holly Pearson on behalf of David Schaefer, and he waives his presence.
On behalf of Mr. Floyd. Do we have anyone joining us on Zoom on behalf of Mr. Floyd?
For Harrison Floyd, remember him?
All right. Well, seeing as counsel had previously attended the prior hearings and this one has been noticed, I'll find that they've waived their appearance for argument today. Anyone on behalf of Ms. Latham?
Good afternoon, Your Honor. Bill Cromwell on behalf of Ms. Latham. She waives her presence.
All right. Thank you, Mr. Cromwell. All right. So I had been informed by counsel collectively for the defendants that they were requesting a total of an hour and a half for argument to be divided amongst themselves
Okay.
as they've already agreed.
90
And
minutes.
so to effectuate that, I'll have the time queued up and we'll start the clock running and y'all can see fit to divide that as you would like.
90 minutes.
Obviously, I've allowed
Tight.
the same amount of time for the state as well. Before we get into that, I believe there may have been a few things just to clean up as part of the record. Specifically, since we last convened, counsel on behalf of Mr. Roman had submitted a Defense Exhibit 39.
Cell phone records.
And if there are any objections that wanted to be placed on the record, I'm happy to do that now. But at a minimum, I think the intention was that I would be admitting that collectively as an exhibit,
Or
if
maybe
nothing
those are
else,
the
just for
texts.
appellate purposes for the record. Mr. Abbate, anything the state wants to add as it relates to Exhibit 39?
No objection from the state.
I have a copy for the court reporter. I printed a copy out and then I sent it all.
All right. If you've got that marked and stamped, we'll provide that to the court reporter.
Okay. Those might be the text messages. She has a big stack of paper there.
All right. And then, as I'd indicated as well on Tuesday, both parties, since the close of the evidence on the 16th, had followed up. Now I think both sides have made requests to reopen the evidence.
Yep.
On behalf of the defense, there were some issues with cell phone records, and
Yep.
the state has found an additional witness that they would like to present. And the instruction I provided on Tuesday was that for today, I think we've reached the point where I'd like to hear more of how some of the legal arguments apply to what has already been presented. And it may already be possible for me to make a decision
Judge heard
without
enough.
those needing to be material to that decision. So
Heard
that's why
enough.
we're here today. I wanted to make sure we held this time because it is a bit of a logistical challenge to get everyone in a room together. But recognizing that, again, in the interest of efficiency, if both parties to reserve part of their time to argue as if those proffered exhibits have been admitted, feel free to make whatever arguments you would like. And if in fact it turns out that I do need those to be part of the record to make a decision, then we'd have to come back and we will do those in accordance with the rules of evidence.
Okay, weird. Little
Mr.
out of,
Gillen.
little out of order, right?
We have we have not filed anything, but we also have a proffer of a witness that we would like to call in the event the court does open the evidence up. I can make an oral proffer as to who that witness is and what that witness would be saying, and I could do it, and I think in a fairly brief manner, if the court would permit me, so the court can understand where I'm coming from. And I believe also Mr. Cromwell also has a brief proffer for a witness that he has talked with and does have an oral proffer. So
are these, this is the first I've heard of it. So are these things that have been discussed or shared with the state at all?
No, Your Honor, I literally, my communication with this particular witness occurred this morning at about 10:10.
Wow.
Along with Mr. Chris Nolan was on the call with me. Be more than happy to enlighten the court as to what the say, who the witness is. And
Please.
In a brief summary
Enlighten us.
of what this particular witness would testify to in the event the court allows for evidence to be reopened. And on the record, I would state that on behalf of my client, Mr. Schaefer, we do want the record to be reopened so that the court could hear what if they want to bring in someone from California, let them bring them in.
Yeah, bring the wine guy.
The court might want to hear the proffer and the evidence that we are prepared to at least proffer today.
All right. So Mr. Gillen, on that point to this and Mr. Cromwell's, even additional evidence, in my mind, in the interest of a fair notice to the other side, I wouldn't want that to be part of the argument today because the state has no idea what you're about to say. And I think the purpose of a proffer, in large part in this role and in this context, is having them at least have the ability to make those initial counter arguments. Now, I don't think that would prevent you from, after today's hearing, if you want to file it, make it part of the record, then I think that both parties have already elected that they are willing to use that mechanism. But just for today,
It's great.
kind of showing up now without having shown this other side at all, even this morning, I don't think that would be fair.
I did not intend to use the proffer in the legal argument.
Sure.
I just wanted the court to be aware that we do have an oral proffer. We can file it, we can supplement the record and file it for the court's consideration.
Great. So
But literally
Right.
hot off the press.
Sure.
As we printed it out and drove down to the court here.
I don't think we'll get a decision
All
today.
right. Well, Mr. Cromwell, is there anything you wanted to add to that?
No, Your Honor.
Okay. Mr. Abbate, anything you want to add to that?
I object.
I don't know what it is. So I don't know how to add to it. No.
You want to take a look at it?
So sorry.
All right. Just anything on a procedural perspective.
I mean, from a procedural perspective, I would submit to the court, as you said multiple times, evidence is closed. This is
No.
beyond the scope of,
You just
I guess,
No,
Your
Adam.
Honor's ruling on, I guess it was Tuesday.
You
Looks
want to
like it
bring
was
in
3
wine
weeks ago,
guy.
But Tuesday. So I guess we'd object at this point and
Yeah, of
go from
course.
there.
Yeah, but don't
Okay.
you? Okay.
All right. Anything else by way of housekeeping, Mr. Sadow?
Apparently the state filed 2 supplemental exhibits, number
Yeah.
2 and number 3, about 15 minutes ago.
Whoa.
So to the extent that they intend to use those in their proffer with this requirement, we actually just got it as well.
Understood.
Adam's a piece of work,
So
man.
as it relates to that, Your Honor, I believe you were very clear on Tuesday as well that in the proffers, we could argue rebuttal evidence as it relates to the evidence that was submitted by defense counsel after the evidence was closed. And that's merely what it is. It's rebuttal evidence as it relates to the cell phone records or analysis that was done by the non-expert filed by Mr. Sadow.
All right.
So Judge,
Mr. Gillen.
now
As
they
it
don't have
relates
notice.
to the proffered evidence, our proffered evidence would be in direct rebuttal to testimony given in the courtroom, particularly by Mr. Bradley. So we would have a direct rebuttal of that. That's what our proffer will be. I understand the court's ruling. Just want to put that on the
Okay.
record.
Just so we know the context of it. Is that similar for Mr. Cromwell as well?
It is.
And just solely relates to Mr. Bradley's testimony?
It does.
Okay.
So we
All right.
still have a lot of evidence left. Like there's not going to be any finality here today. The judge
All
is
right.
doing,
Noted. Anything else then?
Your Honor, the proffered evidence is basically would corroborate what has been admitted in evidence as Exhibit 39, the chronological texts.
Okay.
okay. So I think
All
the
right.
judge is trying to get this over,
yeah.
like stop the
Nothing
bloodbath.
else? I'll turn it over to Ms. Merchant
He's had enough, heard
begin.
enough.
on behalf of the defense.
There's a bloodbath
Sorry,
going
Judge,
on.
Unfortunately, you're
Okay.
stuck with me today.
Understood.
Mr. Merchant. Okay. So I think the judge wants to save the embarrassment in Fulton County. Like we don't need to keep.
May it please the court, Your Honor, John Merchant on behalf of Mr. Roman. Just by way of roadmap, to give you some idea about the allocation of time and what I'm going to be covering. I've been charged with talking to Your Honor about the conflict issue and the appearance of a conflict and what we believe the evidence to show on that issue. Mr. Sadow, Mr. Gillen will be talking more about the forensic misconduct piece of it. Ms. Willis's church speech, statements made to the media.
Prosecutorial
fraud on the
misconduct.
court, frankly, and the book that she gave several interviews for. So I won't be discussing any of those issues. So if you like to ask me, certainly I can try to address them, but that's going to be the focus of their presentation. And then towards the end, other folks may have issue-specific type arguments, either in follow-up to mine or the forensicness. Those are the two lanes that we're going to be covering, but I'm going to do the conflict piece of it for you. And on that issue, Your Honor, this is a matter of first impression in Georgia. I
Okay.
can't find a single case that's been published by the Court of Appeals or the Supreme Court that is based on these facts. There are, of course, a number of different appellate court cases that deal with conflict-related issues, and more importantly, appearance of conflict-related issues. And some of those are based in state law. Some of them are based on the ethical rules that govern lawyers. Some of them are based upon the Sixth Amendment right to due process that's implicit in all of what we're doing here today. I want to remind the court that we're here today on this motion to disqualify DA Willis and her office because of her judgment, frankly. She is supposed to be disinterested under the Sixth Amendment, and she's anything but that.
That's for sure.
The fact that these proceedings have taken this long and through the convoluted way we've made it here today, explain that. So as I present my arguments, I want the court to understand that this court represents the guardrails for the Sixth Amendment in this context, and Ms. Willis has already been disqualified once. So I would encourage the court to remember what Judge McBurney did in his order disqualifying. Same argument was made in that case as to whether or not there needs to be an actual conflict of interest or whether or not the appearance of a conflict of interest
Good.
might be sufficient.
What is the
under facts.
standard?
I want to make clear to the court that the law in Georgia suggests and is very clear that we can demonstrate an appearance of a conflict of interest, and that is
Okay.
sufficient.
What is the standard?
There is, I'm going to be candid with the court. There is a Supreme Court decision from 1996, Lambie State, and then there are two Court of Appeal decisions after that deal, and frankly, in some dicta that suggests that an actual conflict is required. But the Supreme Court of Georgia, since those decisions came down, has made quite clear that the appearance of a conflict standard still applies. And the
Okay.
reason that's important is I think under the Sixth Amendment, which is where we're at, in order to preserve the defendant's rights under that provision and under corollary provisions of Georgia law, you've got to consider the appearance of a conflict. And the reason why the appearance of a conflict is so prescient here is because if this court allows this kind of behavior to go on and allows DAs across the state by its order to engage in these kinds of activities,
The whole
the
system's broken.
public confidence in the system will be shot.
Judge might be looking up
And
the
the
cases.
integrity of the system will be undermined. And so with those sort of public policy and constitutional principles, I wanted to turn to the law in Georgia on disqualification. And Your Honor, I'm gonna give you the law, and then I'm gonna talk about the facts and how they apply to the law at the end. If you want to talk about the facts earlier, jump right in, and I'll be happy to do that. I'm sure Your Honor is very well prepared and probably knows all the law that I'm going to cite to you. But to give the skeleton outline,
That's true.
The original seminal case that deals with conflict of interest from the Georgia Supreme Court is Williams v. State. That's 258 Georgia 305. And there are basically two methods by which you can disqualify a district attorney. One of them is a conflict of interest, and I'll suggest to the court that doesn't mean an actual conflict. That could mean an appearance of conflict as well, and then forensic misconduct. Importantly, in the Williams case, though, in footnote 4, and I think this is important for the court's analysis about the facts and which box it fits into, the court said there is no clear demarcation line between conflict of interest and forensic misconduct, and a given ground for disqualification of the prosecutor might be classifiable as either. And I think that's important because we have facts that fit in both boxes. So if a state stands up actual conflict here, Judge, that doesn't mean necessarily that it doesn't apply to the forensic misconduct. Typically, forensic misconduct relates to statements of the prosecutor designed to impugn the character of the defendant before trial and to affect the jury pool, which we have here, which I'm not going to discuss, but the facts that we have here very much relate to that issue, and there's crossover. Importantly, and I think this is important for the court's consideration of what effect the court's ruling may have, is if you deny this motion, there's a good chance, if it's reversed, that we would be granted a new trial. So that means we're going to have to do this all over again.
Oof. Don't want to do that, Judge.
Amusement sales versus state, 316 Georgia Appellate 727. That's a case that cites Whitworth, which is physical precedent only. The court said, if the assigned prosecutor has acquired a personal interest or stake in the conviction, the trial court abuses its discretion in denying a motion to disqualify him, and the defendant is entitled to a new trial, even without a showing of prejudice. So that means if we show the court today, and I think we have through the proceedings today and before, that Ms. Willis has developed a very personal interest in this case, and Your Honor denies this motion, we're coming back over again if the appellate court say you were wrong.
So what is that personal interest?
So the personal interest can be, there's no definition of that under Georgia law. And it could be a personal financial interest. It could be a personal interest related to bias against a particular defendant, which sort of falls into the forensic misconduct
Cruises with her
box.
boyfriend?
But we have here a very personal financial interest that's been laid out in terms of money received by Ms. Willis as a result of the scheme that she set up.
And more than that.
And
Nice. Nice. And more than that.
To get to the issue of the personal interest in the context of an appearance, I think that's important. I do want to suggest to the court that there are a number of cases that post-date this actual conflict of interest language that's suggested in some of the cases from the 90s that you have to pay attention to what this looks like to the public. And I agree with all of the law, and I'm sure the state's going to stand up here and say it can't be a speculative or a conjectural type of personal interest. We don't have that here. We have something very concrete.
Multiple
And
cruises, Belize,
as Judge McBurney
Napa
put
Valley.
it, actual and palpable, not speculative. Exactly what we have here. We've demonstrated through the testimony of the witnesses, some of whom impeached themselves, that we have a very personal interest. In the seminal United States court case that deals with prosecutorial impropriety is Young v. U.S. That's a 481 U.S. 787 case. In that case, it's the opportunity for conflicts to arise that created at least the appearance of impropriety. And that's the case that requires that the prosecutor be disinterested. Since a scheme injecting a personal interest, financial or otherwise, into the enforcement process may bring irrelevant and impermissible factors into the prosecutorial decision. Now, there are a number of Georgia cases that sort of repeat that theme. Reeves v. State, 231, Georgia Appellate 22, that's a 1998 case.
Judge is looking at his
a
list.
potential conflict of interest existed and the appearance of impropriety existed. Davenport v. State, 157, Georgia Appellate 704, that's a 1981 case. That was decided 7 years before Williams. when there is at least the appearance of impropriety, a defendant is denied fundamental fairness in the state's prosecution of the charges against him or her. There are also rules that govern prosecutors. Lawyers in general are bound to preserve and avoid even the appearance of impropriety.
That's true.
That's Brown v. State, 256, Georgia Appellate, 603, 202, 2002. Head v. State. A prosecutor's close personal relationship with the victim in a case may create at least the appearance of a prosecution unfairly based on private interest rather than one properly based on vindication.
I
of
think the
public
judge
interest.
is looking at his case list. He's done his own research,
ABA
obviously.
criminal justice standards for the prosecution function, standard 3.1.2C. A prosecutor should avoid appearance of impropriety in performing the prosecution function. 3-1.7F, the prosecutor should not permit the prosecutor's professional judgment or obligations to be affected by the prosecutor's personal, political, financial, professional, business, property, or other interests or relationships. So the rules that govern her in her own profession say that this is wrong because she developed a financial interest in this case. And at the very least, created the appearance of unfairness towards these defendants by setting up a relationship, a prosecutorial relationship with her boyfriend that she'd been dating for 2 years, according to the testimony. So before I move, Your Honor, to the specific, you asked, what's personal interest, and I think, frankly, as I was trying to figure this out, I think you know it when you see it. It's just like in the concurrence in Jacobellis versus State of Ohio, Supreme Court case from 1964, Justice Stewart, in his concurrent opinion, said, "I know it when I see it," talking about obscenity. I think you know it when you see it. I think there's
We need more than that,
enough
though.
facts in front of you that you know it when you see it.
If he dismisses
So I
the
think
prosecution,
that governing
he doesn't
principle
get paid.
helps enlighten
That's the connection.
some of the facts here. And also, I think it's not just financial. In McLaughlin v. State, I think the court's very familiar with that case, 295, Georgia 609, 2014. The Supreme Court essentially said that because the acting DA had become a witness in the case and developed a personal interest in the case due to his daughter's relationship with the victim, that he was disqualified. And because he was disqualified, his entire office was disqualified. So turning to the facts of the case, Your Honor, I think I've got, my role is 20 minutes, so I've got about 8 minutes left. So why the relationship, why did we spend so much time on a relationship between these two people? We frankly didn't care less if they had a personal relationship outside of work. That is not what the issue is here. The issue is that they began this relationship in 2019. They were dating for 2 years, and then she awarded him a contract
And then re-awarded it.
where public money, either from Fulton County or the state of Georgia, ended up in his pockets.
To her boyfriend.
That decision alone was improper. But what's even more improper is that then she and he used that money to go on personal vacations and trips.
With her. His
If Your
presence
Honor
was a
will
benefit.
remember, exhibits 9, 11, and 12 dealt with the expenditures by Wade on trips. If you do the math on that, if you look at what he spent, and then you look at the testimony about what was paid back by Willis, because the cash reimbursement theory, I'll talk about in a second, but
Yeah, joke theory.
if you do the math on what he actually paid for it and what they testified she paid back in cash, you still have over $9,200, $9,200 and $9,247 to be exact, is the amount of money they cannot account for in their testimony. And as Your Honor will remember, there was no of cash in Mr. Wade's affidavit when the best and first opportunity to raise that issue would have come up is when the state filed their response in his affidavit. That is nowhere to be found in there.
They
The
just
first
made it
time
up.
we heard about cash was here in this courtroom.
Oh, cash, Nathan said.
And so I think she's received a personal financial benefit of over $9,200 in this case that she can't account for and the state can't account for. And the reason we can't account for it is because they came up with a cash theory. The cash theory only
Before we
raises.
get into that, let me ask you this. Let's say they couldn't have, let's say the theory wasn't even there that they had paid it back or that
Any
there'd been any
cash.
exchange. Should there first be a consideration of a materiality requirement?
No.
Have you
there's
seen
none.
that in this jurisdiction or, well, it's not in this jurisdiction. Have you seen that in any other jurisdiction?
I haven't seen that, Judge. And if it was $6, that would still be improper.
Wow.
Would it
okay.
be improper where it's a per se disqualification? If someone, buys their boss a stick of gum, is that per se disqualifying because there's no materiality requirement?
Well, no, I don't disagree that it may not meet a materiality requirement, but it's a personal benefit. I won't say that giving a pack of gum is just justification for disqualifying a disreturn. I think that's part of the issue, Judge. I think it's a fact-based brief by you.
So there's a continuum involved here.
Yeah, but I think the continuum involves you looking at whether or not on the grand scheme of things, it violates the Constitution, and whether or not what there's an appearance of a conflict, and the appearance suggests that she actually received a benefit. And we know
Yeah.
that she did. They admitted it. We don't have to speculate about that. They said that she said she got a benefit, and she said she paid back certain amounts. So in that regard, Your Honor, I don't know, would $100 be enough? Would $200 be enough? I think you have to look at it.
Yeah, take the money out of it.
globally and consider all of the witnesses, consider all of the facts, consider the credibility of the witnesses, frankly.
Right.
I mean, Your Honor sat here and watched everybody, so I haven't spent
Why?
a lot of
Yeah.
time going into the specific testimony because Your Honor is well aware of it. But you get to evaluate the credibility of the witnesses as a fact finder. And, just
Just from a legal perspective, though, you're saying we can't just say dollar amount, look no further.
No.
There has to be a totality of the circumstances analysis.
I think it's fact specific, Judge. I don't really want you to pin me down on that because there's no law on it. I can't give you a straight answer because I haven't seen anything like that. And I think if we build a materiality requirement into the case law, then you're down a slippery slope then, because then it's going to be very
Subjective.
Is $50 enough? Is $100 enough? So I think it's not necessarily the amount of the money. It's the fact that she received it, and it's not insignificant. And I don't think your order has to say because she received $9,200, she's
Yeah.
disqualified. I
One
think if we go back
indicia.
to the 20,000-foot level, what's the appearance here? Is this fairness to the defendants? Does it appear that she is interested in this prosecution, or does it appear that she's disinterested? She took the stand. You can tell she's not a disinterested person when it comes to this proceeding, but we also argue she's not a disinterested person when it comes
That's
to the
true.
prosecution as a whole.
So I'd like to take money out of it.
I'm going to leave
She's
for.
still got a benefit.
I'll resist the temptation to defend my wife, who I believe to be an excellent lawyer.
Heck
and
yeah.
a member of the bar for 20 years.
Shout out to Ashley.
In good standing. But I will say this, Judge.
Good
You
husband.
don't just evaluate the credibility of the witnesses. You evaluate the credibility of the lawyers. And Mr. Abbate stood up here in open court in front of national news
Yep.
and in the national public and called her a liar.
Yeah, he did.
I need to address that for 1 minute.
Thank you.
There's text messages that are now part of the record, which now are substantive evidence for you to consider. Prove everything that she tried to elicit from Mr. Bradley was absolutely 100% true. And not only was it true, she verified through the witness himself that the motion was accurate before it was filed. So for the state to get up here and impugn her credibility, it's not only improper, it violates Berger versus United States, which is a case that says the state can't just get up here and make any argument it wants. And I encourage the court to call him out on it when he steps up here. We have to have candor towards the tribunal. You
Yep.
cannot lie to the court,
Yep.
cannot lie to the public, cannot lie to the jury. And I think that's what he did.
And Anna did too. They did.
So there's other corroboration of our view that she was in this relationship. I think, frankly, based on Mr. Bradley's testimony, Your Honor can separate the wheat from the chaff when it comes to
That was
credibility. But Mr. Bradley had two chances to correct information that he suddenly developed amnesia about.
Yep.
And he just didn't do it.
How does the timing of the relationship impact a financial interest?
Because it's part of the scheme she created intentionally in order to give benefits to her boyfriend. So there's a reason why they fought so hard on this, Judge. I mean, there's a reason that every single subpoena was objected to. Every time we asked Mr. Bradley was objected to, the jumping up and down, all of the obfuscation. There's a reason for that. They know that if Your Honor finds that relationship started in 2019, that the appointment of Wade itself was improper. And if that was improper, then he had no business as an average citizen along with the fact that they didn't have approval from Fulton County to appoint him in the first place, that undermines the indictment. It creates a structural impairment in the indictment.
Yes.
Because he had no more business being in the grand jury
Yes.
room than I did.
Yes.
So that's what they're worried about. And the reason why it's important for the financial piece, Judge,
That's
is it's how
material.
the money ended up going back to her. She put her boyfriend in the spot, paid him, and then reaped the benefits
Yep.
from it.
Got trips, got vacays.
That she created the system.
Yep.
And then didn't tell anybody about it.
Good stuff.
She didn't even tell her dad about it. So I think if in the grand scheme of things, if you're looking at the totality.
Judge
of the
writing that
facts,
down.
And I've got to sit down here in about 2 minutes to make room for my co-counsel. If you look at it, everything put together, judges, they did this, they knew it was wrong, they hid it, and even when they were called out on it, they tried to create an excuse for it by saying it happened after the fact.
Yep.
We know
Cover-up.
now from the testimony, Ms. Yuri
Cover-up's worse than
confirmed
than the crime.
that Mr. Bradley, his text messages were accurate in court testimony, but
Bless you, Judge.
that fact was accurate. The motion is accurate. And so also, I do want to point out, there's no paper trail here for the cash.
Of course not.
I know that this was I know she and her father both testified,
Cash.
that they kept cash on hand.
Yeah.
Which, I mean, keeping cash on hand in and of itself is not a problem. When you're a public official and you're required to keep track of gifts that you receive, then you need to keep track of it. But there's no paper trail. There's no
course not.
deposit history. There's no withdrawal history. There's no receipts.
Yeah.
None of that.
But you're a white guy,
Even assuming their testimony could be credible, and we don't think that it is, you still don't have enough information to track all that money that she
Yeah,
received.
you're just white.
And
You
this
don't
is just
understand.
what
But
we
does
know
the
about.
lack of evidence fall on the state?
I'm sorry.
Does the lack of evidence fall on the state? Isn't that where burdens come in?
Yeah, yes, I think they had an obligation to tell Your Honor, hey, this is where the money went.
Yeah.
And they certainly had the ability to do that if they could do it. Since they didn't do it, we have to assume they can't. And if they can't, I just want to remind the court of a very important piece of testimony from Ms. Willis that I think goes to credibility of all of the officers of the court who testified. She met with Wade and they developed in 10 minutes after talking about the financial piece, I believe, this cash theory that could not be rebutted. We have no ability to do that.
Yep.
They did,
And they're-
and they chose not to do it.
And they're lawyers. Okay.
So
they
with
have a
that, Your Honor,
higher
unless Your Honor has
obligation.
more questions for me, I'm going to sit down and turn the podium over to my distinguished colleague, Mr. Sadow.
Thank you,
Excellent.
Mr. Merchant.
Appreciate the court's time.
Okay, that was really good. Started off a little slow, but my gosh, that was very good. So we actually did get to some materiality, right? He was saying there were actual consequences to their misconduct that are structurally impairing the indictment. It has to also, in addition to be disqualification, it also has to be dismissal.
Good
Because
afternoon, Your Honor.
the whole prosecution's invalid. Steve Sadow,
I'm
Trump's
going to
attorney.
speak to what I would call a subset of forensic misconduct.
Steve.
And I'm going to assume that all the law that's been provided to you in pleadings as well as emails, you don't need me to tell you what the law is. So I want to just set up how the disqualification and then dismissal of the indictment should take place
Let's
under
go.
the subset of forensic misconduct.
Let's go. So forensic misconduct.
Roman's counsel, Mr. Merchant, filed on January 8 her pleading, her motion to dismiss and to disqualify. We were in court that Friday of that week in which I made it known that that is President Trump, may adopt that motion. I wanted to see what was going to happen before I did so. That Sunday, which would be January the 14th, 2024, DA Willis took it upon herself to go to a historic Black church in
She did.
Atlanta, having not responded at all to the motion,
Why, God?
Ms. Merchant's client. Roman.
Why?
And she made what we've now called the church speech. And Your Honor has reference to that. You didn't necessarily want evidence on that, but you know what the church speech.
They're beating on Nathan
speech
Wade
was.
because he's a racist.
It was
They're all
videoed.
racists.
It was clear that Ms. Willis had notes. She was reading from notes that she had prepared. It was a calculated determination by Ms. Willis to prejudice the defendants and their counsel. How so? By making an issue out of the fact that the person that was challenged in the Roman motion was black,
Yep.
without telling the public or the church members or anyone for that matter that the reason that Mr. Wade was being challenged was not because he was black, had nothing to do with race.
No.
It had to do with the relationship that had been alleged and later admitted to by
Both
Ms.
of them.
Merchant.
That's the hibbity dibbity.
Ms. Willis took full opportunity to the defendants, and then comes along later in a pleading and says it wasn't designed or intended to be at the defendants at all, or the defense counsel.
Total lie.
Which
Obviously.
with all due respect is just nonsense.
Yeah, totally.
The purpose of that was to get public sympathy, public empathy for what Ms. Merchant had already alleged in her motion.
Yep.
Now, that was a violation of the professional rules of conduct. It was a violation of 3.8G. There's no question about it. It wasn't in response to anything that was said. It was a public statement, extrajudicial, for the purpose of making a comment upon the defendants.
It would be in response to a motion that was filed.
But it wasn't filed in a response, in
In
a
a court,
pleading. It was
yeah.
filed in response to a motion. And the motion were allegations made. If Ms. Willis wanted to respond at that point, she could have said the facts of the matter. Instead, she misstated what the situation was, took advantage of the opportunity, an ethical violation, and the ethical violation makes it clear that you must refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused. Can you think of anything more that would heighten public condemnation of the defendants than alleging that defense counsel and the defendants were making their motion based on race and religion?
In Fulton County, Georgia.
That's as bad as it gets in Fulton County, with
Yeah.
all due respect.
Yeah, not appropriate.
That's exactly what Ms. Willis wanted done.
To cover up
And
her
remember, the state
relationship.
still had not responded.
Yeah. She went out to
So then what we
battle in
get
the
from
court
the
of public
state
opinion.
is we get an affidavit filed as part of their response.
Lies.
And that affidavit says specifically, and the affidavit is Mr. Wade, says specifically in paragraphs 26 and 27 that the relationship did not begin until 2022.
Relationship.
It
Whatever that
acknowledges
means.
the relationship and says it didn't begin until 2022. And the pleading that's filed, the state's pleading in response, indicates not exactly that, but it says there was no relationship as of November 1 of 2021, and that's on page 7. So that timing is the issue, because Ms. Merchant made it clear that we alleged and had evidence that indicated the timing was before Mr. Wade was hired, not after. So the state now has filed an affidavit and a pleading that claims post-hiring into 2022. And then Mr. Wade, Ms. Willis testify to the same thing under oath.
Lies.
Now, Ms. Yerty says it began in 2019. Why would she know? Well, she would know because she was a former friend. I know the state's going to get up here and say, you can't believe, essentially what they're going to say is you can't believe any defense witness because they're defense witnesses. And only people that would tell the truth would be Wade and Willis.
Government
I suggest
prosecutors.
to you that that's not accurate.
Yeah, right.
I suggest that the testimony that Mr. Wade gave and Ms. Willis gave, and I'm specifically dealing now with the timing issue, without getting into anything else, that
Perjury.
brought forth a true concern about their truthfulness and being what is required of a lawyer in this state,
Yep.
which is candor for the tribunal. And that's 3.3 of the professional rules. Specifically, small a1, make a false statement of material fact or law to a tribunal. So that's, as I posited to the court, that's the second ethical violation. And then you also have 8.4 of the professional rules, it says it's a violation of the Georgia Rules of Professional Conduct for a lawyer to, and that's A4, engage in a professional conduct involving dishonesty, fraud, deceit, or misrepresentation. Now, do you have to find that Wade and Willis lied? No. What you need to be able to find is that there is a concern, a legitimate concern based on the evidence in this case about their truthfulness. A legitimate concern about the truthfulness, which equates to an appearance of impropriety.
Mm-hmm.
Because once you have the appearance of impropriety under forensic misconduct, the law in Georgia is clear, that's enough to disqualify. So why should you find there's a concern with their truthfulness? ERT is the first one. You have that testimony. But then we go
She owned the condo,
to what is the most obvious indication
former employee.
that Willis and Wade were not truthful on the point of timing, and that's Bradley. Defense Exhibit 26 came into evidence. Defense Exhibit 26 comes in and says, and you know I went into this the last hearing. It says that on January the 5th, 2024, at approximately 9:49 a.m., there's text messages that are exchanged between Ms. Merchant and Mr. Bradley.
In
And the
evidence.
text messages go like just date, and that's from Ms. Merchant. Ms. Merchant says, do you think it started before she hired him? Bradley, who we now know from Defense Exhibit 39, has been texting with Ms. Merchant for a number of months.
Even in
This is not the
2024.
first time.
Right,
This
recently.
is months within the communications between the two. Mr. Bradley says, absolutely.
Yep.
Now, absolutely is not a speculative word.
I don't recall.
That's not speculation.
No.
That's a definitive statement. And Bradley then unprompted says this, and unprompted is important. It started when she left the DA's office and was a judge in South Fulton. It goes on, Ms. Merchant says, she liked it started when she left the DA's office with the appropriate, or whatever one would call it, to say it was liked. And then Mr. Bradley say they met at the municipal court CLE conference. Again, unprompted. He's now definitively telling Ms. Merchant when this relationship started.
And it's specific, not magistrate court,
Ms.
municipal
Merchant says,
court.
that's what I figured when he was married. And then Ms. Merchant says, and we're now talking about a couple hours later, she texts and says, upon information and relief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time.
Here it comes.
And Mr. Bradley responds, no, municipal court. Thank you.
Nice
Doesn't
correction.
say it didn't start then.
No.
He doesn't suggest that she's wrong other than magistrate court municipal. Now we have that and it's in evidence. And what does Bradley do? He knows that he's put himself in a position that if he testifies truthfully on the witness stand, Your Honor is in a position to be able to find, if you choose to, that both Willis and Wade lied.
They did.
So what does Bradley do? Look, you were an assistant U.S. attorney. It works when you have witnesses in this situation. Mr. Bradley did everything he could possibly do
Yep.
to evade answering questions.
Yep.
No recollection, couldn't remember,
All
it was
speculation.
speculation. Anything he could possibly say that would cause, Your Honor, not to believe that Bradley knew when this relationship started. I suggest they were clear-cut lies. And the
Lies.
truth is in Defense Exhibit 26.
Yes.
And so if we take that view that he thoroughly impeached himself, that he did not give truthful conduct, what's left standing? Generally, you would see someone who's impeached, perhaps we have some kind of core that you could point back to and say, that's the time he was telling the truth.
Text messages.
In these text messages, is it ever definitively shown how he knew this and that he actually did know it, other than just a
Oh my
assertion
gosh.
outright, absolutely. Usually, if a state has a witness that goes sideways, they've got them locked in. They've sat down with a detective, got a full statement. We don't have that here.
But what you have is a text message, which is a prior statement of Bradley that he did on his own, that was not given to him by some. The only thing that the court is just noted is, how do we know he wasn't speculating? Because you don't have to accept the fact that he wasn't speculating. The cases that I provided, I think by email yesterday, the first dealing with that, you can disbelieve that testimony and draw a negative inference. That's the Ferguson case. On Lee, the other case, you can simply take the prior inconsistent statement as substantive evidence.
And the
It has
source,
the same value.
the source was
And
Nathan
that's
Wade.
what I'm asking you to do, to take what was the unprompted statement in Defense Exhibit 26 of Bradley and take that on its face value, that is an indication that Bradley in fact knew and had said he did. If you accept that, you have to have concerns about the truthfulness
And it came from
of
Nathan
Willis
Wade.
and Wade on the timing issue.
Bradley
And,
got it
and I don't
from
know if
Wade.
this is something maybe one of your co-counsel were going to address as well. We heard about kind of the law that applies, how we're outside kind of the orbit of the core of cases we're used to dealing with here, where it deals with side switching or where someone is in the relationship, the client relationship.
Never had a Fani
The
Sadow
proposition you're
before.
putting forward now is that if a representative of the state, either the district attorney themselves, says something that's untruthful on the record, that is something that immediately has to be proactively policed by the trial court. Is basically what I'm getting at is, where in
That's
the
not what
law
he
do we
said.
find the remedy to an untruthful statement? Generally, we send you down the street to the bar, right?
Right.
And that's why I gave you the cases of Registe and Edwards yesterday. While those aren't prosecutorial cases or dealing with prosecutors, they deal with counsel. And in both those cases, the trial judge found ethical violations on the part of defense counsel, or potential ethical violations. Went through the ethical violations and said, based on that, you're disqualified. You cannot be the attorney of record in this case. What's good for the goose is good for the gander.
So-
If defense counsel can be kicked off of a case because of ethical violations, I suggest the same thing can happen for prosecutors when the ethical violations deal with truthfulness, candor to the court, extrajudicial statements. Those are the things that this court can rely upon and say, based on those, again, I find an appearance of impropriety.
Where would be the limiting principle? District attorney signs every indictment assigned to this courtroom. Does that mean she's off every case?
No, it would be when
If I found that she's untruthful, is that what you're kind of suggesting though?
you don't have to find, again, I'm not saying you have to find she was untruthful or that Wade was untruthful. You don't have to make a finding of fact that they lied. All you have to
You
do
should.
is make a finding of fact that you have genuine, legitimate concerns about their credibility, about their truthfulness. And once you find that, then you can apply Registe and Edwards.
Well, but it's the same principle though. If I have genuine concerns about her truthfulness on a particular occasion, how do those not spill over into
Yeah.
every criminal case a district attorney brings?
This
Well,
is
it's
why
because she testified under oath, and so did Mr. Wade. They didn't have to testify falsely. They could have testified truthfully. They could have indicated that the relationship, the timing was in fact before Mr. Wade was hired. They chose not to. And in that sense, that dishonesty, that constitutes a violation of their ethical responsibilities. This is not signing an indictment. This is not filing a pleading in which both sides have their own positions. This is a requirement that every witness has to tell the truth under oath. And if they don't tell the truth, or there's a significant concern about their credibility, then they're violating their ethical rules. And as anyone will tell you, as Your Honor already knew from when you were a prosecutor, prosecutors are held to a higher standard.
yes, they're supposed to be.
They're the ones that are supposed to be seeking justice. They don't have a particular, they're supposed to be disinterested. When you have the lead prosecutor and the DA giving, what I suggest to you is
Say it. Lies.
untruthful testimony.
Lies.
Based on what Yerty has said, based on what Bradley said in his text,
I'll say it for
based
him.
on the whole way it was presented to you. Bradley didn't want to testify. He first came up with his attorney-client privilege thing on that. Then Your Honor fortunately went into that. And then when Bradley knew he had to testify about it, you saw what happened. You can draw the inference, as I've suggested on Bradley, that what he said in the text message, Defense Exhibit 26, is true. The relationship in fact started prior to November 1st of 2021, that Yerty says that. And now, without getting into any detail, the cell phone records. The cell phone records show that during that period of time from, let's say, April 1, 2021 to November 30th of 2021, that there was a considerable number, 35 or more occasions where it
Fanny
appeared
calls.
that,
Fanny calls.
based on the records, that Mr. Wade was down in the area where Miss Willis was staying in Yerty's apartment. But more important is there are 2 occasions, and the state has not challenged those. There are 2 occasions where the records reflect that it appears Mr. Wade spent the night at that apartment. The state may say, we don't accept that, but they didn't challenge it. And even when they brought forth what they brought forth today, supplemental 2 and 3, they didn't challenge it again.
Nope, they didn't.
So what does that suggest? That's corroborating evidence of what Yerty had said, of what Bradley said in his text message. It's also impeachment evidence as to what Wade and Willis said about how many times.
Is that a significant, in terms of just the times? Didn't Mr. Wade testify that he was there at least 10 times during that time frame? You've now found 35.
Well, minimum of 35,
Okay.
but never overnight. He said he never spent overnight.
Put that to the side, though, just in terms of the fact that he'd been over there, that he'd visited the place, and I would presume he wasn't obviously keeping a very good accounting of it, but that wasn't something that was entirely denied.
If you're asking me, do we win on the point that he said more than 10 or around 10 and we say 35, do we win on that point?
Sure.
No,
Okay.
it's not determined.
The overnight rate might raise some more concerns. Understood.
It does. And that's the reason why we highlighted it in the affidavit of Mr. Middlestat.
It's
Because
dishonesty.
that is suggestive that they were not being honest to the court.
Yes, Judge.
So then, let's see, how much time have I used?
Too much.
Have I?
I'm letting them use the hook. So, suggestive, again, raising issues. I'm wondering about burden. Is it we're dealing with a preponderance standard?
We are dealing with preponderance standard and it's our burden.
Yeah.
No question about that.
So does
But-
suggestive get us there?
No, but it is corroborating evidence of evidence that we did put up. And that's what the purpose of the cell phone records. They corroborate what Yerty says. They corroborate what Bradley said in Defense Exhibit 26.
And they go.
And they impeach,
Yes, Wade.
to that extent, Wade and Willis's testimony.
Yep.
So if you find by a preponderance of the evidence, if you find by a preponderance of the evidence,
More likely
that-
than not.
what I call subset of forensic misconduct, ethical violations has been shown, and that there is a significant and legitimate concern about the truthfulness of Wade and Willis, they're disqualified. Now, obviously, factual findings are yours, but the law allows you to do that. You don't have to do it through an actual conflict. That's the other side of the equation. And that's what I've argued, and I think that's what Mr. Gillen's going to argue.
Before I let you go, though, this is an interesting classification. You're saying forensic conduct isn't just commenting publicly about the case indicating guilt. You're saying forensic conduct is just anything a district attorney says
No.
falls under that box?
No, I'm saying that
Improper,
that
obviously.
forensic misconduct as a subset of that would include violations, ethical violations.
That he went
which
through.
impact the ability of the defendant to get a fair trial, as well as impact the court's ability to have faith that the prosecutors, these 2 prosecutors, are acting in good faith in their own conduct. Same idea dealing with, as I said, defense counsel in the 2 cases I mentioned. Ethical violations
Gillen's like-
can give rise to disqualification.
It's my turn. Get the
And I
hell
said-
out of here.
Here.
All right. Thank you, Mr. Sadow.
Thank you.
Okay. So this judge is doing some normal stuff, right? He's trying to poke
Where's the
holes
shot clock when you need it?
Right there.
right there.
Your Honor, I want to address very directly here. What we have is a systematic, continuous pattern, a calculated plan, evidencing a design to prejudice the defendants in this case,
That's right.
in the minds of the jurors. This is what we have seen. This isn't the problem that the district attorney has. It's not that the district attorney had some sort of brief off-the-cuff statement in an interaction with a reporter like in Williams. That's not what we have here. We have someone who sat down, wrote out her speech, wrote out her plan, who sat down for whether it's 2, 3, or 6 times with the editors of Find Me the Votes and told and got her message out about this case before it was supposed to be tried in this courtroom. And so that is the problem that we have. We have a pattern of forensic misconduct on behalf of Miss Willis.
So
Now,
Harold, he's going to
we
do
have
it
a
to the other
pattern
side
of
too.
public statements being made. I take it you or your team has dived in and read the book. I know she was asked about specific portions in it. The only case that I can find actually talking about when someone crosses the line on public comments is that Williams case, and it talks about there has to be an implication of saying the defendant, a particular defendant, is guilty, and it even denied it. Right. So, have you found any case in Georgia where they actually said that a prosecutor had gone too far in their public comments? Does one exist?
well, number one, thank goodness it doesn't happen often.
Yeah, we don't have
Sadly,
a lot
it's
of
already
big
happened
fannies
here.
Yeah.
Now, in Williams, the prosecutor had one response to an inquiry. The court found that it was improper, but did not have this pattern. Now, it doesn't necessarily mean a comment about the quote guilt or innocence, although that was the pattern in Williams. It's the improper comments by a prosecutor. For example, in Williams, they cite the nature and consequences of forensic misconduct in prosecution of criminal case, a 1955 Columbia Law School article, and how prophetic that was. When Williams cites that case in that law school, they talk about an awful lot more than simply the comments about specific guilt or references to guilt. What you have here, Your Honor, is a comment, and we can't look at it doesn't apply only if a prosecutor said, I think the defendant is guilty in my mind. No, it's more pernicious than that. What we have here is someone who sat down and drew up a plan for 2 reasons. And what she did reminds me of what the court in Estes v. Texas talks about, and that is that pretrial can create major problems for a defendant, indeed more harmful than publicity during a trial, for it may set the community opinion as to guilt or
Exactly.
innocence.
Programming
That's
the
what we
jury.
have here. That's exactly what we have. And the court in Estes talks about the power of the television camera. So what
And the
what
prosecutor.
do we have, and what did this prosecutor do? What she chose to do is sort of what was criticized by the Supreme Court in Shepard v. Maxwell. Legal trials are not like elections to be won through the use of meeting halls or the newspaper. That's exactly what we have here. What we have is a deflection. What this is all about is more insidious than just making the comments that she's made. It's a deflection. What she chose to do was to say, okay, I have done my best to hide the relationship with Nathan Wade.
It was a
And Nathan
cover-up.
Wade has done his very best by filing false documents in his divorce case to
Misconduct on
hide
top
his
of
relationship
misconduct.
with Miss Willis. Now, and so what did they do? Well, when Miss Merchant filed the motion to disqualify, now the game plan has to change. The game plan I call the deflection begins to take place. The deflection is when the district attorney sat down and wrote out. Look at I'm sure the court has. When you look at that video, it's in evidence of her speech at church. She has written out everything and she's reading from it. She chooses to deflect. The court asked earlier, wasn't she really responding to the motion that had been filed against her? Would that she had. Because if she had, she would have looked the members of that case and say, there's been an allegation that I had a romantic relationship with Mr. Wade. And ladies and gentlemen of this congregation, it's true. She didn't do that. She chose to deflect and to do two things that are reprehensible.
Yes.
For any lawyer, but particularly for a prosecutor. She
The
chose
DA.
to pull out the race card and the God card.
Yep.
That's what she did.
To a
And she
bunch of
wrote it
jurors.
out. She went on to deflect away from the allegations in the Wade motion. And she said, she's saying, why, in her talk, public discussion with
God?
God, why are they only attacking one?
'Cause
In
you slept
reference
with
to
him.
Mr.
That's why.
Wade.
Not
And
complicated.
then she goes on to say, God, isn't it them playing the race card when they only
No.
question one?
No.
Now, if she had been truthful with that congregation, truthful with the community, she would have
And
said,
truthful with
I had a
God.
relationship with him. Good, bad, forgive me, whatever. That's what she should have said.
She
But
didn't.
she chose to deflect and say, them, the reference to them and the others and they. It's obviously a reference to the by Miss Merchant.
Clearly.
They choose to go after the black man.
Yeah.
And she then goes on.
boyfriend.
Again, deflecting away and deflecting to what I call the third rail in American society, choosing somebody on the other side of being a racist. So-and-so is a
Disgusting.
racist. They're
Yep.
racist.
Yep.
She was the one playing the race card in a way to try to deflect from her own conduct.
Misconduct on misconduct.
She goes on to say in discussions with the Lord, God, is it that some will never see a black man as qualified no matter his achievements? Again, the deflection. What is she saying? The listener is not necessarily in that audience in that church. The listener is at Fulton County. The potential jurors who will come into a courtroom and say whether or not they can fairly judge the evidence or judge the defense in this case. She chose to inject race into the minds of the listeners and virtually everybody in this community, and literally everybody in this country has reviewed and analyzed her speech that she made in a premeditated way. And in not only the race card, but also in bringing in the religious matter. This is exactly what Hammonds v. State in our Supreme Court talks about, condemning as an inflammatory appeal to the jurors' private religious beliefs. Why would she do that? To deflect. But now, not only is she deflecting, but she is then going forward and, in a way, telling the community, telling the congregation that God is on her side,
Yeah.
not on the side of these people.
Right. Those evil racists.
God, she said, and when she's talking, and she's saying, God is saying, pray for their souls. I, meaning God, qualified you. I qualified your imperfect, flawed self. I see you in every hour. Do my work.
Wild.
As though she's telling the folks in her very, very, very implicit way, injecting into the minds of the jurors, God wants me to win this case. God wants me to prosecute this case. And why is he going, and why are these others going after the black man? Well, the answer is very simple. As we said in our brief, we didn't mention
You
Mrs.
slept
Cross,
with him. That's why.
Cross, the white female, or Mr. Floyd, the white male, because there was absolutely no evidence and is no evidence of a personal romantic relationship with them in which he
Very
obtained these benefits. That's the reason why we did not do that. So she goes forward with her with the deflections. That's exactly what she does when she goes forward, and she talks about a planned interviews time and time again with authors of a book, Find Me the Votes, where she's talking about a case that's going to be tried in this courtroom. It's reprehensible.
So in that specific, instance, setting aside the fact that she was willing to go on the record before a case had even reached the jury, what specific statements from that book do you contend cross the line?
Well,
book.
for example, she's saying, she goes on to talk about all the calls that she gets from people calling her racial terms. All the calls are racist. What she's trying to do, and I think there's a reference in there to MAGA people, whatever. In that, what
Of
she's
course.
really saying is that those people calling me up and making those claims or those horrible are really people on their side of the fence. That's what she's doing. And there's no reason, Your Honor, ever for a prosecutor to sit down and go forward with this kind of interview. She did it in Find the Votes. But then what really happened here is this hiding of the relationship. Because in hiding the relationship, they have done such a good job. Mr. Wade filed false documents in his divorce case.
Yeah, in his
When,
interrogatories.
on May the 23rd, May of 2023.
Yep.
Talking about, have you ever had sexual relations with a person during the course of the marriage
No.
or including the period of separation? He's still married. He doesn't have a divorce decree, but his answer is none. Then he's asked whether or not on any occasions he's entertained or been entertained by someone, for a woman, a member of the opposite sex, in this case a woman, from the
Another
date of the
lie.
marriage to the present, talking about place and time and all that. What is the answer? None. Why does he do that?
Cover
He
up.
does that because he doesn't want to tell about the relationship that he has with Miss Willis and the benefits that he has gotten and that he gave to her.
Amen. Right on.
And what these answers
And he's a
are
lawyer,
absolutely
okay? He knows.
reprehensible that a member of the State Bar of Georgia would file these answers
It
that
is
are
true.
that are inaccurate.
It's a
What does
flagrant lie.
What does Miss Wade do? Miss Willis do? Miss Willis, on her financial report,
Great.
on whether or not she has gotten anything of $100 or more in value from
Another lawyer.
a prohibited source. The court asked earlier about what a threshold might be. Well, and for the financial report, it's $100. That's it. She doesn't report any of all of the benefits that she received from Mr. Wade, all the trips, all the entertainment, all the 3 nights in the luxury suite
Yeah.
in Aruba,
Napa Valley,
all of that.
Belize,
None of that is here.
Caribbean.
And they say,
Miami.
oh, well, maybe it all balanced out, even though I can't prove it with the cash. Well, that's like saying, did I give the court a Christmas present? Well, maybe I gave the court a Christmas present and the court gave me one back. The court has to fill out a form whether you got a Christmas present from anybody. You say, I got one from Mr. Gillen. You don't say, nah, well, I gave him one back, so it really evens out.
Right.
They're
It's ridiculous.
reports. And because they're false, what they had to do is they had to say, uh-oh, Miss Merchant has caught us. And so what we're going to do is we're going to get, in our response,
Nathan's
we're going to
whispering.
get Mr. Wade to file a false declaration, which he does.
He
His
does.
declaration in this case is false. And
Lies.
the evidence showing that that is false as it relates to the timing, and the court asked earlier, why does it matter, if the relationship was before or after November 1, 2021? The answer is they think it's important. And frankly, I do too, because when she's hiring somebody and she's not telling the people who are going to be paying the tab up to $700,000.
Yeah.
Hey,
Over that now.
I just hired my boyfriend who's taking me on trip to the Caribbean and taking me down to Aruba and taking me to California.
Crazy.
Hope you don't mind. No disclosure whatsoever. And the money flows off. But because they got caught, they then commit what I think is an additional component of forensic misconduct.
Yep.
And that is fraud on this court.
Yes. Said
When
it.
they filed that affidavit, and now it's been proven, I think, beyond virtually any doubt that the relationship occurred November 1, 2021.
Lies.
And the benefits that were there. And we don't have to run around. And I love we've got all the records showing from Mr. Wade about the payment for these trips, for the cruises, for the flights, all this stuff. What's the only way is they sat around and met together before they testified.
and came up with their story. What's the
Cash.
only way that they can save themselves? Pay no attention to the records. Pay no attention to the airlines and to the flights and the vacations and the cruises. I paid him back in cash.
Mm-hmm.
Show us your receipts. Where did you
Don't have
take
any.
cash out of the bank?
Did you deposit it?
Ever?
No.
Oh, I don't have any. Well, show us the deposits
Nope.
that he had.
Don't have
Never. We don't have any. What we have here is a fraud on this court, which has been shown, I think, overwhelmingly by the evidence and overwhelmingly through not only the testimony of Yurdi, the testimony of the emails and the text from Mr. Bradley to Ms. Merchant, as well as all the documents that they had no answer to other than the just trust me, gave him money, it evaporated, I don't know where it came from,
Yeah, it's-
and he doesn't know what he did with it. Just please trust us and believe us because it's our only way out
Yeah.
of the trap that they set for themselves.
Yeah, we're prosecutors.
These people, sadly, and I hate to say I was a former.
Let's get
as the
it.
court knows, I was a prosecutor for about
Say it.
3.5 million years, it seems,
Say it.
in the federal building, and I was an assistant DA beforehand. Prosecutors don't act like this.
Yes.
Lawyers don't act like
Yes.
this. These people, Your Honor, is a systematic misconduct.
Yes.
And they need to go.
Yes.
Thank you.
Yes. Yes. Mr. Gillen calling them out and laying it all down as he should. Absolutely true. It's disgusting, reprehensible behavior. And finally, someone
Your
called
Honor, I'm
them
going to
out
cover
right in front
a
of their
few
faces.
factual details without overly rehashing what has already been said. During the pendency of this investigation in this case, Mr. Wade and Ms. Willis basically lived Robin Leach's lifestyle of the rich and famous. And they did this riding on the backs of the defendants in this case, funded by the taxpayers of Fulton County and the
Yep.
state of Georgia.
Exploiting the
With the money
defendants.
that was Mr. Wade through the contract that Ms. Willis got him. That money flow, that is the personal interest that you asked about.
Yep.
She was personally benefiting from the position, from the job, from the scope of the investigation, from the scope of the indictment and how they conducted it.
And the companionship.
And we know this, we know from the records that have been submitted before the court that Mr. Wade paid at least $17,095 towards this relationship. That does not even include the various dinners, the day trips that both Wade and Willis admitted to. So that number is likely even higher. We know from the documents that Ms. Willis only paid $1,394 for an airline ticket.
Yeah, there's a benefit clearly.
We know from Ms. Yurdi, who was pretty much uncontested. There was no evidence presented by the state disputing her time frame that relationship started in 2019. She saw them kissing, she saw them hugging. Now, whether or not they had sex before January of 2022, I do not know. They admitted sometime in early 2022, and I found it curious that Wade and Willis just went straight to the sex. So maybe that's when they started having sex. I do not know. But the relationship predated that.
Yeah.
And their combined
It was at the
and
conference.
overly suggestive focus on that.
I know
is
what
a
goes
red
on at those
herring to this
conferences.
court and to
Okay.
the defense, that's what they want you to focus on. They want you to ignore all the evidence that the relationship predated that. The relationship started in 2019.
With they had
The
their robes
relationship
on.
continued through 2020. The relationship continued through 2021. Looking at the cell phone communications, just in the first 11 months of 2021, over 2,000 calls, almost 9,800 texts. I don't even think love-struck teenagers communicate that much.
No, that's a lot.
The November 29th,
We got work
and
to do,
November
man.
30th, escapade. Phone call from Miss Willis, between Mr. Willis and Mr. Wade, 11:32 that night.
Who'd he call? Fanny call.
Shortly after midnight, the phone starts traveling down from where Mr. Wade lives. It ends up where Miss Willis is staying, and he's there
For an overnight.
until roughly 4:55 a.m.
Ooh.
None of the excuses, none of the explanations that Mr. Wade gave, experience, going to dinner, going to the airport. None of that explains that.
Porsche experience.
I'm
Yeah.
pretty sure the Porsche experience isn't open in the middle of the night.
I don't think so.
I'm pretty sure that there weren't any restaurants that he drove 30 to 45 minutes to go eat at
At
in the middle of
3:30 in the
night,
morning.
right
Yeah.
after he talked to Miss Willis.
Yeah.
Um,
They were indicting each other.
Teenagers have a
We all
name for
know
those
it.
kind of calls and those kind of escapades. I won't go into it.
Booty fanny
but
call. It's a
the
fanny call.
documentary evidence, the objective evidence, undercuts everything that both Wade and Willis said. When you look at Miss Yurdy, again, she unequivocally said that relationship began in 2019. She saw physical evidence of a romantic relationship. Mr. Bradley, in the text messages, which are substantive evidence, said that that relationship began in 2019. Again, his January, temporary amnesia
Yeah.
that somehow was triggered temporarily after Gabe Banks called him.
Weird. Yeah. Weird.
We can question that.
I don't
But we do
recall.
have statements from him that specifically said that relationship predated Mr. Wade's appointment.
And it matches
Um,
Yurdy.
You asked, well, and Mr. Wade, you asked what the materiality would be. How much is enough? Well, clearly 17,000 is enough. But Fulton County has told Mrs. Willis what the materiality is. It's $100 in a year. She twice signed declarations, certifications that she did not receive any gifts. And even under her strained explanation, there were monies, there were gifts, there were dinners, there were excess contributions flowing her way that exceeded $100. Her explanation, well, I just paid it in cash.
Yeah. Strong, independent woman.
That
You
just
don't need no man.
does not stand to reason. It does not hold up to the light of truth.
And Wade's a bigot.
Anyone that
Sexist.
has ever been in a money laundering trial, a forfeiture trial, if that's the explanation we give the state, they laugh.
Of course. It's
Oh,
ridiculous.
I just gave cash. I have no records for it. I have no source for it. The only thing that
innocent.
she could say that was the source for the money said she was down to $500 to $1,000. The only explanation she have is, well, sometimes I go to Publix and I may get an extra $50.
Yeah, right.
That shows up on your debit card.
Would
or
you
your
like
credit
cash
card.
back with that?
Did they bring those records in? No. Did they bring her bank accounts in? No. Did they bring any documentary
No.
evidence in? No, they did not. And why is that important, Judge? Yes, the burden is ours. But under OCGA 24-14-22, if a party has evidence in such party's power and within such party's reach, by which he or she may repel a claim, and they had that power, Ms. Willis had that power, Mr. Wade had that power, that they can repel the claim that we have made against them, but they admit to produce it, or if they produce weaker evidence, then you, as the fact finder, Judge, it is in your power to disregard that, and a presumption arises that that documentary evidence that is in their possession that they failed to produce supports our claim.
We're talking about burden of proof here.
And that is something that the state relies on regularly in criminal trials. And that is something that the court should rely on in this case when formulating its factual findings.
Who has the burden?
That both Mr. Wade and Ms. Willis have some difficulty expressing the truth when it comes to their relationship in these cases.
A lot of
We know
difficulty.
Mr. Wade lied in his interrogatories multiple times. We know Ms. Willis falsely certified that she hadn't received any gifts from anybody. And Mr. Wade clearly was a prohibited source. He was someone doing business with Fulton County. Anything over $100 in a year, she had to put down, and she put zero. And it
And they lied
defies
about
imagination that she could somehow forget about all these trips, all these dinners, all these day trips,
Total cover up.
and not put that money down. You had asked, I think it was Mr. Gillen, did she say in that church speech or anywhere else that the defendants were guilty? And I think she did in that church speech. She said in that church speech And she was talking about a conversation that she apparently had with God, talking about herself. She said, this leader has a trial conviction rate of 95%. She said, the trial team this leader put together has a conviction rate of 95%. I do not see how anyone that was purposefully intended by Ms. Willis, I do not see how anyone can listen to those two statements and not take that Ms. Willis is telling everyone in that church and everyone that's going to hear that in the media afterwards that these defendants are guilty. That is what she was saying. She is a prosecutor. She's familiar with the U.S. v. Berger. Every single attorney that's ever been a prosecutor is familiar with the dictates of that U.S. Supreme Court case. That is a foul blow. That is improper, and she violated pretty much every tenet a prosecutor must abide by to seek truth and justice in a particular case.
She's Fani, you know, biggest Fani in Georgia. She can do whatever she wants all the
So,
time.
Judge, when you're looking at this, the uncontroverted evidence shows that they had a relationship prior. The uncontroverted evidence shows that Mr. Wade lavishly spent on Miss Willis.
Yes.
The uncontroverted evidence shows that the money that he was spending on Miss Willis came from this contract that he had. And I'm not just talking about the contract as a special prosecutor, but there's also those other questionable contracts that no matter whom his partner seemed to be, so got.
They got him, yeah.
There is a
Totally
direct
correct.
financial benefit that Miss Willis received from this. And Judge, looking back at what Judge McBurney said, if merely hosting a fundraiser for a political opponent of a putative defendant creates not only the appearance, but an actual conflict, then what Miss Willis has done since then in this case creates an actual conflict. But again, as prior counsel has stated, we only need to show the appearance of a conflict. And we have done that by a preponderance of the evidence.
Great.
In fact, I believe we've shown an actual conflict. But nonetheless,
Beyond a
the result
reasonable
should
doubt,
be
too.
that Miss Willis and her office should be disqualified from this case. We still have a few more minutes. I think Mr. Cromwell may have something to say.
Well done.
Thank you, Your Honor.
Okay, so a lot of conversation about the burden of proof. And remember, this is a little strange because the burden of proof in a criminal prosecution, of course, is with the government. But the government
Good afternoon, Your
is
Honor.
on the defense now.
Harry MacDougald for Mr. Clark. I'm going to talk further about conflicts, and I'm going to assume the most difficult standard for us to meet with full conflict.
Actual
But
conflicts.
before I begin that, I want to add just a little bit to what has already been said about the standards that apply to prosecutors. Our appellate courts have said often, the administration of the law, and especially that of the criminal law, should, like Caesar's wife, be above suspicion and should be free from all temptation, bias, or prejudice so far as it is possible for our courts to accomplish it.
Good luck with
The
that,
first
Fanny. Yeah, right.
Occurrence of that I can find is Nichols v. State more than 100 years ago, 1915. The most recent, Registe v. State in the Supreme Court in 2010, although they don't refer to Caesar's wife. That requirement is also embedded in the prosecutor's statutory oath, 15-18-2, which requires impartially and without fear or favor discharge my duties as district attorney and take only my lawful compensation, so help me God.
So some color here, right? We get a little flavor.
The general rule on
Caesar
conflicts
and
of
other
interest
things.
for lawyers is in Rule of Professional Conduct 1.7. And we all know, it's all drummed into us, that we cannot have a conflict of interest. And if we do, we have to withdraw or we will be disqualified.
Totally true. And it's a big thing
The
for lawyers.
basic idea is that a conflict of interest impairs the lawyer's independent professional judgment. That's the test of a conflict and whether it can be waived and whether it's disqualifying. And that conflict is not just financial. It can be any conflict that impairs your independent professional judgment. And you see that in McLaughlin v. Payne. The court asked what was a personal interest for purposes of disqualification. It's anything that impairs professional judgment. That's reflected in the ABA standards that were quoted by Mr. Merchant, which list the prosecutor's personal, political, financial, professional, business, property, or other interests or relationships. And that's really embedded in the prosecutor's oath to act impartially. And the earlier disqualification order by Judge McBurney was based on political interests, not financial. What my colleagues have described as forensic misconduct is also cognizable as a conflict of interest footnote in Williams' case. The root of all of the problems that we see in this court right now is a conflict of interest arising from their individual personal interests
Yes.
in perpetuating and concealing their relationship.
Yes.
That's the original sin
Yep.
from which all of the other problems flow.
They could have come clean.
There are 6 different actual conflicts of interest in this case, any one of which warrants disqualification,
Let's go.
but
6.
collectively practically compelling. First, the financial conflict that's already been covered. Second, the personal ambition, political ambition. Third, there's a dovetailed or complementary pattern of deceit and concealment
Yeah,
of the
cover up.
relationship and the money.
Which is not
Fourth,
good.
the speech at the church. Fifth, the motion for protective order that the DA filed in Mr. Wade's divorce case. Sixth, the way the state has conducted the defense
Yeah.
of this motion to
Asking
disqualify,
for sanctions
especially
for
the hearing.
Ashley. Disgusting.
On the financial piece, the court asked for a limiting principle and asked about materiality. The limiting principle pairs the independent professional judgment of the lawyer that is applied routinely. We have a county code section that flatly prohibits gifts from contractors. Period.
That's the
We
limiting
have,
principle. Here
by
you go, Judge.
analogy, the federal bribery statute,
Here
which
you
has
go.
a threshold of
It's good.
$5,000, 18 USC 666.
5,000 with the feds.
The court asked about burdens and inferences. The court can draw a negative inference from the state's failure to produce evidence to support the invisible magic cash balancing theory
Yes.
based on State v. Thomas,
Magic cash.
311 Georgia 407.
It's invisible.
Particularly footnote 19. As to the timing question that the court asked about, there were 2 contracts for Mr. Wade executed after they acknowledged the relationship began. Each one of them afflicted or conflicted under county and common law.
Yep. There you
The
go.
second conflict is her political ambition, for which she was previously chastised by Judge McBurney. And that's also present in this book.
Held up the book. Love
The
it.
inside book says that they were given, quote, exclusive access to thousands of secret documents, emails, text messages,
This is good.
and audio recordings. The court has twice denied defense motions to unseal special purpose grand jury materials. She helped herself to get the glory of this book.
Yes, she did.
I
Good.
introduced certified copies of a number of county code sections. I'm not going to walk through those, but I'll tell you why they matter. The stack of law from the state constitution down to the county ordinances imposes a regime on the DA under which she has 3 obligations. She has to go to the county commission to get approval to pay him like she did. She cannot accept gifts from a prohibited source.
Didn't do any of that.
She has to disclose the gifts that she received. She evaded all of those requirements.
Yep.
Section 2-69 of the county code prohibited sources, which he was, there's no boyfriend exception.
No, there isn't. This guy's
The
plugging
disclosure
holes.
forms,
He's
the
cleaning up.
evidence is sufficient for you to find that her disclosure form for 2022 is false
Yep.
and that it is a false writing. That's an actual conflict of interest between her duty, legal duty of disclosure, her legal duty of candor as a prosecutor, and her private and personal interests in concealing the relationship, concealing the gifts, and keeping the gravy train rolling for as long as possible.
Totally. More
His
cruises.
part in the pattern of concealment is a story you see in many divorce cases. The husband is hiding things from his wife.
Totally.
How much money he's making, the other woman, and what he's spending on the other woman.
Yeah, Nathan, talking about you
And he
there.
got on that stand. He lied in his interrogatories, and then he got on the stand and he lied about lying in the interrogatories.
Yes, he did.
And the lawyers for the DA's office, they just sat there and let him do it.
Yes, they did.
They did nothing to correct obviously perjured testimony.
Amazing.
In and of its qualification of every one of them.
Yes, yes.
The reason they lied and covered it up was to avoid the trouble they're in right now.
Yep. In your
That
courtroom,
served their
Judge.
personal interests to the detriment of their public duties as prosecutors. The speech at the church. I want to focus on why she did that. Mr. Gillen talked about that. She did it to deflect attention from her own misconduct and that of Mr. Wade. She violated her public duty as a prosecutor to serve her personal interests and the personal interests of her boyfriend. That is a disqualifying conflict
Yes.
between her personal interest and her public duty that is actual, operational, and materialized, and it rests on undisputed facts. The next thing that she did that was a disqualifying conflict of interest was the emergency motion for protective order that she filed in the divorce.
Yep.
I filed a certified copy of that as Exhibit 37.
Why is
She
her
sought a
office
protective order under the Apex doctrine.
intervening
grounds
in
that
Wade's
she's the
divorce?
The whole filing is expressly predicated on her status as DA.
Yep.
In fact, she never lets you forget it. She says it 27 times in 12 pages.
And she threatens to charge
In
people.
that filing, speaking as DA, she said,
Yes.
the circumstances, quote, suggest that defendant Joycelyn Wade is using the legal process to harass and embarrass District Attorney Willis,
And interfere.
and in doing so is obstructing and interfering with an ongoing criminal investigation.
Love it. Love it.
In the prayer for relief on page 11, she asked for 6 months to, quote, complete a review of the filings in the instant case, investigate and depose relevant witnesses with regard to the interference and obstruction this motion contends. There's no sugarcoating it.
No.
That's a clear violation of Rule of Professional Conduct 3.4H, which prohibits lawyers from making threats of criminal prosecution to gain advantage in a civil case.
So disgusting.
She abused her power. She abused her position to threaten her boyfriend's wife with criminal prosecution to gain advantage for herself and her boyfriend in her boyfriend's divorce.
And maybe doing the
She
same thing with
violated
Terrence
her public
Bradley.
duties not to make that
Why
in
did
order to
Bradley
serve
flip?
her private personal interests and those of Mr. Wade. Another actual operational conflict. The last category is the conduct of the defense of this hearing. There were a lot of objections made based on attorney-client privilege during Mr. Bradley's testimony. Most of those objections were made by the state. But the privilege being asserted does not belong to the state. It belongs to Mr. Wade. That shows that the DA's office is serving the personal interests
Of Mr.
of the
Wade.
DA and Mr. Wade
Yes.
in carrying out further concealment and cover-up of their relationship, and not the cause of justice they are sworn to serve. That is a conflict of interest. It's a continuation of the wrongful pattern of concealment and cover-up that they've engaged in since the beginning.
Love it.
But now they've enlisted the entire office in the enterprise.
And they put perjurers up on the
In the
stand.
written response to the motion to disqualify, they said this, and I quote, "To be absolutely clear, there is evidence that DA Willis derived any financial benefit from Mr. Wade." That's on page 15. Flat out false.
Yep.
10 lawyers in this case put their name on that, starting with the DA. So throw another log on the bonfire of conflicts of interest. The problem here is the DA cannot distinguish between her personal interests and ambitions on the one hand and her public duties as a prosecutor on the other, and apparently neither can anyone else in their office. Of the 6 conflicts I've identified, only one is subject to a conflict in the evidence. This is a case study in what happens when you operate under a conflict of interest. It's put an irreparable stain on the case. Think of the message that would be sent if they were not disqualified.
Yes, Judge. Think about
If
that.
this is tolerated, we'll get more of it.
Yep.
This office is a global laughingstock
That's
because
true.
of their conduct.
They invented Fani Call. Booty call is now Fani Call. That's how bad it is. They invented a whole
They
new
should
word.
be disqualified and the case should be
Yes, it should. Dismiss the case. This has been
There's not
excellent.
much oxygen left in the room. We delineated the times based on the whole presentation. Would Your Honor consider some time for us in rebuttal?
No.
Okay, well then, could I reserve what I had, 5 minutes for
Sure,
rebuttal?
that's fine.
All right, thank you, Your Honor.
All right, let's take a quick 5 and we'll be back at 2:40-ish to be here from the state. Thank you.
So, my friends, man, this has been very good. So, we're also going to pause and do a quick. All right, sorry, Judge. Oh, sorry about that. Stand up, everybody. Put your phone down. All right, Judge is all right. Sorry about that, Judge. I was excited to debrief the case. All right, please be seated. Okay, my friend. So that was actually very, very good. And you see how this broke down, right? They all just came out, and the judge was asking some hole-poking questions at the very outset, which I think is very normal. This is a little bit unusual because it almost has like an appellate format, right? The judge doesn't even really know what the law is because this is a case of first impression. Never seen something like this in Georgia before because they've never had someone as problematic as Fani apparently in that office before. So Fani is causing a whole new bunch of law to have to be created in order to deal with this Fani scandal. And so the judge is kind of asking them to brief him on this, all right? And I know the judge has done a ton of work on this. You can see all of his notes back there. He's writing stuff. He's looking stuff up on the computer. And he's trying to really determine what is the rule, what is the standard. And you heard a lot about this today, about the burden of proof. And we're talking about burden shifting. And this is going to be very important because the government is going to say that they don't have a burden to provide any evidence, right? If this is the defense motion to disqualify and dismiss, it's their motion, they have the burden. And so this is like a weird little hearing because we're tucked in the middle of a criminal case and everything just got flipped over essentially for this one limited hearing. So now the prosecutors are like the defense and they're going to say, we don't have to prove anything. Just like a defendant, right? A defendant in a criminal case can literally not testify or present one shred of evidence, not say anything. And if the government doesn't meet their case and prove their case beyond a reasonable doubt in a criminal matter, doesn't matter. Defendant walks free because we have the presumption of innocence on the defense. And now we're asking about that, right? Now we're asking, since this flipped over and since the defense is now acting as the prosecutors, right? They're going after Fani. Fani's team, I predict, they're going to come out and say they haven't met their burden, and the burden should probably be a lot higher than preponderance of the evidence. So the defense came out and they said, Your Honor, you don't need evidence beyond a reasonable doubt. Like Fani Willis is not on trial here. We don't have to convict her of perjury. We don't have to convict Nathan Wade of anything. All we have to do is show that they met the standard, not beyond a reasonable doubt, which is what the co-defendants in this case would have to be met with. And beyond a reasonable doubt, it's like 80%, right? You hear this in the movies all the time. If it's like 80% or more that a person is guilty or committed the conduct, they'll say they're guilty of the crime. But preponderance of the evidence is much, much lower. It's like 51%. So if it's more likely than not that Fani and Wade did all the things that they just alleged, then the idea is they should be disqualified, right? Because it's a preponderance of the evidence standard. And the defense is saying, we've met our burden, okay? We've already put up enough evidence to meet that 51% threshold, and therefore, it's a done deal. And I thought it was very good, right? The judge was poking holes in a lot of this, but the last attorney just came out and plugged them all up. And they did that largely, right? They came back out and they said, oh, you asked for a limiting principle. How about this? You asked for this. How about that? Is that Fani? Did Fani just enter the courtroom? I think Fani's in the building, my friends. I think Fani just walked in here. Oh my gosh. Is she going to do some closing arguments? Oh, okay. So Fani is now in the room. We're going to do a quick refreshment break, my friends, and we're going to be back here in 1 minute. And I think it's going to be Fani time. So I'll see you here in 1 minute. See ya.
Very nice.
All right, my friends. I think we've got Fani in the building. She looks like she's seated there in red. Oh, you know what they did? They put a person in between Fani and Willis. You see that? Fani's like, I really want to sit next to you.
Or no.
But it'd be better looking if they put the white guy in between Fani and Wade. See that? Fani's not sitting too close. She's like, why don't you sit there? I'll sit over here. Better look, you know. You don't want them sitting too close. They might start making out in the courtroom, you know, and then they'd be caught for perjury again, for lying again, that their relationship ended. Hey, keep your hands above the table, Fani. Keep your hands above the table. We can't see your hands, Nathan. You too. Keep your hands up there. All right, we should have the judge back any minute. And we're going to hear arguments on this. Now, again, I think that they're going to go back to materiality. Judge is back. All right.
Just seated.
All right, please be seated. And here we go. We're going to hear from Adam. And Fani Willis is in the courtroom, my friends, if you haven't seen it. Fani Willis sitting right there, a nice distance between her and Nathan Wade, so no funny business accidentally happens there.
All right, we're back on the record.
What's up, Judge?
Stay ready.
Yes, Judge. I just am trying to get to where I can share my screen.
We need to add you as a host then. What's your profile name on the Zoom? Your screen name on the Zoom.
Adam Abbate.
All right, just making sure. Bear with us. Do you need it right away?
Does he have a PowerPoint?
No, I can start without.
All right, floor is yours.
He has a PowerPoint presentation.
Good afternoon, Your Honor. Start with some of the things that were addressed over the last hour and a half. First, beginning with something Mr. Merchant referenced as it related to the comments that the state made in regards to the good faith basis in which was submitted to the court, in which defense counsel claimed the evidence would show. And I would strongly bring to the court's attention that the claims that were made were material misrepresentations. And what I will say to the court,
oh my gosh,
and why I say that to the court is because the representations that were made by counsel was that Miss Daisha Young, Miss Sonia Allen, Mr. Dexter Bonds, Investigator Hill, Investigator Green, Investigator Ricks. All of these people would be called, and Mr. Bradley would be able to impeach their knowledge by saying that he specifically
Look at Ashley.
in his presence or to him said that Miss Willis and Mr. Wade were in a romantic relationship, and that Miss Willis and Mr. Wade were cohabitating, that they all, and I would submit to the court, we didn't
Ridiculous.
hear from any of those individuals.
She's not required
Mr.
to call
Bradley
them.
impeached no one. And I say no one because he did not impeach Mr. Wade. In order to properly impeach a witness, you have to confront the witness with the specific statements. Mr. Wade, and you can look back at the YouTube of the entire
We were here.
hearings of the last couple days, Mr. Wade wasn't once confronted with a statement that he claimed or said, or that is claimed that he said to Mr. Bradley.
Fanny moves one seat
The
over.
way you properly impeach somebody, you have to confront the witness. Here would be Mr. Wade. And once he makes a statement that you believe to be inconsistent, and you have a witness who can prove that inconsistency, that's when you call that witness. And when Mr. Wade
What is he
was on
talking
the
about?
stand, not once was he asked, did you tell Mr. Bradley this in a confidential conversation in your conference room that was not covered under attorney-client privilege? That was not asked.
They don't
The
have to
specifics
ask your
of that
questions,
conversation
Adam.
was not asked.
They don't have to call
So any
all the witnesses
testimony that
either,
Mr.
Adam.
Bradley testified to is impermissible. It is improper impeachment because they did not confront Mr. Wade with it. So that's
Okay, so
would
he's
begin with the comments that
grasping
Mr.
at
Merchant made
technicalities, right?
about me referencing his wife as lying. I never called Miss Merchant a liar. I never used those words. I don't know why she made the material misrepresentations.
wasn't.
It could be because Mr. Bradley lied to her. I don't know the reason. So, but I can submit to the court that those were material misrepresentations that were made to this court on the day a few Mondays ago.
Judge isn't going to buy
as
that.
everyone was arguing
No.
the motions to quash certain subpoenas.
Nice try.
I'd also bring to the court's attention that during that motion to quash subpoenas, certain subpoenas, Miss Yurdy's attorney appeared, Mr. Partridge, and he made very clear on that Zoom that Miss Yurdy had absolutely no knowledge of a romantic relationship and absolutely no knowledge of cohabitation.
But she did.
Those were the specific references that he made.
Okay.
So
He's trying
What
to
I
go
would-
backwards, right?
submit to the court is those are considered adoptive omissions that his client has made based on the statements he made because of the representations she made to him. So, and I know that sounds convoluted.
It
but
does.
what I would say to the
'Cause
court
it
is,
is.
Miss Yurdy told Mr. Partridge, because Mr. Partridge, that she had absolutely no information about a romantic relationship, and she had absolutely no information as in regards to.
So, but wait, are you making an argument I should make inferences based? Now, these would be attorney-client privileges or communications then. She's
Well-
communicating with Mr. Partridge about what her upcoming testimony is. That's why she's hired him. And you're telling me I should infer things based on her communications to him?
Absolutely, because they're not attorney-client communications anymore when he
This dude,
discloses them to the court and everybody else as they watch the Zoom and
He's
attend
trying to go
the hearing.
backwards.
The difference is there was no request to go in camera. There was no request to go or to have a private conversation with you as was done with Mr. Bradley. That would have been the proper procedure. So yes, I'm asking you to infer that 100%. I'm asking you to infer that her testimony was at best inconsistent. Because the testimony of Miss Yurdy, when she testified, was vague, very little description. When asked in a very leading manner, is it true or do you know that Miss Willis and Mr. Wade were in a relationship from 2019 into the time you were fired, or excuse me, you were forced to resign from the district attorney's office in March of 2022? She said yes. And then further, when pressed by Mr. Sadow, he talks about why she believed they were in a relationship. And what was interesting from Miss Yurdy's testimony, that they were pretty close friends up until she left the DA's office, that she
Right.
asserted to the court that on a yearly basis, Miss Willis said, I'm in a relationship with Mr. Wade in 2019. Oh, by the way, I want to tell you again in 2020, because we're in a new year, I'm still in a relationship with Mr. Wade. And again, in 2021, the assertion is Ms. Willis then went back to Ms. Yurdy and confirmed, hey, I just want to reconfirm me and Mr. Wade are still in a relationship.
I don't
It's
remember that
absurd.
testimony.
It's absolutely absurd. More importantly, when Mr. Sadow asked her about
She
why
observed
she believed
everything.
that they were in a romantic relationship based on her own
This
observation,
dude's grasping.
she said something. He actually asked her, did you see him kissing or hugging? She said yes, but there was no description or qualification about when it occurred, what she actually saw, excuse me, was it a kiss on the cheek, things of that nature.
She
So I would
said
ask
they were in a
you to,
relationship in 2019. She was very credible.
Frame her testimony from that standpoint when you're addressing her credibility.
That was
As
not
the court is going to do with each and every witness that you heard during the testimony of all the witnesses during the hearing.
Let's see if he talks about her getting
Let's
fired.
see if my screen will share.
Yeah, share your screen. Let's see what your little notes are. Pull your slides up. Come on. Oh, we got your slides. Nice PowerPoints. Great from this prosecutor. Oh, good. Nice PowerPoints. Typical prosecutor background too. Yeah, real fancy. Nice job. All right, so pull it all up. I'm a big fan of PowerPoint, by the way. I happen to love PowerPoint, but prosecutors are just dorks. All right, so pull it up. Let's see them. Hopefully they put it back on the screen. Can we see them? There we go. All right. Yeah, a lot of text. You know, they have to read it. Prosecutors are very good at reading things. So this is a whole new experience for him where he has to, be on the defense side. It actually takes some creativity and some work. You have to be able to think on your feet. Prosecutors are used to
now I
just
wanna
reading through the slides.
Talk a little bit about the standard and the burden here in
Paint
this
by number
instance
prosecutors.
as it relates to
That's all they can do.
defense counsel and the claims that they have made in the motion to disqualify. And as I was doing a whole lot of research, I came upon this law review article from Cornell scholarship reading or publication.
Do we need to be here for this?
And they made very clear that courts have been relatively reluctant to exercise their power to disqualify prosecutors for any reason.
A law review article.
And
Great. Is that a case?
That goes along with the standard what the state would submit to the court is that the defense has to show an actual conflict. And in this instance, they have to show the actual conflict would be that Miss Willis received a financial benefit or gain and did it based or got it based upon the outcome of the case. It doesn't make any sense. It makes absolutely no sense.
She's prosecuting a case.
During the 3 days of the extensive testimony of all of the witnesses and the prolonged examinations of the witnesses by multiple defense counsel, they still got nowhere. We're in the same position we were in on Monday.
No, we're not.
The same assertions that were made on Monday have no answers today as we before your honor.
We have 6 of them. That last
They were
attorney
not
just
able
articulated
to
them.
provide any evidence as to, or to the contrary of Miss Willis and Miss Wade's assertions of when they began.
You literally just talked about Robin
that
Yurdy.
contradicts that the relationship did not begin later than or around March of 2022, Your Honor.
Dude, you just mentioned
I
Robin.
further
like
submit to the
5
court
minutes
because
ago.
of this failure that their assertion or their request that one, the indictment be dismissed. There's absolutely no evidence that the defendants in this case, their due process rights have been harmed in absolutely any way. There was zero evidence. Not a single shred of evidence was produced through any of the exhibits or the witness testimony showing how their constitutional rights, their due process rights were at all affected
They've been
by
charged
the
with crimes.
relationship that began in March of 2022
They've been
with
charged with
Ms.
crimes and
Willis
arrested.
and Mr. Wade.
How's that?
And because of that, the motion to disqualify should be denied. And Ms. Willis, as the district attorney of Fulton County, and Mr. Wade, as the special prosecutor assigned to this case, should be allowed to remain on this case and continue to prosecute the case to the end, Your Honor, until the trial is set by the court and is to begin. Now, the issues, obviously, you've heard a lot from defense counsel as to
He tried to talk
what
about
the
materiality,
issues
right?
are for you to,
It's pretty rough here.
I guess,
It's pretty rough.
determine. And here would be the state's contention is that you must find that there's an actual conflict if you
We have
were
6 of them,
or
yes.
are to come to the conclusion that you should disqualify Ms. Willis and the district attorney's office. And looking at and
Go talk to Fani, see what she has to
What,
say.
I think you're talking about, is this Ventura?
it's McGlynn v. State, McGlynn v. State, 342 Georgia
Okay, high
Appeal,
standard of proof. They want it
170.
closer to be beyond a
2017
reasonable
case.
doubt,
In
right?
that case, is it talks about the standard of proof that the defense, or the burden that the defense must show and go to show an actual conflict, is they say it's a high standard of proof, which is definitely not a preponderance of the evidence,
they
which
want
is
it
a much
higher.
lower burden
I think they meet
for
beyond a
any
reasonable
party who's
doubt.
trying
I
to
have no
meet
doubt.
that standard of preponderance. But it's very clear that what the standard is that is a high standard of proof for both when determining whether there's an actual conflict
I think
and when there's
that's been
forensic
met.
misconduct that is found, Your Honor.
Great.
And I want to go through some of the cases that defense counsel has
Skipping a lot of slides there,
referenced
Adam.
as they argued here today and in their filings. And bright line standard, or the standard and the grounds for which disqualification is appropriate for Your Honor to be determining in all of the cases as it relates to disqualifying the elected district attorney, is you either find there's a conflict of interest,
Got that?
or that there's been some sort of forensic misconduct.
Got that too.
Those
Thanks.
are, I guess, the 2 areas that, Your Honor, that is in your purview when you are looking to resolve an issue regarding disqualification. Now, in a recent case, Lee v. State, which is 224 Georgia, and I'm sorry, Lexus 31. It's a February of 2024 case here out of our appellate courts. And in that case, Justice Pinson wrote that a trial court did not abuse its discretion by failing to disqualify an assistant district attorney absent an actual conflict of interest. And that is the case that was ruled on by the Georgia Court of Appeals about a month ago.
That's
Your
great.
Honor.
We have an actual conflict of interest. We have 6
Now,
of them.
the cases in which defense counsel have relied on in their briefs and here today, I would submit to the court, the sites are misleading.
Wow.
Many of them are
That's a very good
inapplicable,
slide. Very
and
good
some of
slide.
them
Wow.
actually support the state's position.
Glad he put it on
And
there.
what I would say to you is that the defendants, in many instances, combine language, the multiple cases.
This should be in the
and
notes section. So if you want to have better PowerPoints,
kind of
talk about that.
What I would say is
Don't put it
misstates
on
the
the
law
slide.
as it relates to
Bullet
what
points.
the law or what is required in order for an elected district attorney and their office to be disqualified. And what I would submit to the court
Let's
is
go back to that. Show me how.
Perfect. Let's go, Judge. Yeah.
show you
explain-
how.
So I think the first one they cited was Battle versus the state. Certainly a conflict of interest or the appearance of impropriety can be the grounds of disqualification.
Oh, his PowerPoint slides are going to get messed up now. He got asked a question. Prosecutors aren't used to this. Go ahead.
And there are a number of these cases that
They're-
seem to exclusively rely on the appearance of impropriety.
Right. Well, what
So
I-
they acknowledge that there's some ambiguity here, that sometimes Whitworth gets cited to Ventura, and we've got this quote that comes up where it's just they only cite to an actual conflict
Uh-oh.
that must be involved. But they acknowledge the ambiguity. You're saying there's no ambiguity whatsoever.
I am saying that, and why I am saying that, why I would submit that to the court, is in all of those cases, they do reference the appearance of an impropriety, but they reference that because there's an actual conflict in each one of those cases.
So your position would be, your review of the case law, there's never been an appellate opinion that relied only on an appearance of impropriety.
As it relates to a prosecutor or district attorney, yes, that is what I'm saying. What I would say is in those cases, they do reference the fact that there is an appearance of impropriety, but they reference that fact because when you have an actual conflict, there's always an appearance of impropriety. And those are what those cases stand for. And though I guess that is the main example of what I reference as they kind of combine the language from separate and different cases and tell you that the standard is an appearance of impropriety. And I would submit to the court that is not the standard.
That's not what they're doing at all. They're showing the
In
cases.
my first reading, like Your Honor, I did notice that the cases each reference the appearance of impropriety, but also that that appearance arose from the fact that the court found an actual conflict in each one of those cases. So I won't belabor the point in going through all of the cases that the defense had cited, but what I would submit to the court and reading those cases is that I found that they kind of fell into 5 categories, that some that didn't concern disqualification at all, some that determined or that were about.
We can read it.
I call it divided loyalty, which is a conflict that arises from representing becoming a prosecutor and then having represented the defendant prior to becoming a prosecutor, and then whether there's an actual personal interest in the outcome. And then others talk about whether the defendant was denied a fundamentally fair trial at the conclusion and of the case after conviction.
And is this Calibri, the font? Is this Calibri?
And these are some of the
I think it is,
cases
isn't it?
that defense counsel had cited within
Very basic.
their brief that had
Very
absolutely no
basic to use the
application
default font
to
on your slides.
the issue that we're here before Your Honor today. The first, McIver v. State has nothing to do or has nothing related to the disqualification of anyone.
And I think some of these are just relating to kind of aspiring for broad language about standards to prosecutors. So point taken there. But if they're more, all right, keep going.
All right, whatever. Keep going. I don't care. Okay.
So as it relates to one of the cases that was referenced here earlier and is also in some of the briefing by defense counsel is the Regested v. State, which is 287 Georgia 542, and all of the cases that fall under this, what I would call category, is about a attorney who formerly prosecuted a defendant in, I guess, the same type of case or the same case or similar charges, and that would be why the courts the courts found that disqualification would be necessary because of the relationship that existed between the former client and the now person who's being prosecuted, Your Honor.
All right.
So the next series of slides just goes through what has been
Brutal.
addressed as it relates to the standard
Brutal.
that is required when dealing with the issue of disqualification. And the state would contend and submit to the court that the defense must show an actual conflict in order to have the district attorney disqualified. And that actual conflict has a form of showing that Ms. Willis, in this instance, received a financial benefit or gain in relation to the outcome of the case.
If they
like
dismiss
many of the
it,
cases
she can't
that
keep paying.
involve personal interest,
Wait.
Your Honor, it's all based on a contingency fee, where how much they're paid or a bonus,
All
for
right, so he's
example,
trying to distinguish some
is
other
dependent
cases.
upon the outcome of the case. That's how one is to show that there's a personal interest in the case. We have none of that here. And I would submit to the court, we have absolutely no evidence that Ms. Willis received any financial gain or benefit. The testimony was that Ms. Willis paid all of the money back in cash as related to the trips.
She's
and
not
if didn't
credible.
pay back in cash, it was.
All right, let me explore this one a little bit.
Mhm.
So in addition to, you're saying it's only an actual conflict, are you also saying that it's only if a financial interest is affecting the final result, the outcome? That's the only one we should be worried about?
Not the initiations or the
Is it that the
continuation?
prosecution as a whole is what we should be looking at in terms of a stake? So what I'm thinking of, I'm just going to try and come up with some hypos here. What if ADAs are given a bonus for every motion to suppress they win, $1,000 per Fourth Amendment claim they win?
Yeah, what about
Well, now
that?
they've got officers is lying not to tell you about it because they want to win that motion to suppress. But maybe that doesn't affect the outcome because you can win a motion to suppress or lose it, and that doesn't decide whether it's going to be a guilty or not guilty verdict.
Great
But
question,
doesn't that
Judge.
affect the prosecution of the case, if not the outcome?
Yes, I would definitely agree that that would be an instance where disqualification would, I guess, be necessary and appropriate because
Well-
it's a situation that involves a contingency fee. And I would submit to the court that it actually does end up affecting.
It could, based on how important the motion to suppress is, right?
Right.
But if it's some immaterial,
An
I don't
indictment,
know.
like they
But
did with
I guess-
Nathan.
So you're saying it's maybe not so much just the whether it's a guilty or not guilty dismissal, no pros at the end of the day.
His arguments.
It is
falling
actually the
apart.
conduct of the prosecution that should be
Yes.
looked at throughout the course of the
Oh,
prosecution.
sorry, Adam.
Correct, as it relates to how it affects the prosecution, which I would submit to
Yes!
the court ultimately is going to affect the end outcome of the case. If you have a contingency fee based on winning or how, if you win a motion to suppress
You just
and
agree with the defense.
if you win, you get, a bonus, as Your Honor referenced. I think that is ultimately going to affect the end outcome of the case.
So is
because,
an indictment.
As Your Honor just said, this is where an
Hello?
officer's lying, or that where there isn't a good faith to go forward with that motion, the prosecutor would go for it with regardless.
Yes.
Because
An
of the
indictment
contingency
came-
fee, which not only affects the prosecution at that point of the proceedings, but ultimately is going to affect the entire case. Because if
Yeah.
they were to win a motion to suppress, or I guess the motion would be denied and the evidence wasn't suppressed, knowing that they didn't have a good faith basis to go forward affects the ultimate outcome of the case.
So does an indictment.
So I
doesn't
think
it?
it's twofold, as Your Honor has referenced. I think it's at that part of the procedure of the proceedings would definitely qualify for a reason necessary to disqualify a prosecuting agency. But ultimately, that action during the procedure will lead to the ultimate outcome of the case.
Yeah, so will an
being
indictment.
hinging upon a contingency fee.
Thanks for agreeing with the
like
defense.
the ones
Well done.
in the cases referenced by counsel and the state that are on the screen.
I think the judge just
And,
trapped him right there.
So getting into the language again, what you just had up there with greater amusements
Mhm.
and amusement sales. Greater amusements is one of those. You refer to the appearance of conflict as dicta. Why do you think that's dicta? I think the quote from that one is, it guarantees at least the appearance of a conflict of interest. Why is that dicta? It seems very central to the holding of the
Judge
case.
did his homework.
Because I don't disagree with Your Honor, but in that case, an actual conflict was found and the appearance.
They didn't find that.
I would disagree with Your Honor. I would,
Bummer,
my
man.
reading of the case is that an
Read it
actual
again.
conflict was found, but because of that actual conflict, an appearance of impropriety was seen.
This guy drew the
And
short
that's-
straw, man.
That's the reference.
out of Fulton County.
Or why the state referenced that case in relation to the argument that an actual conflict is required.
Judge is like, I read a different case than you. Yeah. Strange. Okay.
And the series of cases.
Oh man,
Young,
this is rough.
that was referenced by defense counsel as well as Nichols v. State.
He's just
are
slow
both
rolling the
instances
next
where
slides.
there's a personal interest in the case due to the situation and where at one point they were opposing parties. And of course, there's a personal interest or stake as it relates to prosecuting an opposing party in a civil claim,
Look at all
which
this
are what
text
both
on
of
this
those
slide.
cases reference, which shows that there's an actual conflict of interest that relates to the personal gain of the specific prosecuting agency.
And what do you make of Nichols' reference to, it's an older case. Sometimes the language can be what we're not accustomed to seeing, but there's, they refer to the metaphor of Caesar's wife. And generally when there is a ethical standard, that's something that goes beyond just an actual conflict, right? Isn't the beyond reproach getting more into appearance world?
Judge knows the cases, man. The Georgia cases. Good.
Is it getting beyond?
No, isn't getting into the appearance aspect of things when we're talking about Caesar's wife.
But I think it goes beyond that based on the language of the holding in that case, where it literally says that the individual had a personal interest in obtaining a fee by forcing a settlement in the civil case and using the criminal case as leverage. So that's not an appearance of impropriety. That is an actual conflict of interest, in which arises because of the individual's personal stake in the end outcome of the case. Your Honor. So that's how I would differentiate, I guess, the representations of defense counsel as it relates to the standard or the burden that must be shown, and why the state would submit to the court, and the most recent ruling out of the Georgia appellate courts that an actual conflict is required to be shown. So I'm going to skip through these series of slides.
Yeah, because you don't know the cases. The judge knows them better than
All
you.
about Whitworth.
Yeah. Yeah, good call. Fast forward.
So I go back to what we referenced earlier, and what's been referenced by all parties, that the grounds in which
You already had
the
this
district
slide.
attorney can be disqualified is
We already
where
saw it.
a conflict of interest is found, and where there's forensic misconduct that is found. Those are the two grounds that are to be, I guess, are within the purview of the court as it relates to the issues here. And again, I go back to the most recent case that was Justice Pinson wrote about.
He just copied and
and that
pasted
it-
his slides from the front of the
There
presentation
must
to the
be,
back of the
by
presentation.
failing to disqualify the assistant district attorney, absent an actual conflict of interest.
Is he
I think
almost
the
done?
language there is very clear, and I think it's very controlling. And I think it's purposeful, I would submit to the court, because an actual conflict of interest is what is required in order for a district attorney to be disqualified, because the cases make very clear, and through the precedent relating to this issue, that a disqualification of a district attorney is the last, for lack of better words, ditch effort that should, as it relates to the
Can we
court
1.5x
ensuring
this speed
certain
here?
conflicts that may arise. I think the case law is very
You
clear
already said
that
this.
every effort is supposed to be made instead of, or I guess in lieu of, disqualifying the district attorney unless an actual conflict of interest is what's found, Your Honor. And it can't be cured.
Or did we already watch this one too, this slide? Yes, we did. That was Williams versus State. I think he's going through
So
the cases
what I would
again.
reference to the court, as was brought up earlier in Lyons v. State, 271, Georgia, 639, a 1999 case where it talks about a theoretical or speculative conflict
All right.
will not impugn a conviction, meaning that speculation, conjecture, things of that nature, assumptions are not enough for anything to arise to an actual conflict. And what I would submit to the court as well, that goes to the fact that what it has to be shown is an actual conflict. If it's speculation,
Is there any qualifier there, though, that's in a post-conviction context?
So-
We're talking about, competent evidence, obviously in a pretrial phase here. I've wondered how much import to give that sentence when we're in a pretrial realm. That's assessing whether to overturn a conviction, and usually that's kind of an entirely different standard where we assess as a
After the
totality.
case
Was there
is
a fair
closed,
trial?
yeah.
Is there harmless error? I know there's no harmless error when it comes to disqualifications, but
Yeah.
just a thought.
Seems like
If
you're
you had any
misleading.
reactions.
You're
well, I
misleading,
think
Adam.
what Your Honor just said is pretty on point in the sense that if it's found that I guess the trial court either applied the wrong standard or should have disqualified the district attorney, it leads to an automatic reversal, like you said, and it goes back to the trial court. And I think that is very enlightening in the sense that that's only done if an actual conflict is shown. And the fact that it can't just be theoretical, speculative, or assumptions that would lead to the appearance of impropriety, of the
Fanny's coming
appearance of a
up.
conflict that
Fanny
would lead
handed him a
to,
note.
um,
Better read that.
I mean, I
That's
guess
big
I'm
Fanny.
that.
I'm borrowing kind of from, as we've been doing the other pretrial
got a
motions,
Fanny
special
note.
demurrers seem to get different treatment pretrial and post-trial. Post-trial, they get more of a pass unless you can show some issues. And I'm wondering if that same applies here with disqualification.
well, and I would,
But I don't have the answer to that.
well, what I would also say, and I don't remember the exact line, but I know there in Judge McBurney's order, he does address some of the concerns that as it relates to the standard as it is applied post-conviction versus pretrial during pretrial issues. And what I would say to the court is that
So you're citing that in support? Because I didn't think the state was all that pleased with with the, the analysis he
Wild.
applied,
What I'm citing.
legal analysis, that is.
Well, I'm citing to what you specifically referenced as to the standard that is to be applied pre-trial and post-trial, whether it makes a difference. And what I would say to the court is the answer is no, as it relates to the speculative nature of the allegations or the claims made by defense counsel as it relates to whether a conflict actually exists, Your Honor. And what I can't do at the moment is point exactly to the page. At the end of the state's argument, I can give you the page number as it relates to Judge McBurney's order.
I think I know what you're talking, the footnote where he references the appearance standard.
Judge
All right,
Judge
I'm looking
has
at
it,
it.
man. He's done his homework on this.
Further, in Lamb 267, Georgia 41, on page 42, it's a 1996 case where the court says, nevertheless, the conflict must be palpable and have a substantial basis in fact. A theoretical or speculative conflict will not impugn a conviction which is supported by competent evidence. Now, I understand as it relates to the post-conviction factor or the status of the case being in post-conviction based on Your Honor's earlier inquiry, but I would submit to the court that as it relates to the issue of disqualification, that the standard is the same, whether it's post-conviction or pretrial. In Bloomfield v. Bornstein, which is 247 Georgia 406, it's a 1981 case. In that case, it says the appellees have not shown us a case where a per se rule was applied to disqualify an attorney on the basis of an appearance of impropriety alone. The Georgia cases cited by the appellee do not stand for the proposition that a trial judge is authorized in Georgia to disqualify an attorney solely on the basis of an appearance of propriety, which further goes to the state's submission to the court that the standard is that an actual conflict must be shown, and that conflict that arises shows that there's a personal stake of the district attorney as it relates to their personal financial gain that's being alleged. So in the case that's been referenced, all parties here today, Whitworth v. State 275 Georgia,
More slides.
Appeal 790 to 2005 case. In that case, it says Whitworth's complaints are largely based on speculation and conjecture.
He's pounding the
Applying
law.
any evidence standard to the record, it is
Doesn't have
clear that
really
the
good
trial
law,
court did not abuse
but
its
his facts
discretion
are
in denying
terrible.
Whitworth's motion to
So he's pounding the
disqualify
law, pounding the
Morgan
law,
based
pounding the
upon
law.
his
Doesn't have
personal
any
interests.
facts. We'll see if
in
he
his
gets to some
conviction.
facts, if he applies any facts. to
Aren't we
the law.
past the speculation and conjecture aspect of this, though? I mean, the original and the core of the
Yeah.
financial allegation was that there is a relationship and that money has changed hands. There's maybe still an open question of where the ledger stands, but I think it was conceded that that balance could run in one way or in the district attorney's favor. Is that contested?
Yes. What's not contested is that a relationship did develop between.
And that purchases were made back and forth. That's the state's position.
That it's the state's position, but they were made back and forth. The purchases were made back and forth,
Even
either
Stevens.
to equal the money that was spent by one party or the other. And if that wasn't done, cash was exchanged in order to equal the cost paid by either one of the parties.
Even
Right.
Stevens.
But that's a facted issue, whether it was, split even or whether it goes a little bit one way or another, or whether it's all the way $10,000 one way or another. That's a fact and issue as a result of the hearing, but it's no longer just the theory that money changed hand is no longer speculation or conjecture.
Well, I agree that money actually changed hands is not speculation and conjecture, but whether that money that changed hands had any financial benefit or gain to the district attorney, that is all speculation and conjecture. I would submit to the court. Absolutely all speculation and conjecture to harass and honestly embarrass the district attorney based on some of the questions that were asked that had absolutely nothing to do with the proceedings that we were here. For example, the lien on her alleged house, that was highly irrelevant, had nothing to do with the proceedings and the exchange of money between the district attorney and Mr. Wade. The point of that line of questioning was to, again, embarrass and harass the district attorney in a way that was very public, and in a way that was to impugn her character as it relates to that line of questioning in front of the court, in front of anyone watching the proceedings as it unfolded.
Yeah, I don't think the
And the
judge is
language
buying this
in
at all.
Whitworth, I would again submit to the court, requires that an actual conflict must be shown, which is why the reference to speculation and conjecture is a reference, because speculation and conjecture leads to or equals an appearance of impropriety, not necessarily an actual conflict, which I submit to the court is what is required based on the case law.
So hopefully we get to some actual like facts of this case. He's just telling us about the case law, but we want to see what some of the weakness is in the actual evidence that was here, right? Pound the law if you have
So
it,
in
pound the
State
facts
v.
if you have
Sutherland,
it, or
which is
pound the table
190
if you
Georgia
don't.
Appeals 606.
He's just
It's a
all law.
1989 case, and it says, while the prosecuting officers should see that no unfair advantage is taken of the accused, yet he is not a judicial officer. Those who are required to exercise judicial functions in the case are the judge and the jury. The public prosecutor is necessarily a partisan in the case. If we were compelled to proceed with the same circumspection as the judge and jury, there would be an end to the conviction of criminals, which goes to the premise that the appearance of impropriety is to apply to judges, not prosecutors. Because if that standard was to be applied in the manner in which the Sutherland case is referencing, then there would never be a criminal prosecution.
We're talking
because
about an
It's
affair.
always going to appear bias as it relates to getting justice for the victims or righting the wrong as it relates to the crimes
So
in
you're
which
holding
the
prosecutors to
defendant
too
is,
high of a standard here. Fanny's
been
you know,
indicted or accused of.
if she has to be above board, then she'll have some bias and she can't charge anybody. Come on. This is not what, this is so far astray, I think, from the actual facts of this case that it's just, it doesn't even apply. Fast forward
So
through that one.
I want to
Here we go.
move into
Evidence.
I guess
Finally.
the evidence
Thanks.
that
Thanks
Your
for getting
Honor saw and heard
Oh,
during
gosh.
the last couple of days, 3 total days of testimony.
Look at number
As it
5.
relates to the witness. The
Look at
witnesses
number 5.
you heard from Ms. Yurdy, who the state would contend is a disgruntled former employee.
I think
You
Robin
heard
Yurdy
from
told
Terrence
the truth.
Bradley, also someone who is a disgruntled former partner. The text messages in the state's opinion show that he is vengeful. You heard from his own testimony here, sitting before the court, that all he did was speculate, and any information that he had and garnered
After
and
he
then
got that
passed on
gay
to
phone
Ms.
call.
Merchant was mere speculation. I believe he said that over and over again when asked if he had personal knowledge. My recollection is around 15 times he said he had absolutely no personal knowledge of a romantic relationship between the DA and Mr. Wade. You also heard from the special prosecutor, Mr. Wade, a former judge. You heard from the 80th governor of the state of Georgia,
Who provided
Roy
nothing.
Barnes.
Who provided
You heard
nothing.
from the first female elected district attorney of Fulton County.
She's black too,
And you
by
heard
the
from
way.
her father, who was a 40-plus year practicing
First black
attorney,
female. Why'd you leave
in
that out?
good standing when he left the practice of law. And what I would submit to the court is that Miss
Here's the Yurdy
Yurdy's
slide.
testimony was nothing more than inconsistent at best, based on what I referenced to the court earlier as it relates to the representations that were made by her counsel prior to.
Are those in evidence? Would his responses during a motion to quash, which weren't subject to cross-examination by defense attorneys, weren't even part of the evidentiary record of the hearing? Again, I'm just kind of puzzled by that. You didn't ask the question of Ms. Yurdy, what did you tell your attorney before coming here? And then we could have dealt with privilege issues and
Yeah.
whatever else.
Why are you trying to shove evidence in here, Adam?
I would agree with the court. It's not an evidence, but it was
So why are you talking about
a
it?
statement by an officer of this court to the court during a hearing related to her testimony and how we would proceed with her testimony in this hearing. But I would it's clear that what was
trying.
represented as to why she would not have, I guess, be an appropriate person to testify was that she had absolutely no knowledge of the romantic relationship. That was the basis of why her counsel was saying that she shouldn't have to testify. That
So
she
then,
shouldn't be
so then
compelled by
under
the
that
court.
theory, if accepted, where did the incentive arise between Monday and Thursday for her to completely change things around?
Where did the incentive
So
arise?
she was fighting so hard to avoid the, if we're going down that road you propose, she was fighting to have, not to come in here and testify at all. And then she comes in here and testifies. Why would she have testified the way she did if she didn't want to testify so strongly? If we're going down this road of trying to just gauge her
Good
interests
question.
and
That's not on
these
the
kind of
slide.
things, I don't know if
He's
I'm
like-
quite following that theory.
It's not on the
And I
slide.
can appreciate that, but I would say the reason she didn't want to testify, I would submit to the court, is because this is an incredibly public forum where she would have to testify against a former friend and a former boss.
Yeah.
And I
And
think
probably face a
the
lot of the same
change,
pressure that
I
Terrence
wouldn't
Bradley
qualify it
faces.
as an incentive. What I would qualify it is ultimately when she was forced to
Motive.
testify, right, a motive and a bias as to why she testified in the manner in which she did. When asked by Ms. Merchant as to the reasons for her leaving, she kind of danced around the issue. And then as Ms. Cross, whether she resigned or forced to leave, she was fired, she came out and said she was given the choice, you can either resign, but either way you're leaving. You're fired, or you can resign in a manner in which, she wouldn't be officially fired,
Because Fanny's
and
corrupt.
when she's trying to get future employment and things of that nature. So I would submit to the court that there's absolutely no incentive. An incentive is not why Ms. Yurdy's testimony changed, or the state would contend her testimony changed, but it was the reason she testified the way she did was because of her bias towards the DA, which gave her motive to what the state would contend is be less than honest before the court. And I would,
But if we're going to draw inferences based on her fighting the subpoena, why would she have fought it if she had such a bias and wanted to say these untruths?
because she didn't want to come on national television and have to be exposed to the things that,
You guys.
well,
Yeah, you guys calling
I don't know
witnesses,
anybody who
assaulters
wants
or
to testify before a court in a normal trial, a normal proceeding, but one of what I would qualify in this high profile of nature, where everybody would be able to watch and learn at what she has to say as it unfolds in the courtroom.
the
And
truth.
I'd further submit to the court, there is reference to she left the DA's office in the text message that were submitted in, I believe, what is it, Defense Exhibit 39, that it's because she released confidential information in the DA's office, from the DA's office, that led to her firing.
So
that she
that's
wasn't.
wild.
And I know I'm just because it's more conversational, which I appreciate. I know I might be getting you off script, so I don't want to
Oh, he's
use up
away
all
off
your time
script,
if you need
yeah.
to get through some other things.
Next, Terrence Bradley, and I believe the one thing that the state and defense counsel can agree on, that he was less than honest at times during the proceeding and during his testimony.
Everyone calls him a liar.
When Mr. Sadow, why he was fired, he basically chalked it up to a dispute between partners in a business. But when pressed by Ms. Cross, it was clear that that wasn't the reason. And what I would submit to the court, what has been referenced by defense counsel,
Terrence is getting destroyed,
as
man. Look at this. Look at this slide.
baffling as to
Less
why
text,
the state
better
would go
slide.
into such a topic area. The state, as all counsel has when appearing before the court, has a duty of candor. And when Miss Cross
Yeah.
knew she was going to have to cross Mr. Bradley, she knew he lied. And she had a duty of candor to the court.
She was still
in the
objecting to
state's
protect
opinion,
him.
to expose that.
Wild.
More importantly, it goes to his credibility and the statements that had been represented by defense counsel that he allegedly had made in the past. So it was important to bring that to the court's attention, because when a witness is testifying, the court is assessing their credibility and determined to whether to believe the veracity of the statements made by the witness or not. So that is.
This guy was trying to
that is
sanction
the
Ashley
most important
Merchant,
factor,
okay?
When
They were
determining
objecting to
whether somebody
protect
is
Terrence Bradley.
telling the truth
Talk
or-
about
or
duty of
lie.
candor.
Furthermore, he
They were protecting
reluctantly,
him on the stand the whole
when
time.
pressed, finally admitted that he paid off the assault victim. You know, eventually it started with an escrow account and led to he did pay off
Yeah, and
the
you and
the
Anna
victim
were
in that
jumping up.
case.
Objection, 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 right
He
before
testified
that.
over a span of 3 days, and like I referenced to the court, he must have said 15 times that he had no personal firsthand knowledge
Right, and that
as
was
it
not
relates
credible.
to the relationship
Everyone knows that
between
was a
Ms.
lie.
Willis and Mr. Wade. More importantly,
It's funny he will
when
reference that.
pressed by counsel,
You just said he was not
he
credible.
could not
You
pinpoint
just said he was a liar.
a time in which he knew that the relationship occurred.
And then you reference
There were
his
many
statements as being
instances in which he
credible.
described that very well could have fallen within
Good job.
the time frame that
Good
was
job.
testified and by both Ms. Willis and Mr. Wade as it relates to the relationship beginning or transitioning into dating in March of 2022 and into the end of the relationship in August or the summer of 2023.
Great. So now,
And as I
now we should
referenced
believe him
to
on
the
that?
court, the statements that Mr. Bradley made, the state would contend are inadmissible hearsay as it relates to the statements that he was pressed and asked about what Mr. Wade told him, because Mr. Wade was never confronted with those statements.
So-
And in order for impeachment to be proper, he must be confronted with the specific statements
They want all the
that are alleged to have
attorney-client
been made
privilege
in
stuff
order to
also
impeach
thrown
him.
out on hearsay. He just
Again,
skipped over that.
Mr. Bradley had every motive to lie. I believe the text messages are kind
Thriving
of
law
clear,
practice.
are very clear as it relates to his disdain towards Mr. Wade, which due to the fact that, you know, he was expelled or exiled from a thriving law practice. And it was clear that the practice and Mr. Wade sided with the alleged sexual assault victim, which is clear he assaulted her due to the fact that he paid her off. And as I referenced earlier, you know, Ms. Merchant represented to the court that Mr. Bradley had personal firsthand knowledge, basically of it all, of everything, and that he would be able to basically be an impeaching machine. I think Your Honor referenced him as the star witness when you were addressing the claims that were made by Ms. Cross in relation
That
to
was in his text,
Ms.
Adam.
Merchant's representations to the court.
Before you
And,
guys flipped
what
him.
I would submit to the court is that all Mr. Bradley's representations as it relates to whether or when the relationship between Ms. Willis and Mr. Wade began,
Did he really
and,
put the words lies, lies, lies? on
whether
his
they
slides?
cohabitated, because that was a promise that was also made, that he would be able to impeach the investigators as it relates to cohabitation, was mere
Didn't call them.
speculation, gossip.
Didn't call them.
Um,
They don't have to call all
and
your
This
witnesses.
is, Your
The
Honor,
question I got, and we can
Yeah.
correct this while we're all here together, is that Mr. Bradley directly overheard a statement from each of these individuals that they could be impeached with. Ms. Merchant, is that accurate?
Directly overheard, which ones are we talking about specifically?
Well, essentially, that kind of seemed to be all of them. You had said Allen, Bond, Young, and then the investigators, Hill, Green, and Ricks, could all be directly impeached by statements overheard by Mr. Bradley.
Yes.
If she would have called them.
in reference to your question, the unequivocal answer was yes. And when Your Honor is looking through the text messages, I would submit to the court that the text messages don't even say or indicate what was represented to the court in relation to the good faith basis for this motion to disqualify as it relates to the testimony of and the ability to impeach witnesses through Mr. Bradley.
She didn't call them. They got what they
What's
needed from
been
Nathan
referenced,
Wade.
by all counsel is Mr. Bradley's assertion of absolutely as it relates to whether the relationship existed prior to Mr. Wade's hiring.
He didn't
And
play that
the
video
question
clip
in
on that
itself,
last slide.
involve speculation because it asks, do you think it started before she hired him? And he says, absolutely. He doesn't say he knows. He doesn't provide any context as to how he knows. And in these text messages and through his testimony with the court, the source of his information
That was on January
was
5th
unclear.
this year.
What I would say to the court. As to a lot of things, other than the
Well, 'cause he
one
was lying,
conversation
yeah.
that allegedly occurred between Mr. Wade and Mr. Bradley. And I would submit to the court that that conversation never occurred. That would be the state's contention. And how do we know that? We know that because that conversation was not confronted, or Mr. Wade was not confronted with that conversation. And that is evidence circumstantially, and I'd even say direct, as to that conversation not existing. Because based on the representation made by defense counsel, it would be clear that that would be a conversation that would have been relayed to, because it wasn't privileged, as Your Honor found, that would have been relayed to Ms. Merchant. And if that conversation happened, you better believe that would have been a conversation that defense counsel would have confronted Mr. Wade with and against. And the reason they didn't do that was because it didn't exist. You heard from Mr. John C. Floyd III, the
Fanny's
district attorney's
daddy.
father. As Your Honor heard, he was a well-respected member of the legal community for over 40 years. But the importance of his testimony was to provide the court with corroboration as it relates to
He was totally not credible
the
because
years
he
leading up
listened to
to
Fani
the
Willis's
relationship
testimony.
that
He even admitted that.
transitioned
Well, I listened on
into
talk
dating
radio.
between the district attorney and
So
Mr.
he
Wade.
came in and
What he
just
testified
supported
to is that he
Fani
moved
completely.
into her South Fulton home in 2019. The evidence of his moving into that home at that time was his Georgia driver's license, official government document. He further testified that not only did that just Miss Willis and himself live at the South Fulton home, but that he often would see on numerous occasions the significant other of Miss Willis that was not Mr. Wade. He referenced that that person had a nickname of Deuce, and
DJ
that
Deuce
he kept a
in the
lot of his
house.
belongings in the garage of Miss Willis. He specifically said he kept a lot of his disc jockey.
That's why they
equipment,
needed
as
the
he-
condo,
as
so they had a little
is how
bang
he
house,
referred to
right?
it,
Because Daddy didn't want
when
Nathan
before the
Wade
court.
indicting his
He
daughter.
made very
the
clear
bedroom.
that he had never seen Mr. Wade at the South that is owned by Ms. Willis. He made clear that he
Totally
lived
uncredible.
in that
Guy,
home with
watch the
Ms.
slot,
Willis
watch the
and
whole
Ms. Willis
presentation.
alone,
Next
other
slide.
than her two daughters who would occasionally visit that home until after February of 2021. But what precipitated the soon move of Ms. Willis to what I would reference as safe houses for her protection was a protest that occurred before her home in February of 2021. He then expressed to the court that Ms. Willis moved in the spring of 2021, and that due to these threats that were taken
What does
very
this have to
seriously,
do with
he had only
anything?
seen his child 13 times. He
'cause she
said,
was indicting Nathan.
in reference to the questions by defense counsel that were in a,
This is where we learned about cash. Remember Fanny's daddy said, hey,
and
you know,
I'm just going to
we
be
keep cash.
straight up with the court. They were trying to make Ms. Willis a liar.
She is a
How
liar.
I would submit to the court, in the sense that she testified that she was concerned for her safety and her family's safety, which included her father and her daughters, and that Mr. Floyd remaining in that home kind of rebutted all of that, made it so it wasn't true. But he testified that he stayed in the home because it was the home that she had put her blood, sweat, and tears in and was able to buy, and that he stayed in the home because there was constant officer presence. He told the court that he bought extra security equipment. He even went as far to tell the court that he slept in different rooms on different nights because he felt his safety was in such a concern. So I would submit to the court that line of questioning was done in an attempt to discredit Ms. Willis, but failed. would be this, what the state, how the state would characterize
It's
it.
mostly irrelevant, you know.
Then
it's-
he
it's-
testified about
She's a liar
the first
about
time
that
he did
too.
meet Mr. Wade, which is in 2023 here at the district attorney's office.
Where they were
And,
sleeping with each
he
other
talked
is kind
about,
of irrelevant. They made it a little bit more
how he
secretive
kept
by
cash
having
in
this
his
separate
home
bang session
and
house
why
down
Miss
in
Willis
South Fulton.
kept cash in his home. And what I would, what the court should take
And he's the
note
cash
of is
guy, right?
the state didn't ask Mr. Floyd about the cash in his home. That came out through the cross-examination of defense counsel. There was I guess, an implication that Mr. Floyd only did so due through his preparation with the state and his hearing and seeing news articles and clips related to the testimony that had occurred prior to him. But I would submit to the court that it's telling that that information came out through questions that were asked by defense counsel, which gives credibility to the statements that were made. And he further explained as to why he taught his daughter to keep cash
Yeah, black people
in the
keep
home
cash. White
as it
people
relates to
don't
financial
understand.
independence and
Remember.
having a safety net. It was further testified that
Yeah.
he had multiple safes and that he gave Miss Willis his first lockbox or her first
Wow,
lockbox.
what a beautiful moment
for
between a father and a daughter.
situations as she described when she was testifying. And what I want to make clear is during Ms. Willis's testimony, it was pressed about the cash and where she kept it and did it follow her?
'Cause it was
where
ridiculous,
She laid
yeah.
her head and things of that nature, trying to further discredit the practice that she had as it relates to keeping cash in her home and why she had the ability to pay cash to Mr. Wade and other people and for other situations. And what the court should take note of is that there was no evidence that controverted that at all. Where was the evidence that controverted Miss Willis's claim and practice of keeping cash in her home?
You
There was
can't
none.
disprove that. That's what's
In
so
fact,
ridiculous about
The
it.
only evidence
It's
was
cash.
it was substantiated through the testimony of her father, Mr. Floyd.
He wasn't present to those transactions. He just says, I taught my daughter to keep cash. He didn't know anything
Furthermore,
about the actual
you heard
transactions.
from former Governor Roy
Again,
Barnes.
Roy Barnes is
and,
not
His
relevant.
testimony was significant and important.
No, it
because
wasn't. It
what I
absolutely
would-
was not.
how I would phrase it.
He was
Your
on
Honor,
there
is
for
that
like
the
5
bump-
minutes.
Let me, on this point,
Mhm.
and I think you might have had a more recent opportunity to review his testimony than I have.
Mhm.
You say on the slide that she was the first choice to lead the prosecution. Was that actually his testimony, or was his testimony that he was asked to come aboard? Did he use the words that he was asked to lead?
Yes, it would be, that's my recollection, that he was asked to lead the prosecution. He was asked to he was asked to fill the position that Mr. Wade is currently in, which is the lead prosecutor. It was said in that way as well as it relates to the testimony of Mr. Barnes. So I think it would be very clear. My recollection is that he said lead, but what I can submit to the court that I know he also said that he was asked to fill the Wade is currently filling for the state of Georgia.
So
which
because
is the
At
lead
he
that
went to
prosecutor.
time,
this guy
as
first.
special grand jury prosecutor, right?
Yeah, the special, I guess, yeah, as the special prosecutor lead the investigation, which led to the ultimate prosecution that we're here before Your Honor.
So because she checked
today.
with the governor.
He also indicated that the reason he turned that job down was because it didn't pay enough.
She could
He said
then
he had
hire her
mouths to
boyfriend
feed,
afterwards.
at his law firm, and that he also didn't want to live the rest of his life with bodyguards because he had lived that for the years in which he was the governor of Georgia. Furthermore, he confirmed the qualifications of Mr. Wade, which I still find it quite interesting and confusing as to attacking Mr. Wade's qualifications, in that it's almost as if Mr. Roman's counsel is asking that the state put a prosecutor on the case that she sees to be more qualified to attempt to convict her client.
That's not the argument.
It's an interesting.
It shows there's a conflict. She hired her
argument, and it's one
boyfriend who's
that
not qualified.
makes
Why?
no sense.
Because she's her boyfriend.
Furthermore, if you were to believe the claims and allegations as it relates to Ms. Willis' personal stake in the prosecution, the receiving of financial benefits and gains, then you'd have to believe that she was also dating Roy Barnes, the former governor, and Gabe Banks,
Was
in
she?
addition to Mr. Wade. if she has this grand plan scheme in order to profit off of the prosecution of this case.
What a
Because that's
dumb
what they're
argument.
saying.
Oh my
Or they're
gosh.
saying that she
doesn't have to sleep with all of them.
Prophetically was able to know that Mr. Barnes and Mr. Banks would turn down so she could then hire Mr. Wade.
Or
It's
she wanted to
ridiculous.
look like
It's absurd.
she talked to
and
other people.
It's desperate. It's a desperate attempt to
Wow.
remove a prosecutor
Good reading.
from a case
Good reading there.
for
done.
absolutely no reason, Your Honor,
You see that? We
other
got
than harassment
We got capitalized again, but we didn't have bolded or underlined.
and embarrassment. This slide, and we've been through a lot of the testimony.
And I should be clear there, it was not introduced in evidence that Mr. Banks turned her down, right? That's not, is that part, how's that part of the record?
Well, I'd ask the court to take judicial notices, has been asked repeatedly.
Unless the district attorney had testified to that. I don't recall offhand.
I will be frank with the court. I don't recall if
Okay.
Ms. Willis testified to that exact fact, but I know that Mr. Banks represented that to the court during Monday's hearing as it relates to the allegations that were made. I understand Your Honor's position as it
Just
relates to
trying to make
that.
sure we know exactly what is in the evidence and is not, but
Well-
regardless, I think your point is made.
I think it's an evidence of the record as it relates to, I guess, the issues that led up to the actual hearing of this case. So I understand Your Honor's position, but it did come out during a proceeding that was prior to the actual hearing. This slide is just a
The
chart showing kind of the
consistencies.
testimony of both
Wade and
the
Willis are
district
both
attorney,
honest.
Ms. Willis and Mr. Wade,
Because their
as it relates to
testimonies
how
are
they
in
met,
sync.
how
Charts are
or
good
when,
tools for this.
Mr. Wade became the special prosecutor, when their relationship evolved into a romantic one, talking about the trips in which they took after their relationship evolved into one
Yeah,
that
they got their story
became
straight
romantic.
and they both lied
and,
together.
when
Great.
it ended.
Thanks for showing
And
us.
what, again, I would submit to the court is that those facts were consistent. And the only person who contradicted that when the relationship started was Ms. Yurdy. And what I would bring to the court's attention is that it was represented to the court that Ms. Yurdy was a witness other than Mr. Bradley who could bring to the forefront this issue of cohabitation. And when pressed and when asked about it, Ms. Yurdy had absolutely no information as it relates to this alleged cohabitation. It was false. She said she had no information. She was asked about trips. She said she had no information
Four
about the trips.
trips.
Yet,
Cruise 1, Aruba,
she's such a good
Cruise 2,
friend that
Belize,
Ms. Willis
Napa.
confirmed each year that Mr. Wade and her continue to be in a relationship in 2020, 2021, until their relationship ended due to her forced resignation and I guess splintering of their friendship, Your Honor. I guess several exhibits obviously were tendered in. Most of them were exhibits that came from the sealed divorce of
So you shouldn't be
Mr.
allowed to
Wade
look at those.
and Ms. Jocelyn Wade, contracts for legal services, trip itineraries, and the text messages. And I would specifically reference prior to today, the only text messages that were before Your Honor were Defense Exhibits 26 and 27, which it's the assertion of defense counsel that what those show is
There's
that
the
Mr.
wine
Bradley
guy, the affidavit
was
from the
in
wine guy at the
informa- or
bottom.
was had information as it relates to the relationship starting prior to March of 2022, and that's just false. Those text messages do not contain that. It does not pinpoint, just as Mr. Bradley couldn't, when the relationship actually started. And furthermore, you have the testimony and the evidence of the text messages that it was mere speculation.
Are we
If
only
you,
48
as Your
minutes
Honor
into this
reviews
thing?
the full chain of text messages, it is clearly Ms. Merchant and Mr. Bradley going through what I can describe as nothing else other than a mere fishing expedition
Oh,
between the
gosh.
two of them at first, because
That's
it's
prosecutors.
asked about
That's what they
certain
all
members
say.
of the DA's office who would have information as it relates, just specifically for one, Ms. Young. It is asked whether she would have information, and he had no idea. He said he assumed, he was speculating. And that is the same as each person that was subpoenaed
Because he
in
was not
reference
credible.
in the text messages all of that was speculation. And you know it was speculation because not a single one of them testified. That's telling. Because if it wasn't mere speculation, if it wasn't mere gossip, and if it wasn't mere conjecture, each one of those people who were subpoenaed would have been called to testify, like District Attorney Willis was.
They all locked
like
their stories
Mr.
up,
Wade was,
and we got what we needed
in
out
order
of
to be
Terrence
confronted.
and everyone else we had.
and then impeached by Mr. Bradley.
So you didn't call enough evidence. If you would have called more, then you
You've
could have
heard
proven your case.
obviously about the phone records, and I have a maybe because whether it comes into the purview of Your Honor as it relates to the determination Your Honor is to make as it relates to the disqualification of the district attorney. You also have the affidavit from the employee who worked at the winery who confirmed that Miss Willis did in fact
Wine
pay
guy.
In cash.
We have one
up
example
to,
of a
more than
$400 cash
$400.
payment from
And
some random dude.
I understand that this is part of the proffer of the state, but it's important because that is a witness who the state didn't go find. That is a witness who went to CNN in order to confirm what Miss Willis testified to, further giving her statements credibility and credence before the court. You heard about
Well, before we move on from that one, other than the foundational concerns, would you have a response to the proffer of the cell phone records?
I have, I'll get to that now. I was going to get to it later, but I have several foundational concerns as it relates to the cell phone records. I don't think I've ever, as Mr. Sadow's motion makes very clear, the state uses cell phone records routinely. And I would agree with that. We use them
All the time.
routinely, but we
Yeah.
use them with an expert and they're always challenged.
Right. So, like I said, in the interest of time, setting aside the foundational
Foundation.
concerns.
Oh, I thought you were asking about
No,
them.
no, no. The focusing on the substance of them, assuming that it would be admissible in the guise that he's proffered. What's maybe you have that further up, but what's the reaction to that?
So what I would say initially is that due to the fact that they were analyzed by someone who was a non-expert, the analyzation of those cell phone records were not properly peer reviewed. They were not, it's clear from the state review that
on,
the
dude.
normal
It's the same software you guys
practices
use
that are used
or
to
prosecutors
check,
use.
the use of which kind of data is being used. Reference to the two specific dates, I believe it's September 10th and 11th and November
didn't repeat
29th and
that.
30th. The affidavit that is used to say that Mr. Wade remains at Miss Willis's or in the area of
For the
Hateville.
Fani call, yeah.
Because again, during the hearing, the address for the Yurdy condo never came out. It was just that it was the Hateville condo.
Okay.
Actual phone number for Mr. Wade was never established. And the documents that
not a
were
criminal
provided
trial,
to the state
dude.
that were certified business records did not have a subscriber page. So we have no idea that the number belongs to Mr. Wade. Now, I understand Your Honor wants to look past the foundational issues, and I can appreciate that. But the
Trying to get
foundational
it dismissed on a
stuff
technicality.
is
He
very
sounds like a
important as it
defense
relates
attorney
to
a
the
little bit right
admissibility
now.
of the
I'm a little
records.
nervous.
No doubt about that. But if somewhere how they were able to survive those foundational concerns, do you have any reaction?
Yes, I do, and I will skip forward so I don't.
Yeah, go back to your script. Fast forward.
Let's see.
Here you go. Go to the
So-
cell phone records. Wade's handset was
What's
never in South
interesting
Fulton.
is that the records that were provided were for, they start in January of 2021 and they go, I believe it's to
November.
November 30th, I think
Yes.
is what of 2021, the
Yep, we're
span of the
missing
records.
December, yep.
And you heard from all of the witnesses, including Miss Yurdy, that Miss Willis did not move into the Hateville address until April of 2021. That was the testimony from all of the witnesses, April of 2021, and that she lived in her South Fulton home from when she met Mr. Wade in October of 2019 up until when she had to move. And the assertion by defense counsel is that Mr. Wade and Miss Willis began a relationship right after they met in October of 2019. What's interesting and what's telling is that Mr. Wade's handset doesn't once appear in anywhere near the area of her South Fulton home, but they're dating, but they're in a serious relationship. And if you were to believe what the defense counsel says, that they have been in a relationship from October of 2019 up until she moves in April of 2021. So, a year and a half or so, but he never once enters the area of her home. but they want you to believe that that's a lie, which is why counsel for defense continued to press District Attorney Willis and Mr. Wade as to whether he had ever been to that South Fulton home. Well, this corroborates that that was not a lie, that he had never been to that home. And it's more than suspect if you've been in a relationship, as they claim, for all this time, but never once went to the house.
Went to her bang
So,
house.
I think that's telling.
Went to
What I
Robin
would also
Yurdy's
bring to the
condo.
court's attention in the state's initial review of the records, that from January of 2021 to March of 2021, those times when Ms. Willis did not live again at the Hateville address, she didn't move there until April of 2021, that his handset appears in that area 23 times.
Sure.
Why
How do
he's
you, how do you
not living.
reconcile that with this testimony that was alluded to, I think, by opposing counsel, the reasons he gave for being in the area?
Well,
Would those line up to 23 times?
At the Porsche
I think,
experience?
you know,
well,
they didn't
what
give
I-
it too many
what-
reasons for being
Restaurants?
there, right?
What's he going
Well,
there
that's-
for then?
Well, I think that's the point. I would say yes, that is the point. He referenced that that's an area that it was not uncommon for him to be in. And it clearly that is the case because Miss Willis didn't live in that area. So again, it's further corroboration as to what Mr. Wade indicated to the court. And when
So you'd
I
have to
guess
believe
after
that-
Miss Willis moved into the condo in April of 2021, they appeared 35 times. Now, I want to make clear to the court, both Miss Willis and Mr. Wade never denied that he had been to that condo before. The specific testimony that was elicited by Miss Willis and Mr. Wade was that he had never laid his head, was the direct quote, at that condo, which
Never laid
these
my
records don't
head.
prove that he laid his head anywhere.
Whoa.
If you were to believe the analysis, or if you were to
I didn't sleep over.
if you were
I
to
never
give
laid my
credence
head.
to what the non-expert says as it relates to
So they must have been indicting each
Mr.
other on the
Wade's
couch,
handset
you know, or on the
in
kitchen
September
table.
and November for the 3 to 4 hours that the phone is alleged to have remained. That doesn't disprove anything that was testified by both Mr. Wade and District Attorney Willis. It was that he visited there. The specific hours of their visits was not something that was pursued during the questioning of both of the parties. So what I would also submit to the court is that if you look at the days as it relates to in September and November, the use, the type of information that is used to make the plots for the longitude and latitude of the handset is data records. It's not voice records. It's not
Duplicate
SMS
entries.
or text
Look at
messages.
that.
It's data records. And it is not uncommon for an expert to testify as it relates specifically to AT&T records that actual data record is unreliable as it relates to the location of the handset due to the type of information that it is, that it's data. It's not the voice and the SMS, which I know, Your Honor, as has been referenced, was a prosecutor not only here in this county, but for the federal government where this kind of information is commonly used. So in the comments that were made by the court, it was clear that you understood and understand the use of cell phone records as it relates to put somebody in an area, and again, not in a specific location. I'd also bring to the court's attention as it relates to the validity of the affidavit and the analysis done by the expert that was hired by Mr. Sadow, is that not once does it reference the fact that AT&T records commonly have duplicate entries within the call detail records. That is something that is commonly seen, and that is something that is seen in these records. And that is something that leads to the incorrect number of times that has been alleged that Ms. Willis and Mr. Wade were in communication through text and voicemail. And I'd also submit to the court that that number doesn't prove anything again, doesn't prove that anybody's in a relationship. It proves that they were in communication with each other.
About
And,
the case, I'm sure.
I think Your Honor
Yeah,
can
at
use
9 o'clock at
your own
night.
life experience as it relates
He
to
can.
people you work with or friends that you're close with.
Yeah, Judge.
And the number of times that you
Did you ever
make
tell
calls
your colleagues
to
that got home safe,
any of those
baby?
people. I can
See you at the office
submit to the
tomorrow.
court that I've
At 4 in
have
the
a
morning?
friend who I have
No.
been friends with for 15 years, and she worked in the office previously with me. And
4 in the
based on
morning?
our professional relationship and our personal relationship, the friendship that we had and still have, that we talk 30 times a day.
Whoa.
So and that doesn't mean we're in a relationship. So the assertion that
What's your
the
wife
number
say
of
about that?
times that Miss Willis and Mr. Wade have spoken to each other, whether it's through text
You
message
indict your
or
colleagues too?
phone, it's has no validity
At 4 in the morning, 30
as
times
it
a
relates
day?
to them being in a relationship. What I would submit to
I
the
don't know what's
court
going
is
on there in
that
Fulton.
what was shown through all of the evidence was that there's been a true cost to Miss Willis as it relates to her life, that she had additional expenses that she had to endure because
safe
of
house.
her position, in
It's
the
a bang
sense that she
house. That's what it
told the
was.
court that she had a mortgage, but on top of that mortgage, that
Gosh.
in a house she didn't live in anymore, she had to
Racism
pay
and sexism
for a
right
safe
here.
house. That her home was vandalized, and there were racial epithets and
Yes, we
sexual
know.
bigotry that were
Yes,
spray
we
painted
know.
onto her
Bigots
house.
everywhere, I know.
The concern of her safety and her life is something that was testified to, and the fact that this job has led to the isolation and separation of her from her family and friends, which was given credence and were provided by her father, Mr. Floyd, that he had only seen his daughter 13 times since all of these instances occurred. The cruel nature of the statements and the falsehoods that, for example, in these text messages that were purposefully leaked to the media as it relates to Miss Willis's daughter, subjecting her position in school, that she flunked out of college, which isn't true.
Okay.
Which in fact she has
How
graduated
about
from at
Fani calling
HBCU.
every
But
co-defendant
what's
a
been leaked to the
racist
media is the fact
and
that she
being opposed by God? How about that?
flunked out of school and someone other than her father
Yeah.
moved her, which again, the validity of which was never shown.
Yeah.
And all the while, Ms. Willis facing these costs has been able to continue to do the work unrelated to this case, which is shown in the fact that Atlanta's murder rate and violent crime rates have decreased while she has been in office. What was shown through the testimony of all of the witnesses and through the evidence that Your Honor heard was that there wasn't an actual conflict, that the defense failed to provide any sort of actual conflict in relation to Ms. Wade's
We got another note coming up
relationship
here.
that
Fanny
transpired
didn't deliver that note.
from the relationship between her and Mr. Wade, and that there was absolutely no evidence of a financial benefit that she gained as it relates to the prosecution of this case and the ultimate outcome of the case. The corroboration of all of that is the things that Your Honor is very much aware that she could have, I guess, financially benefited from, stretching out the case, for lack of better words, by the special grand jury recommended that 39 individuals be indicted. But through her sifting through the special grand jury's
Okay.
Report and all of the evidence with the
They
team
could have
that
prosecuted
indicted
more
the case,
people and ripped
they
off
only
more money.
went with 19 of the defendants, which had she gone with all 39, there, based on the defense counsel's assertions, would have given her the opportunity to certainly
Make more money.
find these
Yeah.
financial gains that are claimed through the allegations of defense counsel.
Yeah. So Fanny realized that Nathan couldn't handle 39.
More importantly,
you can handle 19.
why would Ms. Willis repeatedly ask this court to set a trial date as soon as possible if her motive in prosecuting this case was to continue to financially gain as alleged from the prosecution of this case? It doesn't line up. It doesn't make sense. And it doesn't make sense for a reason, because it doesn't exist. More importantly, this office has multiple RICO and as well as large scale cases like this one and much larger. And they also have, there's a lot of high profile prosecutions. If Ms. Willis's ultimate goal by hiring Mr. Wade was for her financial benefit, then she would put Mr. Wade on every single one of those cases.
So Fanny's
So
not
she could,
corrupt because
certainly
if she was corrupt, she would be completely corrupt.
riches and
Everything
lavish
would be
lifestyle
corrupt.
that has been referred to by defense
So
counsel.
she's zero. You're either zero corrupt or 100.
Which there's been
corrupt,
absolutely no
like
evidence of.
100%.
The evidence was
You're
she
not,
stated
like,
a
just a little
DoubleTree
bit corrupt.
in Napa, a DoubleTree.
What a ridiculous argument.
I don't know that to be a lavish hotel. Most people, when they go to Napa, if they want to lavishly experience Napa, stay at the Ritz-Carlton, the Four Seasons, things of that nature, not a DoubleTree. So the allegations and assertions that Miss Willis was living the lifestyle of the rich and the famous is a joke. Absolute joke.
She was on like 4 cruises in like 5
As it relates
months.
to what you heard.
4
And
trips.
the secondary issue is the forensic misconduct. And
This
for lack
poor
of better
guy. When's
words,
the last time he's been on vacation?
what it has
In
to be
Fanny's
shown is that the
office, right?
statements that were made here, Ms. Willis, related to the prosecution of the case and ultimately the guilt or innocence of the defendants. And we have none of those statements. There's been no evidence. Nothing has been provided to your honor as it relates to Ms. Willis's specific statements made about any of the defendants and in relation to the guilt or innocence of any of the defendants. I forget which defense counsel referenced the fact that she said she had a 95% conviction rate. Well, what Ms. Willis's job instill confidence in the community as to how well she is doing as it relates to her constitutional duties. And that was exactly what was done when she referenced that she had a
DoubleTrees are
95%
nice, aren't they
conviction
nice?
rate from the previous year that she was serving as the district attorney. More importantly, it's been the allegations about race and religion being imputed in her speech, and that those comments were directed at the defendants at this table. And if you listen to the speech, those comments are directed at 2 elected or political officials.
No, they're
I
not.
believe it was Marjorie Taylor Greene.
No, it's not.
And
You guys are ridiculous.
Miss Bridget Thorne, who is a member of the Fulton County Board of Commissioners here. She specifically used their names. I don't know that they, and my knowledge is they're not supposed to be sitting at the table, and I haven't seen them in my work as it relates to this case, Your Honor. So those allegations that Miss Willis committed forensic misconduct are, again, there's no validity to them. There's no evidence of them as it relates to any of those comments, which this is an issue that Judge McBurney has previously ruled on when these same allegations were alleged as it relates to extrajudicial statements made by Ms. Willis. And it involved a statement that the words fake electors were said by Ms. Willis. And he found that there was absolutely no conduct that was impermissible as it relates to forensic misconduct.
All right. I think we've got like 24 minutes left of this dude. And he's just walking us through the
And,
slides, fast forwarding now a
I
little
guess
bit.
to drive home the point.
You've already done that.
No
We got
point
it.
in any of
Got
the
it.
statements that were made and that are alleged here as it relates to the speech that she made at the church.
Look
At
at that
no point
statement.
did she mention the guilt
They are
or
not a type
innocence
that has ever
of
been
any of the
recognized.
defendants.
It's never
She,
happened in Georgia.
again, was merely responding to comments made
There's no
by
precedent for
Marjorie
this.
Taylor Greene
You say
and Bridget
hello.
Thorne to other political officials, therefore making her comments not even
It's never
close
been
in the
happened.
realm
Never
of any
happened
sort of
before.
forensic misconduct. What I find interesting is that defense counsel wants to make these allegations that Ms. Willis committed this forensic misconduct by the statements that she made in this as 2
Here we go.
unrelated.
Fanny was
distinct
bad,
public
but the
officials,
government, but the defense
criticized
is even
the job that
worse.
she was doing. And,
The defense is not a
I find
prosecutor
that
who swears an oath
hypocrisy,
and gets a badge.
Interesting in the
like the
sense that
prosecutor does.
we've had video proffers released to the media by defense counsel, emails between counsel released to the media by defense counsel.
Yeah, good.
Statements have
Good.
been
So
made
some transparency.
by
I'm glad we
defense
got those
counsel,
text messages.
in relation to this case. We had the unredacted version of the cell phone records of Mr. Wade released to the media by defense counsel with his private and personal information, causing the threat of harm to both Ms. Willis and Mr. Wade to increase. The most recent instance was the text messages that Your Honor hadn't ruled on their admissibility prior to their release. And it was made clear during the hearings that the ability to get those, the full chain was something that they were unable to do. But they figured a way, and the minute they figured a way they released it, the information to the media simultaneously with turning it over to the state.
Yeah, shout out to
And the
Megyn
court.
Kelly and Phil Holloway on that one. Shout out to Phil Holloway.
For all the reasons obviously stated before your honor, that this motion should be denied because the legal requirements that are required in order for the district attorney to be disqualified have not been satisfied. The defendants have failed to raise any issue legally or factually to satisfy the legal standard for disqualification. They must show an actual conflict. They've been unable to show that the prosecution of this case was at all a result of political bias, which has been accused or accusations have been made, as well as demonstrated that the prosecution of this case was motivated by any
think that's
means
irrelevant,
or
the
any way
political
because of
bias.
malicious prosecution. And they haven't been able to prove that this case was one of selected prosecution for political benefit or gain. All allegations that have been made during the course of different hearings and the procedures as it relates to this case. What I would leave the court with
Thank you.
and how
Gosh.
the state started
Finally.
the argument is that courts have been generally unreceptive, if not hostile, to attempts to disqualify prosecutors
This is true.
based on pervasive and institutional conflicts,
Think this
which
is
makes
true.
clear that the burden, that the standard is very, very high that must be met in order for an elected district attorney to be disqualified.
Yeah, and
And that
Fani
burden,
just
that
pole vaulted over it.
actual conflict has
It's a
not
high
been shown.
burden. She just
And
pole vaulted.
more importantly,
Fani.
in conjunction with
Right
that,
over
there's
it.
been
Nathan Wade
absolutely
right behind her.
no evidence that the district attorney has benefited financially at all, but benefited financially
4
in conjunction
trips.
with any outcome, whether it be now or ultimately as it relates to the prosecution of this case. And because of all those reasons, Your Honor, we respectfully request you deny defense counsel's motion to disqualify the elected district attorney, Ms. Fani Willis.
Oh, gosh. Fanny's now getting up, moving out of his
Thank you,
seat.
Mr. Abbate.
And Fanny's leaving the courtroom. Fanny is exiting the courtroom
44 seconds.
with her entourage.
That's what it says. Mr. Cromwell. I'll leave it. Oh, okay, handing it over. Understood.
All right,
Mr.
get
Sadow, all
those
yours.
disgusting PowerPoints out of here. Trump's attorney, Steve Sadow's back up for some rebuttal.
I'm going to do
minutes.
rebuttal, specific rebuttal. One, the state somehow makes an argument that we should have asked Mr. Wade questions about his relationship and his communications with Mr. Bradley when they objected over and over and over. Its counsel objected over and over and over, claiming that everything that Bradley was told by Wade was attorney-client privilege.
Exactly.
Your Honor made determinations thereafter
That it was
to
not.
Bradley. We didn't get the opportunity to call Mr. Wade back to the stand. So to claim that you can't impeach him because you didn't ask him when they objected to us asking him is obviously a false position to take.
Thank you.
As disingenuous as
Yep.
it can be.
Yep.
Now, if the court wants to open it up, we'll be more than happy to call Mr. Wade back to the stand.
Happy
But
to.
as the record stands, there could be no confrontation of Mr. Wade when both his counsel and the state are arguing that it shouldn't be done.
And covering up for what they know is going to be
Second.
perjury, which was so offensive about that.
Let's
Well done,
use a little
Steve.
common sense here.
Please.
Forensic misconduct received about 2 minutes worth of discussion. The rest of it is all on conflict. Forensic misconduct dealing with the way the state wants you to have it is if you don't accuse someone or you don't say that someone's guilty,
Yeah, assuming you can impugn someone's character to the degree that constitutes forensic misconduct. Why is that
I'm sorry,
the
say
case
that.
here? Assuming you can impugn someone's character to the degree that it constitutes forensic misconduct. The state's primary position was that they weren't talking about you at the church.
Right. And if you go listen to it and watch it, it starts off by saying, why does Commissioner Bridget Thorne and so many others, and then it refers to they attack him for being black. They attack him, not anyone else, just they attack the black man.
Yeah.
They're not talking about Miss Thorne or Marjorie Taylor Greene. They're talking about us.
Filing
And
a
you know how
motion.
everybody knows that? Because not a single story from the media reported anything other than Fani Willis accused the defense and defendants of being racist.
Clearly.
Now, here's the common sense part of this. If you follow the state's position on forensic misconduct, Fani Willis could all day long talk about race. She could say the defendants, I'm not saying they're guilty or not guilty, but they're racist.
Yeah.
They're racist. They're racist. And according to the state's position on forensic misconduct,
That's
that
allowed.
wouldn't be a problem.
Totally fine.
Obviously, that makes no sense whatsoever.
Their
The
standard
issue
is
here
stupid.
that we've dealt with on forensic misconduct, it's not simply the church speech. It's why she did it, how she did it, calculated, and all the other things that we talked about with the testimony of Wade. And let's go to the relationship issues and the cell phones briefly. No one knew that there was a relationship between Wade and Willis, according to Wade and Willis.
Right.
Not a soul was ever told that they were dating or that there was an intimate relationship, ever. They concealed it from all parties, from Daddy. Daddy didn't even know
Daddy
they had
Fani.
a relationship. To suggest that somehow in the beginning of 2021, January to whatever it was into April, that they couldn't have met in Hapeville, they didn't meet anywhere that would allow the public to see them. That's the reason why
They had a bang house.
they were meeting at Yertes,
Bang
because
house.
no one else was ever there. Remember the testimony? Who else was there besides Mr. Wade and Miss Willis? Both of them agreed. No one ever went there except them. They didn't go to where Daddy was in
No, they
Miss
didn't.
Willis's house because Daddy was there and Daddy would know. No other prosecutors knew. No one knows except who? The one person that knew was Bradley and Yerty. Yerty was best friend at that time of Miss Willis, and Bradley was the partner of Wade. Now,
Good stuff, Steve. Thanks for showing us how to speak like you
the
got a
only
pair.
way that Wade can walk, I'm sorry, the only way that Bradley can walk away from I have very little time, so I'll skip that. Let's go to something. Motive. That's an issue. Whose motive in this case is the strongest? Fani Willis,
Of course it is.
Nathan Wade.
Cover it up.
Because if they testify truthfully on every point, what happens if the relationship started before November 1st? They get disqualified.
Yep.
Who has the best motive of anyone to lie? They do. Who has the most at stake to lie? They do. Who wants to stay on this case for whatever the financial reason may be? They do. And
All right. Thank you, Mr. Sadow.
Thank you, Mr. Steve Sadow, Trump's attorney.
There
And
it
I
is.
think we're done.
All right. Thank you, everybody.
Ruling? No.
I think has been very much made clear by the argument and the made today is that there are several legal issues to sort through,
Yeah.
several factual determinations that I have
Yeah.
to make. And those aren't ones I can make at this moment. And so I will be taking the time to make sure that I give this case the full consideration it's due. I hope to have an answer for everyone within the next 2 weeks.
2 weeks.
Until that point, if there are any other issues that come up, council can reach out
File your motions.
and we'll have an order posted on the docket. Thank you all. We're off the record.
All rise. Thanks, Judge. Oh, okay. We're going to debrief, my friends, and we're going to hear from you. So Fani, as you know,
Thank you, sir.
it's Friday. She's probably already pounding that Grey Goose out in her office. Nathan Wade's going to go join her right now. Going to go fire back some shots. All right. Please be seated. Judge is out of there. All right. Let's see if we can percolate on any interactions that are happening back there. Okay. So Merchant and Merchant. Nathan Wade got a scratch on the nose. He's going over to co-counsel. getting some files. You got to get your files before you leave. So he's helping her grab some files. Let's see. Oh, let me move myself out of the way so you can see that. All right. All right. So Adam Abbate has his backpack. Good. All right. And the courtroom's clearing out, my friends. So, all right, let's debrief, shall we? We'll keep this open in the background. Let's do a little bit of a debrief. So today was a very interesting day. And I think, is that the judge again? Is he talking? No, I think that's someone else. That's probably Steve Sadow. Looks like Steve Sadow is back here. All right. So, my friends, the big takeaways. Now, this was closing arguments on the evidentiary hearing. And just as a quick recap, Fani is on the defensive here. And the defendants who have been charged with crimes, they are the people who are acting as though they are the prosecutors for this very limited hearing. It's their motion, meaning the defendant's motion, to disqualify and to dismiss. And a big part of today's closing arguments was really about two things. One is about the legal standard. Okay, what in Georgia is the law? We've never had a Fani situation like this before historically in Georgia, and so they don't have case law on this. They don't really know. And we spent a lot of time going through the cases to say this is what the standard should be. So whenever Judge McAfee comes back out and issues a ruling, he's going to define that for us. He's going to say this is the standard for disqualification. This is the standard for dismissal. Ashley Merchant's talking to the clerk, the court reporter, rather. And so we're going to see that. We're going to see what the standard is. In order to be disqualified, you have to do this, right? Just like in the law. In order to get a DUI, you got to be above 0.08 in some situations. You can also be impaired to the slightest degree, but you get it, right? What's the standard that you have to cross? That's number one. And that standard is going to have some elements to it, right? It's going to be defined. It's going to have some rules, materiality maybe in there. We don't know. Judge McAfee's really going to have to create this, sounds like, on his own. He'll be able to pull from some prior cases, but he's going to have to articulate what the standard is, and we'll see what it looks like. So we'll have those elements, and then once we get those elements, a little subcomponent to that is going to be what is the evidentiary standard. Okay, so once we know like relationship, benefit, materiality, maybe a threshold of $100 or more, whatever he comes up with, then we'll ask ourselves, what is the burden of proof? What is the evidentiary burden as it applies to those elements, right? So he'll define the elements for disqualification and dismissal, and then he'll tell us that the burden, in order to show that there was a relationship or that there was a material benefit or something, he will come back out, and the Zoom screen just ended for us, but then they'll come back out and they'll tell us what has to be met. So in other words, in criminal law, you often hear that you got to be proven guilty beyond a reasonable doubt. And that's like 80% or more. If you have any doubt that's based in reason about a person's innocence or guilt, or the elements of the crime, you got to find them not guilty. So that's a pretty high standard, right? And this is a criminal case, but this hearing is not a criminal hearing. This hearing is an evidentiary hearing, and it talks about disqualification. So the beyond a reasonable doubt standard that would apply to the co-defendants, to Trump and the rest of the co-defendants, that's not going to be the standard we're talking about, presumably. It'll be a much lower standard. So are Fani and Wade disqualified? What standard applies? Probably won't be beyond a reasonable doubt, but maybe it's a little higher than preponderance of the evidence, which is like 51%. If it's more likely than not, they'll find that you did it. So think of that standard. That's mostly a civil traffic violation is typically a preponderance of the evidence standard. So if there was enough evidence to hit those elements, let's just call them relationship, benefit, and materiality, then what evidentiary standard applies in order to cross that threshold? If it's a high standard like the government wants, they want it to be very high. And they want the elements to be about an actual conflict. They don't want it to be about an appearance of a conflict. Those are different elements, right? One's stricter than the other. And so if the judge comes back out and he says, yeah, you know what, it is an actual conflict, then what is the standard that applies to that one? And is it going to be beyond a reasonable doubt? I would say probably not. Is it going to be above preponderance of the evidence? Maybe. Clear and convincing evidence? Maybe. The judge will have to come to that determination, but it's going to depend on appearance of impropriety or not. Now, the other component to all of this is the burden of proof. So a lot of different, complex legal topics there, but burden of proof is who has the burden. And in this case, it is the defense motion. So in theory, right, they've got to bring the evidence, the factual evidence, in order to make their claim. And what we're talking about in a lot of this is burden shifting. So the defense is saying, well, we've already made our case. Okay, we've already shown that there's some lies here and there's evidence of that. And so the government should now have the burden, right? The burden shifts from the defense because it's their motion. It shifts over to the government, and then the government has the burden of refuting that. Or they have a government, or maybe they have the burden in the first place, right? We're trying to decide who gets to go, who gets to present the evidence that is going to be consequential in the outcome of this evidentiary hearing. But as we thought, the judge is going to retire. The judge is going to give this a lot of consideration and think through it. There was a lot of great testimony today. I think that the defense really did a nice job, and they have a nice benefit of having a whole slew of people there who can kind of plug the holes. So right at the beginning, we saw that there were some questions that were being lobbed at Mr. Merchant from the judge, and he was kind of trying to poke holes in it. And it reminded me almost of Supreme Court arguments or of an appellate court arguments where they interrupt you in closing and ask you about questions on the law, because that's what it was. The judge doesn't know what the law is. It's not clear cut either way. He's going to be making this up because it's going to be a case of first impression in here, especially in Georgia, especially with Fani Willis being extra Fani. It's like nobody's ever seen this before. So he's going to have to come up with a new standard, new elements, and then make these determinations. But he was poking holes. I thought Mr. Merchant did a great job. I really like how he came out and called the state, defended his wife's honor, called them out, said, they have been reprehensible from the very beginning. They came in demanding sanctions, calling us untruthful and all those things. And obviously that's not what happened here. We got evidence that came out, and a lot of it supports the defense arguments. Steve Sadow was great. I love how methodical he is. He just comes out, walks us through basically the elements, and he gave us some very good background on the ethical rules that they have on the books for lawyers, right? Lawyers have higher standards of care, a higher duty of care, right? Like if there's a doctor who's operating on you, you expect that doctor is going to provide higher care than someone who is a non-doctor, right? A non-doctor who's cutting your leg off is probably going to have a different duty or have a different idea of a duty, or we'd have a different expectation of that dude's duty than an officer who's a surgeon or a medical person who's a surgeon, right? Different duties, different standards of care because of your expertise. It's reasonable to ascribe a higher standard, higher expectations to the surgeon. Same thing here in this case, right? These are lawyers, and not just any lawyers. It's Nathan Wade, it's Fani Willis. These are the two highest power attorneys apparently in Fulton County, maybe Georgia, and they should know better than to lie on their interrogatories, to lie on their disclosure forms, and to lie in their affidavits to the court. And that causes specific ethical problems and violations of the rules that you then say are evidence of the misconduct, and this was the forensic misconduct that then is parlayed into the underlying claim. In other words, all of that was done, all of those lies were done to cover up their original misdeeds. Like getting in trouble when you're a kid, mom says, okay, I know you did it. You're in trouble, but if you just tell me the truth, things will be a little bit better for you. We all know that standard. It's a pretty good one. We all make mistakes. That's fine. But if you come clean about it and don't double down, then usually you're shown a little bit of grace. And I think that's how it should be because we're all human. But that's not what happened here, right? They covered up. They had people making phone calls to get rid of witnesses, and they lied in their documents, Nathan specifically, to hide all this materiality from his wife. And so it's reprehensible behavior, and they continue to lie. And it's an ethical problem. And I think Steve Sadow did a very nice job in calling all of that out. And so there was a lot more that went on, my friends. We had a lot of details about the affidavits. Robin Yurdy came up. The government, I thought Adam Abbate was the person who apparently drew the short end of the stick, and they just kind of gave him some slides, or he went up there. Fani was like right behind him, like with a cattle prod. She's like, if you screw this up, we're going to indict you next. What do you think about that there, Adam? He's like sweating, flowing through his PowerPoint slides. It was a rough presentation. I'm glad he finished up early and didn't use the full time because our ears were starting to bleed and it was painful. So in short, I think that what they were doing was a little bit of pounding the law, right? They don't have good facts in this case. We had a little bit on the back end of his presentation about some of the evidentiary stuff. He spent a lot of time on kind of irrelevant witnesses, I thought, like the governor, who was not really that meaningful. Fani's daddy, we had a whole big slide on that, but the rest of it was about the law. And even his interpretation of the law, I don't think the judge was very keen on, because he had read all the cases. He'd already seen it all. And every time he brought something up, he had some questions about it. He said, well, maybe my interpretation is going to now be what I know about the cases and my interpretation of it. So, all that being said, from here, we've been covering this at length, and we're grateful to have everybody joining us. We're covering all the Trump litigation, by the way, all of the J6 case activity, Florida case. Alvin Bragg is starting up in 3 weeks. We're going to be covering that trial at length here. That's going to be the next criminal trial for Trump. That's going to be a big one. And so thanks for subscribing, my friends, wherever it is you're joining us. Very grateful to have you, because this is a big deal. And what we're asking the judge to do is a big deal. And I can't understate that enough. I mean, what we've seen here from Fani Willis is disgusting. As a licensed attorney, it makes my skin crawl to think that prosecutors are openly doing this. And then when they get busted on it, then they lie about getting busted. It's constant dishonesty. And I've already known, I got my own opinions about prosecutors, but what we've seen out of Fulton County has been at a whole different level. Now, that being said, disqualifying the elected DA is a big deal. It's a big deal, especially on this case of national importance. So we got some questions about what's going to be happening in the court of public opinion in addition to the court of law. We have all seen the court of law. We all know Terrence Bradley. We can judge his credibility. You might have difference of opinions on that one, but I think it's been pretty clear that him, Nathan Wade, and Fani Willis have been dishonest and lied in their documents. To me, automatic, right? If I'm a judge, you lied to me and you have an opportunity to correct this, you're bringing dishonor not only to Fulton County, not only to the DA's office, but into my courtroom personally. And I've got an obligation to make sure that this courtroom is sanctified against all people who come in here and try to bring dishonor and lies on it. Now, if McAfee does disqualify her and there's some sort of a finding of dishonesty, some time ago, right? Great questions have come up here. Will this have impact on other Fulton County cases? And of course, my answer was very lawyerly. It's always, well, it depends. What is the judge going to do? If the judge says, yeah, Fani is a corrupt liar through and through, every defense attorney in Fulton County in Georgia is going to be doing backflips on that one and saying, oh, perfect. Because now we're going to make different arguments to our judge, right? So the public policy is going to counsel strongly against the judge disqualifying Fani and calling her a liar, because every defense attorney, it's going to be like Pandora's box just opens. Everyone is going to go hog wild in Fulton County, and they are going to want to get their cases dismissed. So the whole county is going to be in disarray if she gets disqualified. And if the case gets dismissed, there'll be political consequences for this too. And so one other idea is that Fulton and Georgia, they've been coming up. And to my knowledge, I'm not positive on the dates, but to my knowledge, both Fani and Judge McAfee are up for re-election. And there will be a date that comes by very soon, I think, where it will no longer be possible for anyone to register and run against them. Okay, so in other words, Fani will not have, she's currently running unopposed. I think she'll continue to run unopposed unless someone drops in like any minute. Same thing with the judge. So I think there's some deadlines coming up about, election deadlines. And if they can postpone a decision on this, in other words, if Judge McAfee can come out afterwards and say that Fani should be disqualified, he may not have to face the political consequences of that because the deadline for him to have a competitor may have already passed, right? And I don't know exactly the dates, but the logic remains. Same thing with Fani. If the decision comes out after, she won't have a challenger and she'll likely be reelected. So a lot of political pressure out there, a lot of legal pressure in there. And I think the judge was very fair today. I think that he asked the appropriate questions of both sides. And quite frankly, I think he's doing everything that he can not to reopen evidence. I think there's a strong inclination by the judge to say, I have enough evidence here. We do not need to keep exposing all of this because it's just causing disrepute on the court and in Fulton County. In other words, it's too messy. It's too bloody, right? Stop the bloodshed. Okay. They're already dead already. Let's just leave it there. Because if they bring back, and by the way, while we're here, I just saw this from Phil Holloway. Okay. So Phil Holloway, like there's more to come. We're not done yet. The lawyers are going to be submitting a bunch of other stuff in. And Phil Holloway, the same guy who broke the text message records, he just posted this. He says, big Fani Willis news inbound. This is from Phil Holloway. You should be following him on X. He says, today, bad news for Fani. A witness has come forward who saw Nathan Wade at lunch with Terrence Bradley 5 weeks ago. There's going to be audio of a voicemail to this effect soon. The evidence didn't make it into today's hearing, but the parties can file additional motions, as we heard, and Megyn Kelly has the audio. Shout out to Megyn Kelly, who's been breaking some amazing stories on this. Let's see what she dropped. Says exclusive, a waiter. Oh, so they have another affidavit. They can combat wine guy with this one. Waiter reveals he saw Nathan Wade with Terrence Bradley just weeks ago at a restaurant. Here's the voicemail. Megyn Kelly broke it. Here, let me unmute this. Actually, let me switch this. Let me give me 1 second. Otherwise, we're not all going to be able to hear this unless I put it appropriately in this browser. So let's do that right now. Boom. Let's see what Megyn Kelly has for us. New voicemail audio from the Megyn Kelly show.
Listening to the testimony, including Terrence Bradley saying he hadn't spoken to Nathan Wade in 2 years. Well, this waiter drops the following voicemail to Ashley Merchant. Listen.
I'm calling. So I just watched the Terrence Bradley hearing, and I noticed on there he said that he hasn't talked to Nathan Wade in 2 years. But I work at a restaurant here on the square, and I waited on Terrence, BC Chopper, and Nathan Wade about 5 weeks ago.
Wow.
We've reached out to this
Oh my gosh. These dudes are just flat out liars.
person, and he has told us after Nathan Wade joined Terrence Bradley and his lawyer, Chopra, who's mentioned there, at the table, that the waiter introduced himself to Nathan because Nathan Wade was the only one he did not know on a first name basis. Watching the hearing, he was surprised to hear that they, quote, have not spoken in years.
Wow. Wow. Shout out to Megyn Kelly and to Phil Holloway and to Ashley Merchant and to that waiter. Shout out to that waiter for giving them a call. Yeah. So they're liars, man. They just got up there and they just lied. Incredible. And man, hopefully the judge does the right thing. And so that's going to get dropped in there, submitted in, and it's just going to be wild to see. So I think it went about as well, about as what we suspected. And they submitted the wine affidavit and all the things. And so, my friends, now it is time to hear from you. What a wild day. And we're going to be here, obviously, when the opinion drops. And so thank you for subscribing wherever it is you're watching this. We also do members-only streams. So if you want to do a little extra debriefing on some of this, we're going to be doing that tomorrow morning. We have member-only streams on YouTube and on Locals, watchingthewatchers.locals.com. We do shows on Saturday morning, and we're going to obviously be talking about this. So come and join us, watchingthewatchers.locals.com, or become a member on the YouTubes. Also, if you want to sign up for our show newsletter and access any of the other show segments that we do, robertgovea.com is where you can find all of our PDFs, our newsletter, and other cool stuff over there. So thanks for checking that out. And we got some fun stuff cooking at watcherlodge.com. We don't have any events scheduled for the next week, but I'm working on it. And so make sure you check out watcherlodge.com. We just had a great political Zen wellness conversation that we're editing right now, and we're going to get it reposted over there. So come and check it out. But my friends, now it's time to hear from you. I know it's been a long hearing. We got some amazing super chats in the house, including one from Stephen M., which is the biggest one we've ever had here on the channel. Incredible. Thank you, Stephen. And so we're going to go through them and see what you have to say about this. And of course, I'm very grateful that you were here and joining us. I think this is one of the most wild cases that we're probably likely going to see in criminal law. And it's going to be historic because there's going to be consequences that impact the 2024 election. So very, very grateful to have you here. We go live every day of the week at 3 p.m. my time, 5 p.m. Eastern time. And we would love to have you join us when we go live. Of course, we'll be back here with the live regular show on Monday. And so let's hit some of these super chats, my friends. You guys are super generous. Oh my goodness. We got, starting out this morning, we had a beautiful morning. Robert W., our newest supporter. Welcome aboard, Robert. We got Billy N. Says, you know, today is a great day for Fani to have to take some accountability. You're right about that, Billy. She just showed up there for like, what, 5 minutes and sat in the back courtroom there. She passed one note to her guy to make sure that he, you know, didn't do a bad job. Otherwise, he was going to get indicted too. Thanks for the nice dono, Billy. And thanks for being here. We got Jose G. What's up, Jose? Is our newest supporter. Great to have you aboard. Knox Bierman's a defense attorney in Texas, says, I have to head to my own courts. Can't wait to catch up when I return. Enjoy, my fellow watchers. Enjoy. We did. It was a good one. Milo Phone Bill shared this GIF. Oh, yeah. So this one, he says, we're going to have to see what happens to the RICO expert today. And apparently he flies off the toilet. So I'll let that one play elsewhere. But thank you for that one. That came in from Milo Phone Bill. Glocky says, it's Friday, people. And it's Breakfast Club in the house. And it's good to see you, Glocky. Says, the lawfare against Trump is temporary, but the glory of Rome is forever. Says, Rob, if you have a minute, read the comment I left about the New York AG. She's unhinged. We'll get to that another time. Glocky says, hey, I think that hacker group was supposed to start dropping court stuff today because I don't think Fulton County paid the ransom. Oh, that's interesting. Yeah, Fulton County ransom. You know, the Fulton County computers been hacked, apparently. And that was interesting. Thank you for that, Glocky. Hey, Drew M. is our newest supporter on the tubes. And John B. has been a member for 2 months. Thank you, John. Says, Big Fani going down today. I think she's in a bad spot for sure. Jeffrey A. says, Rob, can the judge tell Fani and Wade in advance that he is going to dismiss them and give them a chance to resign? I don't think, I mean, not in an above board manner, you know, like that would be a backroom deal type of a thing. Otherwise, that's ex parte communications and not appropriate. But, you know, it's politics. Somebody might give him a heads up. We got Peter. What's up, Peter? Our newest supporter on the YouTubes. Great to have you. We got Tom F. says, Fani's condo was drafty, so Nathan came over to help her seal up her residence. You know, sometimes when you have like a window that has like a little bit of a crack in there, wind comes through it. And so Fani's condo was drafty. And so what happened is Nathan needed to come over there and give her some caulk. Put the L in there. Caulking, right? Put it in there. We got Glenn Croy says, hey, what's up, Glenn? Is bringing in 20 membos. We got Kevin H. Nojabski, the Sentinels here. Robert G. We got Chris N. Karen E. Kurt B. Edward H. God Rides a Harley is joining us. That's probably true. I'm a ruler of the planet Omicron. Per se 8 is now joining us. JF is here. Steve O. We got No Chillin'. Diane B. Peter R. Douglas D. Ray H. Will I. Sarah L. And Just D. All joining us. And thank you to Glenn Croy for bringing in 20 new members. We'll see you in the morning stream tomorrow. Debbie G says, will Trump be able to sue anyone, including Big Fani or Little Nathan, for malicious persecution? That's a good question. You know, it's another tall order. So in other words, once this case was dismissed, does Trump have any recourse? And the answer may be no, right? I mean, prosecutors have a lot of qualified immunity. So is he going to get any compensation on the back end of that? I probably would doubt it, but maybe. We'll see what the judge says. We got Shri. What's up, Shri? Bringing in 5 new membos. Michael S., Kim A., the lost 10mm socket. You always lose that one. Tambelina and Janie Laney in the house, courtesy of Shri. Thank you, Shri, for bringing the membos in. Tammy Beck. Very nice dono. Thank you, Tammy. Very generous of you. No question on that, but very grateful for you sending that in. Lady I says, hey, good morning again, Rob. Have you considered trying to read some of the dono chats in the hearing in the moment? It would be fun. It would, but it sometimes is, I try to squeeze it in. I try to squeeze in little blurbs in the middle of stuff. So sometimes it might be too much. We got Penny W says, Rob, thanks for your dedication. I'm learning so much about the law via your content. You are also sharpening my critical thinking skills, improving all areas of my life. Penny, what a nice compliment. And you know, it goes both ways, right? Iron sharpens iron. And we're all here having a conversation about this. And I'm learning a lot too. And I'm really, you know, growing, I think, as a person. And I'm really grateful that you're having a similar experience. And we're going to keep this up for a long time. So thanks for being here, Penny. And Penny's over on Rumble. She's got a Rumble channel. So if you're watching on Rumble or you want to go check out Nurse Penny, go check out her Rumble account, Penny Whitbrot on the Rumbles. Thank you, Penny. Lady Ice, we got Michael R. says, do you think Nathan is billing the state for his time in these hearings? It's a great question. He's probably not, but it would be amazing if they showed up. He's like, well, 2,000 hours, $2,000. It was a full day of me sitting there. $2,000, pay me. Hey, JKMT with a nice dono. Thank you, JKMT, for sending that one in. David D says, Rob, can the 8 criminal referrals Devin Nunes sent to the DOJ be revisited if Trump is elected? Crossfire hurricane? Probably. I mean, I'd be asking about statute of limitations and stuff like that, but probably. 2019, if he's back there 2025, I think he's probably within the statute of limitations. Liberty or Death says, I thought after Fani said that she didn't categorize it as a relationship until later, that the lawyer should have followed up with, well, what do you consider a relationship? Okay, when did you first have sex with Mr. Wade? Wouldn't that be victim shaming? They would say that, but it's a good question. Like, if they can't pin down their definitions, well, then you have to help them pin them down because they don't know what gift means. They don't know what marriage means. They don't know what relationship means. It's all strange. So you have to help them define terms. Penny, what's up? Says Nurse Penny here. I too have a brother with an intellectual disability. When you took my brother Joey's call during your show, it touched my heart. He and my bro share the same interest. Here's a gift for your bro. Well, thank you, Penny. We do love Joey here. So, of course, my brother Joey has Down syndrome, and he called in back during the evidentiary hearing. He's very interested in movies, Marvel Comics. He has some videos on YouTube at I Am Joey G. If you look that up, I Am Joey G. You can meet my brother Joey. He's amazing. And Penny, shout out to your brother. They're the best. They're the best. So we're in good company together. And shout out to Nurse Penny and your bro. Thank you for sharing that too. Quarter Native says, awful convenient. There's suddenly someone to say Fani paid in cash. I saw it. Anyone who believes that is deliberately blind. Wild Things Forever says, okay, I got my popcorn ready. Let's get this party started. It was a good one. Quarter says, next question is, does Brody know the Pelosi's? I bet he does. Yeah, the wine guy, right? He's like the wine guy. GOP Congress says, subpoena wine guy's phone records to see if he got contacted by the Dems and the deep state. In particular, look for Pelosi, Paul, Nancy, Gavin, and all those other connections there in California. Jay Water says, a $400 confession of Hibbing with no gift shop treasures, no photos, no I'm here with stupid shirts next to Pelosi's? Yeah. Did they take any photos and post them on their Instagrams? I don't know. Jennifer V says she doesn't even like wine. Yeah, she's back there right now hammering the Grey Goose. Her and Nathan are like, oh gosh, we made it. Oh, slamming them back. Stephen M says Anna Cross removed herself. At least one of them had ethics. Thank you, Stephen. And I know there's a really nice one coming in from you, so thanks in advance. Barb's Loves Alaska says businesses keep register receipts so there can be some digging at the wine business for their records on that date. So to determine if cash was in fact paid by Fani. Good to see you, Barb's. And thanks for watching over on Rumble and being a member over there. We got Frank L says, let's get her done, counselor. Are you going to cover the Letitia James money bots? We already did. Yeah, Frank, we already did that. I think this week we had a full segment on that and read through that amazing X thread by Mel. It was great. The segment should be up on that. Joel R says, you know what makes me mad? Fani and Wade get free legal defense for this case. They do. It's the entire Fulton County prosecutor's office is now on Nathan Wade's side. It's crazy. Fani's too. NY says, how much does the fact that she paid cash one time help her? How does it get around the Georgia ethics rules that was not $1 could come from Wade to Fani since he's a contractor? Even if they paid 50-50, it doesn't absolve them of this problem. Totally. She lied. He lied. Clearly. We got Surfer Rick says on cross, Nathan said that he couldn't recall if he traveled with Fani in 2021. I bet that's in the defense close. I don't know that we heard that specifically today. Yeah, and that's curious, right? I can't recall. Why would he be traveling with her at all if you're not in a relationship? Glenn Croy bringing in 10 new membos. Thank you, Glenn. NH is coming in. Zach J. Lawrence K. We got Christy L. Wire Rat is here. POV walks with roving Cyclops. Well, we got Paul. That sounds pretty cool. Point of view walks with roving Cyclops. Paul J, Renee C, and John M all coming in courtesy of Glenn Croy. We got this one from Felix. I believe they had hit Brad with the assault that made him clam up, but all this really makes the DA look like a bunch of cut-rate attorneys. They look terrible at their jobs. And I think they are, honestly. It's like, wow, even worse than I thought. Quarter says, Rob said, all rise, and 3 of my dogs looked at the TV and they stood up. Hey, shout out to those real good boys over there. Real good boys. It's true. We all have to rise, even to pay our respects. Even our furry friends have to, pay their respects to the judge. It's the judge. Ike's girl says, Anna mad after seeing them pay invoices. Oh yeah. So she's like, wait a minute. You were getting 700 grand. I got 130. This is racist. Real with Robo's in the house. What's up? Says Anna is gone because she proved Bradley and his rise is a liar. And that means all are liars. By the way, CNN cuts off the part on their stream. Expect guests. I invite them all. Real with Robo. Thank you for that one. Is Good Logic in the house? I think I saw Good Logic's in the house. Shout out to our friend Good Logic. What's up, Joe? My friends, if you're not familiar with Good Logic, he's right next door on YouTube. He's right next door on Rumble, and he's right next door on Locals. Of course, he does great work. And we love Joe. Shout out to Joe and Good Logic. Make sure you subscribe to his channel. And he's covering this stuff too. So alternative takes and more analysis from our friend Joe. We got Ike's girl. What's up? We got this one from Gordon. Gordon B says, I am exercising selective speculation soon. You can get away with it. I guess if you're charged with a crime, like in Fulton County, just say you don't remember anything. And I think you're off scot-free. Dapper Dave says, Dershowitz believes the judge is going to split the baby. Wade gets disqualified and Fani stays because he's looking for his own political interests. I don't know how he does that. I think it starts with Fani. I think they all got to go. We got Helen F. What's up? Shouting out from Sweden. Shout out to our friends in Sweden, man. That's super cool. I'd love to visit your country one day. It's going to happen. Eddie Block Film says they are bluffing because they don't want the evidence in. I think that's been true. A lot of evidence is coming in. So, and I think now their bluffs are being called out. They're being called liars about that. That was a big mistake. Felix is here. Says, winery affidavit looks like a note passed in a high school classroom trying to tell a girlfriend that all that they did with each other was taste milkshakes. And he didn't even pay for it, so it wasn't a real date from Felix. Yeah, it was pathetic. It's like, this is what you got. This is going to exonerate your DA, some random dude at a winery who said Fani paid with cash. Thanks. That's your big saving grace? Wow. Barb's Loves Alaska says, someone mentioned on a stream earlier that the judge and Fani's position are voted on in May. To date, no one is challenging the judge's seat and no one is challenging Fani's position as a factor. Okay, so I was looking at these dates earlier. We were looking at these on our member-only stream this morning. We were trying to pin that down. Like, I don't know what the timeline is, but I was wondering, because I think there's a March deadline. Like, I think there's a March deadline to submit your applications for positions that may be voted on in May. It's something like that. So if they waited, like if the judge waits until after, like let's say he disqualifies Fani and dismisses the case. Maybe there's a bunch of people in Fulton County who say, I'm going to go get this judge, get rid of this judge. Well, what if it's too late to run against him by the time he releases the decision? Does that insulate him so that he'll be back on the ballot because he won't have a challenger? Got to consider those things, but I don't know the specific timeline. It's just an interesting thought. Rob is here. Says, wouldn't running for office for the purpose of prosecuting Trump be a personal interest conflict of interest? Yes, I would certainly think so. Yeah, and that's like Letitia James to the T. Felix says, not only that, but the stupid public speech done in church was displaying her racial bias. Yeah, but she says it wasn't about the, it wasn't about them. It was about Marjorie Taylor Greene, I'm sure. John McGarvey says, hey, Rob, I really like this new McCarthy. Talking about Kev? I haven't seen much of the new Kev. Is he on a thing? Is he doing something out there? David D says, you know, I have satellite, which is Wi-Fi dish. My feed is constantly buffering, but only when it's a red-pilled vlogger like you, Rob. I've heard that before. Yeah, I've heard that. And, weird things happen on the tubes. It's probably the feds, The feds in the tubes. Thank you, David. Felix is joining us. Says, I hate when liberals use that kind of example. Cash in the thousands of dollars is not equal to a stick of gum. The fact is that they lied. And why would you need to lie if you did nothing wrong? They clearly lied. Great comment from Felix. Thank you. I agree. I agree. We'll see if the judge agrees as well. Just Cause is here, modding down the fort for us, says, take notes, Nathan. This is how you treat your wife. Talking about Mr. Merchant defending the honor of Ashley Merchant, something that Nathan Wade would never do. Felix says, where are the invoices? Where is the initial contract? For everything. Yeah, for everything. Good question. There were some invoices from Nathan Wade's bills, like we have those. But receipts and cash transactions and deposits and all the things, nope, don't exist. Anukai. What's up, Anukai? Anunnaki. Anunnaki descendant. What's up, Anunnaki descendant? Do I have a book about that? Let me, hold on a second here. Do I have this book? Yes. Okay, I know what that is. All right, I know what that is. Anunnaki descendant says, thank you for your coverage and translation of the legal mumbo jumbo. Yeah, there's a wild book out there that talks about the Anunnakis. Yeah, wild. Okay, that's a rabbit hole if you ever want to go down one. Thank you for that one, Anunnaki. We got Roy MC says, I wonder if Cross being missing and not being mentioned here is because she's flipped sides. I don't know about that. She's probably just disgusted and, not partaking. We got Yisraela in the house. Thank you for the pronunciation. I know, I'm bad about it. Finally made it to the stream, and I'm Snowbird in Arizona. Love it. Amazing. Well, we're glad to have you here. We love our snowbirds in Arizona, because they come here all the time and generally clog the traffic, but we still love our snowbirds. And we definitely love you, Yisraela. We're glad you made it too. And my other question would be, where are you from? Like, where are you going back to when the snow's over? Grateful to have you here, Yisraela. And thanks for being a member over on the locals. Felix says, her spirit in church where the church members should have rebuked her, since they're hexed by that, and they did not. Repent. From Felix. We got Ole Halnas. Ole Halnas says, hi from Sweden. Man, that's super cool. Again, I can't wait to go visit Sweden. Hi back at you, Ollie. Thank you for being here. We got Felix says, Proverbs 5:3-14 talks about the ways of the adulterous woman. This is the scripture her church members should have given her. Yeah, but she said, no weapon formed against me shall prosper. Okay. All right, Fani. Okay. Crash is here. Says, Sadow is an old pro. No nonsense. No extraneous gun flapping. Straight to the point. Nice and methodical. I love it. Wild Thing says, it's so sad, but the judge is setting up a way to not find Willis accountable. He's arguing her innocence. And he was poking holes, which I think he was, that was at the beginning. I think he was kind of doing that against both sides. I hope we're wrong about that. I hope that he does do it. Liberty says, what is good for the gray goose is good for the gander. From Steve Sadow. Great comment. Ryan PD says, shouldn't he be pushing the fact that Fani and Wade should be the new poster children of the film Giglio? We got this one. Felix says, every officer of the court needs to tell the truth under oath. 100%. How does the legal system function if everybody's lying in courts? It doesn't at all. Banks brother, what's up, says, first super, says, I can't wait to hear the state talk about how the defense is being racist. They did, basically. Yeah, racist attacks. Such a persuasive argument. You also saw first female elected DA. So when the judge disqualifies her, they're going to say a white judge and Trump MAGA got the first black female from Fulton County disqualified. Johnny Fives in the house says, all the other cases do matter, but this case is all the court here should deal with. You're right about that, Johnny. Wild Thing says, I can tell you now, based on his questions to the lawyers, he's already decided Wade and Fani walk, right? In the beginning, you may have felt that way, but hopefully you feel like maybe he was also asking the other side some questions as well. I thought it was pretty fair, all said and done. At the outset, it did feel like he's a little, poking holes, but we were waiting for him to poke holes at Adam, which he did. America First in the house says, hey, how's it going? It's going pretty good, America. Had a lovely Friday. Hopefully you did too. Voice of the People says, though the chat doesn't like this judge, to me it sounds like he's trying to cover all angles, so there's no wiggle room in his ruling. Exactly right. So basically the judge is saying, look, I'm going to write this thing down, and I'm afraid that I'm going to be attacked about this. So how do you answer that? Right? Like if I'm the judge, that's what I'm doing. I'm saying, okay, I think this is my argument, but let me poke holes in my own argument, and then let me ask the side to fix those for me. And then if those are good, then I know my argument is solid, and then I can release that. So I think that's ultimately what he was doing. Trevelyn Gale. Trevelyn in the house. Thank you, Trevelyn, for sending that one in. And hopefully I pronounced that right. Hey, Jaster M says, I know it's early in the hearing, but I feel this judge doesn't want to be the one to disrupt a huge court case of national interest due to liberal backlash or some other similar reason. It's my interpretation. It's a great interpretation, honestly. It's a public policy, again, court of public opinion, court of law. Court of law, we all see what's going on here, but we don't know what the governor's doing. We don't know what the White House is doing. We don't know what's going on in these other domains that might lead to pressure. And if we came out and we got everything's fine, I wouldn't even be that surprised. I'd be like, I would be disgusted. And I'd say, well, it's pretty much the end of justice in America, because that means prosecutors can do whatever they want all the time and no one cares. But that's why I don't think he's going to do that, because he's got his own he's a young guy. He's like in his 30s. He's got a whole career ahead of him as a judge. But I do get concerned about the politics, because you don't hear DAs get disqualified, especially on a case of national importance like this one. Ike's Girl says, this case has opened Pandora's box, literally bringing in all county offices and their conduct. County auditor, director, comptroller, PR, AP, bookkeeping, they all have the power to stop any spending. I would imagine that, right? I think there's going to be a domino effect. Whatever the judge decides, it's going to cause a lot of ripples throughout the entire government in Georgia. Jeffrey N says, is Nathan billing for this time in court? Wouldn't surprise me. Doug M, Lake and Riley funeral today is why we fight evil. Rest in peace to Lake and Riley. Prayers to her family. We hope that they have a beautiful and honored service today, and I'm sure they did. We got Marine for Life says, Wade is texting Fani, watch him. He's like, hey, baby, you seeing this BS? Can you believe this guy? He's clearly texting someone. Marine for Life says, Wade is texting Fani. And we got that one. Voice says, forgot about that. Wade lied in his interrogatories. His wife will get everything that she wants now. That's true. And I think that was already happening. But yeah, and I think that's why the divorce basically got resolved. It's because he's like, do anything, I'll do anything you want. Felix says, I can't wait to hear what the DA's office has to say. PowerPoint slides, wasn't that good? Stephen M says, Your Honor, if you put up with Wade's level of candor, we can't trust you. Yeah, it's just, to even believe those guys were being truthful, especially Bradley, what is your definition of truthful then? Pinochet says, how does this get investigated? The White House and via the executive branch, the DOJ in itself has its fingers in this. There is no way that they didn't know. Well, I would imagine that they probably did. I think the whole thing is tainted from the outset, right? Fani got the call from the White House to do this. What's up, Trevelyn? Trevelyn Gale says, Wade and Willis was living on the back of the Trump witch hunt gravy train. Trevelyn in the house. They were, yeah. And if they didn't indict Trump and the 19 co-defendants, they would have no money for their vacays. Frank L says, a lot of bored lawyers at those conferences, huh? Yeah, those conferences, man, those attorney conferences, especially the ones in Vegas. Everybody, all the lawyers, they're like, we're going to go learn about improving our law practices. We're going to learn about the latest technology. Yeah, right. Give me a break. All right, we got Todd Scott. What's up? 22K people in here, man. It was great. We had a great stream, and I'm just humbled. And it's awesome that we all get to talk about this together. It's really, really cool. Thank you, Todd, for saying that. Y'all hit that like button yet? Good reminder. Thank you, Todd. Felix says, 84-1, I wonder if we're going to have an Untouchables like in a 1987 movie, you were on the list moment with this judge, meaning Fani and Wade have something on the judge too. I certainly hope not. Hopefully he does the right thing. Jennifer says, I've had to do many silent screams to deal with the anger I feel at the deep corruption and the filthy criminal acts by Swampy Willis and Wade and Bradley. The judge must disqualify these people or I'm going to be angry about it. Jennifer, hang in there. We're going to wait for justice to prevail. Hopefully it does. And we'll be better off for it, all of us, even the people of Fulton County. It's not good for them to have corrupt prosecutors. Marine for Life says, I know Fani is watching in her office. You think when the state goes to give their closing, Fani comes bursting into the courtroom like the Kool-Aid guy, just like she did when she testified? Oh, yeah. Let's go. Remember that? Ray K. WTF, where are the funds, Nathan? Where'd those funds come from? Richard T. says, congrats to Lauren De Laguna for passing the bar in Arizona. She's also single, winky face. For all you single gentlemen out there, Richard Townsend, Lauren De Laguna, Arizona bar exam. Congratulations, Lauren. That is a tough test to take. You accomplished it. And we're looking forward to having you as a good member of the Arizona bar, fighting for justice out there all across the fruited plains of Arizona. Good to see you, Richard. And shout out to Lauren. Sounds like a babe. We got Matt P. What's up, Matt P? In the house with a nice dono and the first dono on a live stream. Thank you for that, Matt. Glocky says, the saddest thing about watching these older defense attorneys is the fact that once they are gone, the only lawyers America has left is the Marxist DEI-trained attorneys who don't even believe in the Constitution. Yeah, or care about ethics at all. They just do whatever they want with their money and just, go to Belize. Mother's Love. What about Tish James? It seems that she falls into this conflict of interest category based on her campaign videos. Would it? Angeron says no. New York seems to be perfectly happy with this, but yeah. She's civil, she prosecuted Trump civilly and it wasn't a criminal case, but yeah, she's conflicted as heck too. Rex M, man, what a generous dono, Rex. Rex Magnum. Thank you, Rex. Says, thank you for all your hard work. Great channel. Very, very generous of you, Rex. And we're really grateful to have you here. Appreciate the dono and your contribution. That's a big one. Thank you for that. Rex Magnum in the house. Thank you, Rex. Hey, Lauren De Laguna. Whoa, it's the newest bar passer. What's up, Lauren De Laguna in the house? Arizona's incoming attorney says, thanks for the shout out. Good to see you, Lauren. Very, very nice to have you stop by the stream and say hello. Congratulations again. We got Chubby. Says, I'm really curious how many of these valid points being made by the defense will actually be responded to by the prosecution, or if they'll just cherry pick what they respond to. Yeah, it's a good question. They're prosecutors. I figured he had slides. They kind of just mosey on through. They read. That's what prosecutors do. They just read and they have scripts. You should see them in trials, just like checking boxes. It's pathetic. Hey, what's up, Felix? Look at the clerks. They are disgusted. I was also watching for facial features and stuff. I would like to get, HDs on all their faces. I think you're probably right. RMR in the house with the Punisher logo. Thank you, RMR, for the nice dono. We got Daniel L., our new supporter. Danielle L. joining us. Felix says, this state just got burned to ash. The defense went scorched earth. And it was good. And I really like the tag team approach. They just boom, 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 one after the other to bring it all home. Stephen M. says, witness the grand slam at the end. And that was probably from Sadow or from that final guy, right? With the 6 points. Boom, 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 boom. That was great. You're right. We got Felix says they put the DA and the special prosecutor and they lied. Just Ranting says that last lawyer was the nail in the coffin. It was good. That last guy was really good. Very methodical, 6 conflicts. Pick any one that you want, Judge, and let's call it. Sharecoat says one major issue with guilt is she received a major benefit of being able to pay half of what their joint vacation would cost if she was alone. Yes. Well, and I think a benefit was having her boyfriend there. It's like if he's not there getting money, then she has no one to travel with. She doesn't have a travel buddy. So now she does. Philip B says, will they be able to appear in traffic court afterwards? Maybe in Georgia. Sounds like they kind of like it over there. Like they I don't know. Maybe, she'll go and maybe be the traffic ticket for judge for some other jurisdiction where they think that she was thrown out on a racist, bigoted attack by MAGA. Stephen M says, last guy crushed it. Their behavior in court sinks the whole office. Definitely clear and convincing. Yeah, it's gross behavior. And it should not be tolerated in law. Like there are other defendants who are not Trump, who are innocent people who have to deal with this office. It's sick. Like sons, daughters, brothers, sisters, mothers, fathers, all going through the system in Fulton County, dealing with Fani's reign. It's gross. Fani, says Felix. Dig that hole deeper. King Ginger says, wearing red like the Fani that she is. Rob says, I can see it now. This is all a racist attack on me because I am a black woman, which is basically what we got here. We got Caution Time says, I was expecting Sadow to shine, but Cromwell absolutely crushed that. What a perfect way to finish their arguments. Very, very satisfying. Good to see you, Caution. Former says, back when honor meant something, the oath at one time was beyond a reasonable doubt and a moral certainty. That was removed, and we can all see why. Yeah, to make it easier to convict people. BS, did Fani kiss the cheek of someone that looked like Bradley? The cheek of someone that looked like Bradley from my tiny faraway view? I don't know. Maybe she was whispering or something. I didn't see it, but yeah, she showed up just to make sure she could cattle prod her attorney. Stephen M says, Fani, judge says, Fani, you're going to close? Dig no deeper hole in my court or the bailiff will escort you to lockup. I was hoping that she would do those closing arguments. That would have been amazing. Felix says, hyperbole Fani, here come the amateurs. We know Fani wasn't going to do the arguments because she wasn't there listening to the defense close, but maybe she was on the stream or something. We don't know. Hey, what's up, Chris? Thank you for that one. And Stuart M says, Marie Antoinette, right before the guillotine, said, let them eat cake. Didn't work out well for her. Felix says, Fulton County DA, the office has DEI consequences. They're amateurs. It looked like that today. Kristen G. What's up, Kristen G? Thank you for the lovely dono. Great to have you here. And thanks for being here and joining us. 200 Watt Studio says, why didn't Merchant close today? Honestly, it sounded like Mr. Merchant was the kind of the academic. Like some attorneys are better at like reading case law and mulling it over and like getting really into the law. Other attorneys are kind of like punchers. Okay. So like there's writers and there's punchers. And Ashley's much more of a, like, I'm going to just punch everybody, right? We're going to send emails, send subpoenas, send text messages, like diggers. Maybe not puncher, like a digger. She's just digging all over the place. And the other guy's like researching, writing, theorizing about all this. And you want that guy to go do an appellant type of an argument, which is what we saw here today. So I think they just picked the people they thought were best suited to deliver the arguments. What's up? Kristen G says the state tested and didn't ask or bring Wade back up for rebuttal. Am I missing something here? No, you're right. You're right. And I think Steve Sadow made the same point. He's like, they kept objecting, right? They were protecting all of this, even though they knew on the back end, like behind the objections, they knew that it was bad testimony for them. And then they said, well, they didn't even bring it up. It's because you guys were protecting a liar on the stand. Chris, what's up? Says, hello, everyone. And hi, ladies. Hello, single ladies out there. Angry Bee. Anyone else notice Rob hasn't been standing when the judge comes in? He just kind of lifts his fanny a few inches. It's true. I'm totally busted. Seems like he took a page from the blue boxer guy. Those were shorts. We support our defense attorneys here. Those were clearly shorts. Sorry about that, Judge. We got Roy says, wanted her testimony and not the representative. If she makes the statement, then privilege doesn't apply. Chris is here, says, hi, Robert. I'm watching you on my lunch. Hey, cool, Chris. Hopefully you had a nice lunch. Something delicious. It's Friday. You deserve it. Felix says, guess the Microsoft PowerPoint class paid off. What a weenie. Man, he needed to work on his PowerPoint skills. First of all, I think it's like a default template. Then he used Calibri as the font, which is just like so generic and default, very basic. And then it was full of text all over the place. Totally ridiculous. Move those to your notes, bullet points. You don't want to confuse the person in the audience with all this text. Ridiculous. Yeah. Michael W. says, this prosecutor arguments are painful. They are not good at being on the defense. No, they're used to reading. Paint by numbers prosecution. Always make fun of them. I mean, because they put their officer on the stand. The officers know what happened. They say, oh, what happened next? Oh, what happened next? Oh, tell me what happened next. Tell me what happened next. And they just go down, check, 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 check. The defense has to be creative and actually do something in response to their lies and to their manipulations. And so it's a whole different ballgame. Good to see you, Michael. My friends, oh my gosh. Let's say, thank you, Stephen. Stephen M. Look at this monstrous dono here. Extremely, extremely generous, Stephen. And I'm like pretty sure this is the biggest one we've ever gotten here on this channel. I'm like 99% sure. So thank you so much for sending that in. And I know you've been here every time, been very generous on every one of these. We're on day 4 of this. You're here all the time, Stephen, being very generous. But this is like fantastic. You know, it's really good. Really, really nice. Thank you so much for sending that in, honestly. Goes a long way. We have a great team here. You know, I have people who help me with some post-production stuff. And so we are actually building this out to have more impact. And so the funds go places that we just reinvest back into the show. So thank you so much, Stephen. Really extremely generous. And so I wanted to just say thank you as much as possible for that. I appreciate it. Thank you. Felix, Bush League, Fulton County DA's office. Very sad. Shane Higgins says, thank you for doing this stream, Rob. Are the attorneys for the DA now potentially going to get sanctioned for their conduct? Maybe. The judge even said, did you hear him say, normally we refer this stuff over to the bar. Like, why don't we just give this to them? Make them deal with it. Well, it's because, Judge, the fraud happened in your courtroom and you need to do something about that. Hey, we got Judge. Did I even read Stephen's message? Says, this guy misrepresenting testimony. Be gone. I don't even think I read your message. I was so shocked about how much money you sent in to support us. And I know who you're talking about. Adam Abbate. Yeah, he was inserting new facts into the case in trying to squeeze all those by. Thank you, Stephen. Sorry, I was so shocked. I almost skipped your dang question. You're right. And Adam Abbate, I don't know if he drew the short end of the stick or what, but he's probably drinking some Grey Goose with Fani as well. We got D. London says, Judge McAfee says, someone please make this stop, my brain. Philip B. says, has he ever argued a case? He sounds scared. He's probably nervous. I mean, you know, think about having to go defend Fani Willis in front of all of America when we all know it's total lies. Thomas W. says, so did Cross remove herself from the case? You definitely see why she hasn't been leading the DA's case the whole time. She may have, you know, we haven't seen her show up in filings and we haven't seen her back. So but the last time I checked the Georgia docket, not that it's updated regularly, she was still on there. So I don't know that she's filed like a formal, you know, motion to withdraw from the case or anything like that. I have not seen that. D. London, the defense has met beyond a shadow of a doubt. I would absolutely, like, if this was a prosecuting team prosecuting someone for perjury, they'd have all the evidence in the world they need. Joshua B. in the house. What's up, Joshua? Says, did she hire the dumbest people in the state of Georgia for this county's DA office? I'm pretty sure. Yeah, I'm pretty sure. And again, like, there's external evidence to this. They have 0 convictions in this trial, in this whole prosecution, 0. Even Jenna Ellis and Sidney Powell, 2 of the brains behind the whole operation, got diversion deals, okay? They don't even have convictions for them. The whole thing is just like a joke. Jeffrey Neal says his legal skills are worse than Fani's. It's probably why he works for her. She's like, just like I trained him. Great job, just like I told you. Glocky says, this prosecutor's terrible. I noticed he was a lot tougher calling defense counsel a liar, and he should be disbarred, than he is actually making a valid argument to this judge. Dude is beta. Andrea C. says, Fani told him to read the PowerPoint she created. Here, go read this. I don't know if she did it, because if she did it, there would be a lot more bold. There was some bold, and there was bold and underline. You're right. There was bold and underline there. We saw a lot of it. Kristen G says Fani made a PowerPoint for them, and he has no idea how to argue her crooked points. They are basically calling the judges stupid. Yeah, the judge was like, I didn't read the case that way. Well, I did. Okay. Well, we'll see how that argument works out for you. Andrea C says, he sounds so weak and scared. Well, he's a prosecutor. He's actually got to do some thinking for once. Daniel H. Nice dono, Daniel, says, I noticed a number of simple clerical formatting errors in the state's PowerPoint presentation. Also, the presenter needs to retake public speaking from his freshman undergraduate year. What's up with all this, Rob? I don't know, Daniel. It sounds to me like this dude is maybe just, again, the one who drew the short end of the stick. A bunch of other prosecutors at that table. Why couldn't they do it? Why didn't, Anna Cross come back and do it? This is the best dude they got. Okay. He did say and basically as filler words in between every sentence or so. I mean, he's probably nervous. But this guy I've not been, a fan of from the day one. He wanted sanctions and all that stuff. Like a lot of bravado, a lot of bark, but you can't back it up. Thank you for that one, Daniel. Liberty says, the only thing better with the Abbate would have been to have slide transitions. A mirage here, a tile in, a tile out, etc. I was expecting it. That would have been great. Like every one of them has like really obnoxious, like, when every character comes in one at a time, it's like, ba, 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 ba. Like, oh gosh, it's really annoying. I have that for every single slide. Ike's Girl says, my 7-year-old grandson can argue better than this guy. I believe that's true. Deborah C, what's up, says, goal. Thank you, Deborah, for sending that one in. Very generous of you, and a lovely cat in that photograph. We got Kathy C says, thank you for your coverage. Truly appreciate the facts and explaining the truth in this trial. Kathy, I appreciate you. Thanks for being here and for sending in that dono. We got Teeny BB says, a membo for 7 months, 2 months away from a baby, says, Rob, does this guy's law citations seem credible? Well, I think he's citing to cases, but I don't know. I don't know all the Georgia case law. The judge does, and the judge had some serious questions for him about it. And so I think that they had some differences of opinions on some pretty big cases that definitely mattered. Jed Finn says Adam's voice is irritating. It was. Yeah, it was. It was like painful. I'm glad he finished early. Obscure Ocelot says, have you ever had a dream that, a lot of that. T. Lewis says, Adam knows he's way out of his league. He's running with the big dogs. You can hear it in his voice. I bet he wishes he kept his hiney on the porch instead of trying to run with the big dogs. Pretty hilarious. Yeah, and honestly, I'm not trying to defend this guy, but he had an unenviable position of having to defend Fani. And I don't know if anybody could have done that very well. But he had a lot of bravado, which is what I don't appreciate about that, And he kind of kept doubling down on some other things. Like, no, I wasn't dishonest. She was dishonest. And she made a material misrepresentation, right? So he was following the Fani strategy, honestly. Crawley says, voicemail from a waiter, Wade and Bradley, they met 5 weeks ago. Wade lied, and Megyn Kelly and Phil Holloway broke that one. Thank you, Crawley, for the notice and for being here today. Daniel Henry says, yes, it's the default font shipped with the previous version of Office 365, which is Calibri. I had a feeling. I knew it. Not even the current version, which is Aptos, making things even more ratchet. Totally agree. Totally agree with you, Daniel. That is also an out-of-the-box theme. It's not even from the gallery. Pathetic. Pathetic. I'm as offended as you, Daniel. At least change the font. Don't be disrespectful to your audience. We don't want to see Calibri anymore, okay? We've seen the Calibri font for like 2 decades. We're sick of it. Change it. All right, thank you, Daniel. And I didn't even know Aptos was the newest one. I think I have to update my PowerPoint. Thanks for the update. Hey, what's up, Obscure Ocelot? Says Adams is the MVP for the defense. He did a great job for Ashley Merchant and Mike Roman. Kristen Galante says, please say it. Sit down, Adam. Sit down. Oh, gosh, he finally did. Catania says, Megyn Kelly reported a waiter came forward disputing Bradley's testimony. He waited on Bradley, his lawyer, and Wade 5 weeks ago, not 2 years ago. Mr. Bradley's attorney also committed fraud on the court. It's just so disgusting. Disgusting. Steve N says, this has been great, Rob. Sure am hoping for a good outcome from our friends in Montana, Missoula. Amazing, Steve. Thank you for saying that, man. And I think I was telling you, that's Montana, right? And yeah, I was looking around Montana. You guys have a beautiful state, man. It's gorgeous up there. Hey, what's up, Teeny BB? Says, thank you, Rob, for your time and energy covering this. You're the bestest. Well, Teeny, I think the same about you. Thanks for being a membo and sending this in. Says, love ya, aloha, love and flowers and aloha. Aloha back to you, Teeny BB. Thank you for being here and for donating and for supporting our work here all the time. You're amazing. Thank you for that. We got this one from Stephen M. Says, son, sit down before the bailiff drags your old Fanny to jail. Oh, gosh. Honestly, they could all be charged with crimes, and Fulton County would be better off. Thanks again, Stephen. We got Roy MC says, this sounds like the movie Liar, Liar. Bathroom break neck so this guy can beat himself up in defense. Come back up and say, who beat you? A madman, Your Honor. Danny Liu is our newest supporter. Thank you, Danny. Welcome aboard. We'll see you tomorrow on the members-only morning stream for all of our membos. Yisraela says Cross jumped the sinking ship. Saving a little bit of what's left of her reputation there. We got Neoe says, how many ums per minute per Nutella, or is he special at? Good question. There was unfortunately no Nutella, but there were a lot of ums. Felix says, they're not qualified to handle a RICO case. Very sad. POV walks with roving Cyclops says, attorney. Okay, yeah, attorney. Oh gosh, that's a bad visual. Yeah, says that guy's been really taking it. 59 minutes presents. Thanks for what you do, Rob. Thank you. 59 minutes, not 60 minutes. Even faster show. None of us have 60 minutes. Okay, 59 we can do. Lewis H is bringing in 5 new membos. Amazing. We got Big Boy Blue, Marty F, Anti Metals joining us. Raza's here, and Krista coming in. Thanks to Lewis, Holly, 5 new membos, and bringing in a membo as well. Amazing. Hey, my goodness. Louise Holly, thank you. We got Daniel Henry, another one, says, someone give the state attorney his animal career cookies and his juice box. It's nap time soon. He did a good job pretending to make a good argument. He could be a real prosecutor someday. Everyone clap for little Adam. Okay. Good job, Adam. Okay, you're done. Okay, good job. Okay, thanks for, okay, come sit down over here. Don't move. Okay. The teacher's like, oh my gosh, what did I do this for? Adam, hilarious comment. It did feel like that. It's like, next slide, next slide, next slide. And he just read from the slides. Like, oh. But maybe that's what they do in Fulton. Maybe Fanny's like, this is great. She's like tapping Wade. She's like, we're crushing, aren't we? Let's go have some Grey Goose. Lady Ice says, he's cold. He's so cold and slimy and nervous, like someone caught in a trap trying to talk his way out with the cat. Not a good strategy. Will H has been a membo for 1 month. First month's the hardest. It gets easier from there. If this kid says, one more time, Carrie Cake is here, not Lake. 5 months as a membo, 4 months until a baby comes. Says, thank you, Rob, for enduring this with us. Yeah, that second half was a little rocky there. Always love the extra commentary. It warms my heart. Proud to be here in Arizona with you. Amazing, Carrie. Carrie Cake Membo, 5 months. Keep up the amazing work. Thank you, Carrie. And shout out to our friends in Arizona, right around the corner. Good to see you. We got this one from Mother Love. Says he will probably resort to teaching law after this. He's totally qualified to meet the woke requirements. Yeah, probably a lot of that. Or maybe they'll get gigs at MSNBC. Pamela B says, hard to feel bad for any of these people. They're not making their case. My computer is very hard to listen to him. My computer keeps buffering, and I don't know why. Maybe because it feels sorry for the guy. That's the second buffering complaint. Have other people had buffering? I got excellent connection over here, excellent connection over here on all my locations. I don't know if that's on my end. Hopefully not. It says, my computer keeps buffering. I don't know why. Maybe because it feels sorry for this guy, but it makes his nonsense even more pixelated and even more nonsensical. Interesting word. Yeah, pixelated. What a great word. Yeah. You can like see the pixels, right? What a great word. I love that. Joel is here. Hey, as our newest shout out membo, good to see you, Joel R. Thanks for joining us. We got Senevies says, even if she actually did reimburse Wade her half, that's still a conflict because she didn't cover his half, which came from state money that he was proportionally paid. She may have had her half, doubtful, but he had his half because he got $700K. Wild. All right, so locals, friends, we're going to open up a new thread because we're about to run out of time over on our locals platform. So before that happens, we're going to do a part 3 and make sure you join us on this one. And so that is going to be coming up very soon, as soon as I click it here. And we're just going to swap it over. And then that way we'll have our members only after party happening any minute now, as soon as we wrap up over here. But let me connect some different tubes so we can get our locals friends back up on the screen with us. And here is that happening now. Okay, so thank you, Senevies, for that one. We've got Venick Artful says, so he wants us to accept corrupt prosecutors? I think that's absolutely true. Says, yes, basically, the standards are so high that they have not met it and they can do whatever they want all the time. G23 says, the worst closing argument I've ever seen. He needs my cousin Vinny. It was pretty rough, wasn't it? It was rough. We made it. Michael M says, is Abbate a law student? What the heck's going on here? This is laughable. What font do you use, Rob? Oh, that's a good question. Well, in my PowerPoints, I'll tell you right now. Let me tell you what font it is. PowerPoints. What do we do? What font did we use for our Survival Squad challenge? I'll tell you. Tell you what, it wasn't Calibri. That's for sure. Oh, Avenir. This is a good font. Look at this one. This is Avenir, okay? This is from our Survival Squad PowerPoint that was over on locals. Okay, so just to show you, this is how I do my PowerPoints, right? And like here, like this is like a nice visual of our food sovereignty workshop. Okay, bullet points. You just talk about it. These are simple bullet points that I flash through one after another, right? Like just like, and this is a checklist. This is for people to like print out and build a checklist, right? So that they can print all this stuff out. But yeah, I mean, what font is this? Avenir book. This is Avenir medium, Avenir black. It's a little nicer, a little simpler, you know, and you just have a little bit more clarity in what you're doing. You don't have like a weird PowerPoint like that. And I'm not a PowerPoint master, by any stretch. But I'm not using Calibri, that's for sure. Hey, we got this one from Jojo Maru. Says, here's a quote, 1700 French attorney. It says, "C'est qui sait quand quoi, bien s'inscance clairement, et les mots pour les deux arrivent aisément," which means, that's my best French, says, what is well conceived is clearly stated, and the words to say it come easily. Great quote. Great quote on that one. And I think that is true. Yes. All right. So thank you, Jojo. We got Felix says, crossed arms from the DA to comfort and protect himself. Good body language catch. Pinochet says, the way the prosecutor is talking is chilling. It's just kind of sending disgusting chills down your spine. Mrs. TR says, they never mentioned Willis's dad was a Black Panther. What kind of upbringing did she have? I've heard that. I've seen other headlines to say that. They did not mention that, right? Did not come up. Don G says, if UMM was a drinking game, we'd all be having our stomachs pumped right now. Here's a quote from Lady Ice. Says, Your Honor, I would like to present to the court that what I'm trying to make clear is that this slide explicitly demonstrates that I have absolutely no good arguments because Miss Willis is so obviously guilty and corrupt. Yeah, good attempt there, Adam. Voice of the People says, this Adams guy is like listening to a leftist defend Fani when they never heard even a minute of the trial. We've seen a lot of that, right? We played that clip yesterday from 11 Alive in Atlanta. And they were all doing the attacking a black woman thing. You're like, did you guys watch anything? Like, nobody's even talking about the fact that she's black or a woman at all. At all. But that's all that they default to. It's crazy. Roy MC says he didn't testify he paid it off. He said he left money in escrow. That's a good point. That is a good point. Mustafa says black and white are both fighting the demons of racism. Ignorance does not discriminate. We must humble ourselves and unite to overcome the past so that we may preserve our future. I couldn't agree more. I mean, can't we all just agree that we want basic human rights like, free speech, due process of law, like all of those things, right? We can at least agree on that. But they just are constantly trying to get us to kill each other over this race crap, and it drives me nuts. And they bring it into the courts. Drives me nuts. Spuds is here. Pound the PowerPoint. That's a great line. I love that. Yeah, if you can't pound the facts or pound the law or pound the table, just pound the PowerPoint. That's another good one. I'll add that to my little routine. V is never silent. Says, wondering if Trump is going to incorporate this guy's ramblings into one of his speeches. It could be pretty entertaining. And he just clicks the slides. Crisis at the Border says, I'm sure my cat could have done better than Adam. No doubt about it. Cats are at least, cats are very fickle creatures as well. So are prosecutors. But I believe it. Hey, what's up? Kelly K says, Robert, Megyn Kelly has audio of the evidence that they said about when things before things started today. The part of the defense lawyers raised at around 1:03 p.m. And Kelly, you sent this in before we played it. And it's good audio. And hopefully they get that guy. And he says, yeah, they lied, Judge. Again, here's another witness. So they want to submit the wine guy. Here, we'll submit another one. They're liars. Thank you, Kelly. Brian says, did Wade give her the money, example, a wad of cash, before they did the wine tasting and heating up Fani for the gavel pounding the gavel? Boom. We don't know. Are they paying for intercourse, I guess, is the question. Luke's television review says cash would still have a paper trail if they deposited it, withdrawals, etc., which is what the defense established did not exist. It's a great question. Yeah, they said there's no evidence. Well, because they didn't deposit it, because they didn't withdraw it from anywhere, because it was all a lie, because there was no exchange of cash. That's the truth. Glenn Croy bringing in 5 new membos. Queen Bee's Art Hive, Carrie Who's a What's It, Rick Allen's joining us, Kez Dean, and Man of Steel, all in the house, courtesy of Glenn Croy. Thank you, Glenn, for bringing in our newest of membos. Felix calls it deflection. Absolutely true. And Glocky says, X is exploding. Fulton DA is looking like trash to a lot of people. Here's this one. That during their closing arguments, their slides have 2 number 1s. Oh, look at that. Yeah, 1. Is there an actual conflict? So even his PowerPoint skills aren't that good. So he's translating between the number 1 and the bullet points. Yeah, total amateur. Hey, Spirit Dragon says, he's harder to listen to than Justin Trudeau. Grateful for all you do, Rob. Thank you, Spirit Dragon. Thanks for being a membo on the locals and for supporting us here today. We got Leah says, will we get a decision today? No, unfortunately. He kind of said maybe. He kind of hinted maybe we'll set something, but no. Took it all back. And we'll get a ruling in 2 weeks or within 2 weeks. Knox is here. Defense attorney in Texas says, TGIF all. I would love for the state to Daubert its own telephone record software. And that means to basically, Daubert is a case that talks about whether evidence is really reliable and whether an expert witness and whether evidence meets basically a scientific standard and whether you can admit it and rely on it. It's all about the admissibility of evidence and witnesses. And so if Fani says that her own telephone record software is bad, then they have just disqualified it from all of their other cases. And Knox says, I would be drafting writs all day if I was down there. I know. It's like, it would be a lot of fun to be a defense attorney in Fulton right now. I got to tell you, anytime there's even a whiff of prosecutorial misconduct, it spreads through the defense community like wildfire. We just go wild. And not so much anymore, but when I was practicing, a lot. And it's got to just be a field day over there. They're all texting each other, going to happy hours. Did you hear this? And stuff that they can't share with us, like they're all talking about it. 51K says, this guy is sorely lacking in confidence. He doesn't even sound like he believes what he's even saying. It makes me wonder, if you were to rank in order of importance a list of skills and traits necessary to become a successful attorney, what would that list look like, and his confidence on it? I think it depends on the role. It's like asking, like, what's the best football player? I don't know. I don't know, like, what's the best football player? Who would make the best football player? It's like, well, I don't know. Do you want him to be a running back, or someone who can catch, or someone who's a big lineman, or a fullback, or a quarterback? Like, what do you want? So it's a great question, but it depends. There's many different positions in the law. And so if you're a litigator, confidence is definitely on that list and definitely near the top. And that guy didn't have it. Jetstream says, I haven't said this publicly until now. All cases against Trump will be dismissed or have problems. It's a bold statement. I like it. I give thanks to my Lord and Savior, Jesus Christ, for answering our prayers. Amen. We sure hope it goes that way, Jetstream. Thanks for saying that publicly here on our channel. And amen to that. We got Wild Thing Forever says, I think that need to look for a hotel in the area from January to April 2021. Then they opted to get a condo in April. No. Another great point. I wouldn't even believe their statements, honestly, about when they actually moved in or not. If you believe their timeline, if you think they're credible, then maybe you could say, yeah, there was probably another solution there, but I don't believe it in the first place. Hey, what's up? Stephen M says, never laid my head because I have a special pillow. Yeah, he's got one of those neck pillows. So he just falls asleep on Fani's couch like this with the neck pillow on. Brian says, maybe she got her cut of the money before the wine tasting. The waiter means nothing. Where did that wad of cash come from? I still think maybe the evidence locker, could be the evidence locker is where it came from. Hey, Ike's Girl says, Rob, look up the cell towers, please. Look them up? Well, we have the affidavit. Is that what you're asking about? Parlor said, hey, what's up, Parlor? Our newest supporter. Welcome aboard, Parlor. Good to see you. Wild Things Forever says hotel, hotel, hotel. From January to April 2021, then a condo. Must be the answer, no? Could be. Or they were just already at the condo, and they just said that they got there in April or signed a lease in April, but they were still just borrowing it from Yurdi or whatever. Like maybe the paperwork was done, but this was like a friendly deal. So maybe they executed a lease when they needed to. Michael W. says, if she had so many extra financial burdens, how'd she afford to pay back all those trips and dinners? I don't know. I don't know where all that extra money came from or where she got it from, but apparently it's magical. Jennifer, excellent show. Thanks, Rob. Thank you, Jennifer. Thanks for the donos. Thanks for being here. Thanks for being a membo. Amazing. We got DJ Liquid Smoke says, McAfee is like, I want to believe. And it's the X-Files theme song. We got Jetstream says, the prosecutor is stumbling over his own words, meaning he can't defend his case. It's a hard one to defend. Irked is joining, says, the prosecution is what happens when charisma is your dump stat and wisdom too. So in a video game, like an RPG, you got different things you can elevate. Irked is in the house. Charisma is at a 0. Rocky Waters in the house. Says, Rob, any idea how we can get you the old Rush Limbaugh AM radio slot? Oh my gosh. That would be like such a thing if that ever happened. I would absolutely love that. Who to call? I don't know. Yeah, I know it's been replaced by these two guys, one of whom is, we'll leave that alone because I'm sure they're nice guys, but the CIA is everywhere. Let's just leave it at that. Okay. And it'd be nice to get that slot back. It'd be nice to get the Rush Limbaugh slot away from the CIA and back into the hands of the people. And I'd be honored to take that over. Rush Limbaugh, may he rest in peace. We miss Rush. And America was in a lot better position when he was around. Thank you, Rocky. Amazing. Hey, this old guy says, this is Rob after listening to the defense for 2.5 hours. That's basically how I felt all day. That's how I felt all day. I know many of you felt that too. Thanks. Great screen grab. That's very true. Oh, gosh. Here, Jomaz says he needs 2 weeks to figure out how to let them prosecute Trump anyways. We'll see. I hope that's not what he's waiting for, but we'll see. Felix is here saying Fani is getting notes ready for a third church speech. Maybe she'll show up on Sunday. I need your prayers again, Atlanta. Wild Thing says 2 weeks is BS. He wants everyone to forget the overwhelming evidence, then rule that Fani did nothing wrong. Total BS. We'll see. I'm willing to give him the benefit of the doubt to see if this comes through as it should. Jay Water, Road Less Wolf says it's not just financial now. It could be financial after from the Democrat Party. Slideshow is for MSM propaganda. Fani screamed racist only, not sexist. As a female, brought the accusations against them. From Jay Water, Road Less Wolf. Roy says it's probably allowed, but isn't Fani leaving before the judge disrespectful? I don't think so. I think that was kind of normal. I don't know why she didn't stay for the whole thing, but says, so do you think that riveting slideshow persuaded the judge? No, I don't. He already knew the case law better than the other guy did. And it wasn't even a good slideshow. Johnny 5 says, I would think the judge would want to scour the state's rulings on similar cases because Georgia never had this issue come up. Well, he's definitely investigating other case law and how it applies, right? If it's precedential, he'll pull from some of these other cases and incorporate them into his ruling. Cyrus is here, says, if Big Fani gets tossed, can she appeal? Yes, I think she can. How soon would the appeals court hear it? And so that depends. I mean, she's going to probably ask for it all to be expedited. And so I don't know what the timelines are there, but you know, you always have to file a notice of appeal and then an appellate memorandum and then, you know, response and then oral arguments. Would she have to pay for the appeal? Paid by taxpayers? I think her office is behind this. So the taxpayers are paying for it. Now, whether Nathan's billing for this or not is a separate story, but yeah, I mean, like Adam, Abbate, all these guys, that's Fulton County money, baby. Fani's not paying that money, even if she has cash. What's up? Illy Lopez says, they need proof beyond a reasonable doubt, unless you're Trump, of course. I hope all criminals in Fulton County were paying attention, since they can use the state's position on burden of proof. Yeah, total double standards everywhere we look. SD 1985 says, Wade's divorce lawyer would know the timeline. Wade would have told him on the chance that his wife finds out. Yeah, and in other words, Terrence was not telling us the truth. Joel is here, says, thanks for covering this. Thank you, Joel. Thanks for being a membo for 6 months. Amazing to have you. We got Bonnie says, can they appeal his decision one way or another? Yeah, and I think they can either way, right? If he disqualifies her or disqualifies and then dismisses the case, you know, or dismisses it, you know, at the outset, I think that she'll be able to appeal that. But I do not know specifically on how Georgia manages that. Johnny 5 says, Fani is the DA, and there is no excuse for her to say that she did not know what the ethics laws were. She knows that transactions with cash would need to be documented, yet she said she had no clue, which in her position as a professional is not believable or competent. She's a licensed lawyer. We take exams on ethics. We have to take an ethical exam before we take the bar exam. And then you go through character and fitness. It's ridiculous to say that she didn't know, you know, that they didn't know what a gift was or what a marriage was or what a relationship was. This old guy says, I'm convinced that Nathan Wade, Terrence Bradley, Fani Willis, and all the rest of the prosecutors think that they have the cloak of invisibility surrounding them in Atlanta. I think you're right. Like, they think there's not going to be recourse here. The judge is not going to do it, or they're already protected. There'll be a public backlash that they think they're on the right side of history. Who knows? Roy says, I wonder if there's CCTV footage in the restaurant. That's a great question, too. Midnight Spirit is joining us. Welcome aboard, Midnight Spirit. Good to have you. We do member streams in the morning on Saturdays, and we'll see you tomorrow. Hey, what's up? Riptokus says, the Illinois disqualification of Trump is fully correct. Trump is not eligible to be president. Presidents can only be elected for 2 terms, and Trump already won twice. Well, then I guess we're going to have him a 3rd time, aren't we? JPB and AZ says, I'm a bit behind the live stream, those dang pesky work calls, but wondering if all DAs are this boring in their closings. A lot of them are. Yeah, a lot of them are. This guy was especially boring. This guy allegedly has 10 years of experience trying cases. Seems like this should be used in law school class. How not to do closing arguments or how to bore your jurors to death. And the PowerPoint for closing, I've never seen this in any civil trial. I've seen it in either a first or second chair. Anyways, thank you, Rob, for streaming and the expected breakdown after. Well, thank you, JPB. Yeah, it's great to have you, and I'm glad that we got to go through it all together. Thanks for the nice dono. You know, like, I'm not opposed to PowerPoints. So there's a great couple of attorneys in Arizona who I know well, who are excellent DUI lawyers, and they have excellent DUI PowerPoint slides. But they show visuals, right? They show what the gas chromatography machine looks like so they can explain to the jurors, look at all the tubes that go into this thing, you know? And so like PowerPoint can be a very effective tool, but not the way this guy was using it. He was like reading from it, and like that's the number one no-no. Knox says MSM is calling Big Fanny's presence at closing defiant. Yeah. I call it not doing any work on a Friday. Yeah, she didn't do anything. She just went to go observe and then pass him a note. Give me a break. Scott Benbow is our newest supporter. Welcome aboard, Scott. Great to have you. We got Joe Sapp. Says, will the voicemail from the waiter be admitted? It's pronounced Joe Sapp, 23. What's up, Joe Sapp, 23? In the house. So good question. The judge said he's willing to hear other things, but I don't know if he's going to want to accept that as evidence. And maybe he'll accept the wine affidavit as evidence and submit, and maybe he'll accept it all. I don't know. But the judge, you know, the judge was, we don't know. We'll see. We'll see what he does. I think he's going to be, I hope he accepts it, right? Because these people are lying, and he needs to stop them from lying to him in his courtroom. And if they want to get the wine stuff admitted, admit this one too. And it's, again, it's extrinsic impeachment evidence against Terrence Bradley. So I think they have a better basis for this, actually, than the wine guy, because it's brought in to impeach Terrence Bradley. He said he never met with Nathan, not for 2 years. Of course they did. Good Logic in the house, man. Shout out to our friend Good Logic. And so if you're not already subscribed to Good Logic, you should be. I certainly am. And the reason being is because he does great coverage of legal stories, just like we cover here. Very smart man from the state of New York, by the way. And so probably going to be covering a lot of the Trump trials, just like we're doing. So go subscribe to Good Logic. He's right next door on YouTube, right next door on Rumble, and right next door on Locals. Good Logic, Joe in the house. Great to see you, Joe. Thanks for coming over and joining us, my friend. Joe does great work. We love Joe. Babs is here. And Wild Thing says, LOL, finally a receipt. Finally. Can the waiter bring it with him? They got one receipt out of this whole dang case. Amazing. Dustin F says, there has to be a different pre versus post trial. The appearance standards applies more liberally before a trial due date to the prejudice on the accused post trial. Yeah, and I think you're right about that, Dustin. And even Judge McAfee was getting into that, right? He was asking him, isn't it, that's like a post-conviction thing. Like, why are you telling me about that? It's different now. And I think he really lost the plot on that one, the government prosecutor. Basically admitting that it is about like important conduct in the trial or in the pretrial process. It's even, you know, a motion to suppress is enough. Well, that's interesting, because if a motion to suppress is good enough, isn't an indictment? Yeah, busted. Richard P. What's up, Richard? Our newest supporter on the YouTubes. Taylor B. Also in the house. What's up, Taylor B? Thanks for sending this one in. First super chat on a live stream. Happy to be here with you. We got Not a Bot. Says, love your show, Rob. Do we get a badge for sitting through Adam's PowerPoint? We all do. Yeah, we all do. We all have earned a star on our refrigerator for dealing with corrupt scumbags. We all get a star for that. We all lived through it. And so, you know, treat yourself well, Not a Bot. Ice cream tonight, one scoop, whatever. We did it. We earned it. And it was painful. We got Love the Crake says, how much cash does Willis and Wade carry around daily? Well, that's a good question. We didn't get a quantifiable number, but like 1,000, you know, 1,500. She goes on trips. A lot of cash. KT is bringing in, Katie bringing in 10 new membos. KT. Merms is here. Kim S. Nurple's coming in. Digital Soldier, the original outlaw. Spitfire, the DJNA Tronic. Brian B., Christy M., and Anonymous. All got gifted Membo's courtesy of KT in the house. Hey, Ryan H. says Good Logic sent us here. What a nice guy. Man, Good Logic is just a classy dude. For sure. Shout out to Joe. Thanks, Ryan. Thanks for coming over and saying hello. Crash B says, Rob, thanks to you, Viva, Barnes, Ricada, Good Logic, I'm learning how the media is using word salad to misdirect all of us normies. Thanks again. Yeah, there's a lot of great people covering this stuff. And it's wild that we live in two different realities, right? The media says Fani is triumphant, defiant. Come on. Like, guys, stop selling us this fake propaganda. Good to see you, Crash. We got Taylor B. Says, why hire a divorce attorney 3 years early? Yeah, it's good question. Yeah, because he didn't, that was bro talk, not pro talk. And they lied to all of us about it. Good to see you, Taylor. Thanks for that. KT, another one, KD. And are these roses? That's beautiful, KT. Thank you for that, for the lovely dono. Another kid is here. Says, I saw how Adam tried to insist on facts that aren't in evidence or testimony during his PowerPoint presentation. I'm glad the judge caught on to that and called him out on it. The defense did great, no doubt. And this one from Ginger Ninja says, the disgrace Fani brings to the courtroom. And I think this is, what is this from? Dishonor on your whole family. Dishonor on you, dishonor on your cow. That is from Ginger Ninja. What movie is that from? I don't recall. Glocky says, people keep forgetting that Fani was already bounced off another case in this trial because of her political bias. We saw C. Warren says Georgia primary is March 12th. Is that for Fani's office, though? That was the question. I don't know when Fani's office is on, like when they are running. T. Lewis says, yeah, I think we looked at that PDF, but I couldn't tell like when the deadlines for Fani are. I don't know. Salty Vet Dad says, no contract and loans on paper only because he was committing perjury in the divorce trial. Yes, he was hiding stuff from his wife because he didn't want his wife to know about all of his misdeeds. LC says, thank you. This was amazing. I agree completely. Thank you, LC. I agree. Totally amazing. This trial, this evidentiary hearing has been wild. This one from Truth in Action says, I think the judge is just trying to be fair to both sides, so he can't be accused of not being fair. I wouldn't want to be in his shoes. He has a difficult job. He will do the right thing. Glocky says, interesting headlines from CFP, Citizen Free Press. Citizen says, you don't need 2 weeks if you're keeping her. You need 2 weeks if you're disqualifying her, and you need to prepare and write a detailed opinion. That's a good take. Yeah, why do you need 2 weeks? Make sure it's bulletproof. God Rides a Harley says, I'm not a troll, in just old. Shush hope, and thanks for the membo. I'm not a troll, I'm just old. And thanks for the membo. Glad to have you. God Rides a Harley in the house. Show Bizzle says, today watching closing arguments was the most satisfying thing I've seen in a very long time. It was awesome. They became so confident with the power they were handed. They became a very sloppy in the aftermath. And boy, was that showcased today. They deserve everything coming their way. From Show Bizzle. New membos, Channa G. What's up, Channa? Joining us. We'll see you in the morning as well. Dijan D. We'll see you in the morning, my friend. Charles W. says, every prosecution ends in habeas corpus, and this is the best the government can hope for. I think they pulled out all the stops in this, and they are grasping, and I hope the judge does the right thing. Holly K. says, thank you so much for covering this. You're my favorite to watch. I can't believe this is happening, but thank God some of us can see through the lies. Thank you, Holly. It's a very nice compliment. There's a lot of amazing people out there. We're really glad to have you as a membo. Grateful that you're here. We are, I think, peeling back the many layers. They try to obfuscate the truth, and we just keep peeling it back. I'm sure they hate that. Roy says, that remark was about the defense claiming attorney-client privilege for Yurdi. She gave testimony of when the affair started, not the attorney. The attorney didn't give testimony. Yurdi did. Talking about the prosecution Yes, I got it. Yeah, prosecution. Yes, talking about privilege. That was Adam Abbate did. Hey, Ike's girl says, Anna Cross was in the lower left box on the screen at the end. She was she? Interesting. I did not catch that, Ike's girl, so she popped in. Tony Hay Munkets says, we actually need to thank Big Fanny for the thousands of new subscribers. That's true. That's true. We have a lot of activity on our channel. We're grateful for that. And yeah, thank you, Tony Hay. We're super grateful to have new subscribers. Yeah, Fanny's the gift that keeps on giving here. John G says, back up to an hour 45 minutes. Anna popped up on the Zoom. That's 2 for 2. Good to see you guys. Thanks for catching that one. Conservative Mama in the house says, thank you for the great stream. By the way, my homeschooled 10-year-old made a better PowerPoint presentation on the Civil War with transitions. She laughed at his PowerPoint game. Amazing. Shout out to conservative mama and daughter who are just destroying the PowerPoint game, even beyond even prosecutors. I'm sure it's great. It sounds like a great one. The Civil War, I'm sure it's a great presentation. So shout out to conservative mama and daughter doing great work over there, studying the important stuff. Hey, Flash River. Yeah, what's up, Flash? Flash, thank you for saying this, because I'm not really good at accepting things I'm not really good at accepting stuff, And when Steven sent in this $400 tip, I was like, oh my gosh, I don't know what to say. What do I say about that? So Flash, thank you for sending in some support on the back end here. Says, hey, Stephen M. On behalf of all of us at Watching the Watchers, I want to extend our deepest gratitude for your incredible generosity and support. Your donation is not just a contribution, it's an inspiration. It's a testament to the remarkable spirit of giving and the commitment to the values we hold dear. Justice, indeed. So amazing. Amazing. A great comment, Flash, and thanks for sending that in. It's like, wow, I don't even know what to say about it. It's really, really, really cool. So Stephen, thanks for doing that. And it goes to good use, man. It's, we reinvest a lot back in the show and we're still building. So very great. Thank you for that, Flash. And thanks for helping me figure out what to say. We got this one from Brandon Lee says, I need those CDRs. Those CDRs. Like the rewritable CD discs. We need a lot of evidence in this case. I'd like to see a lot of it. Mima says, this annoying lawyer, he speaks just like Justin Trudeau. I had to mute him at some point. I know. We couldn't do that here, unfortunately. Maybe we should just muted it for all of us. We're not going to listen to this weirdo. Okay, once again, thank you so much, Robert, for your dedication. I'm learning so much. Thank you, Mima. I'm learning a lot too. We're seeing, this is all new. This is new. It's new in Georgia. Judges never seen this before. Anyone have any idea what I'm supposed to do? They're like, no, not really. Amazing. Thank you for that one, Mima. Charles W. in the house. Thank you, Charles. Welcome aboard as our new membo. We got Ella says, death by PowerPoint. We all suffered through it today. Quiet Your Mind Now is our newest supporter. Quiet Your Mind Now. It's important. We just talked Zen Wellness yesterday. Wojo says, good thing I didn't play the do a shot every time that guy said otherwise I'd blow a 4.0 or higher on the breathalyzer. That's dead level. Pamela B says, Fanny is so arrogant. I think she likely is very difficult to work for and with. Just like Yurdi coming to her in honesty, and Fanny hung her out to dry. Congress is going to get to the bottom of that one. We hope so. Yeah, Congress is investigating. She's got bar complaints. She's got several complaints in a city council meeting coming up on March 7th. America First Legal suing her. Jim Jordan sent over a subpoena. CDR call detail records. Thank you, B.H. Williams. I was thinking CDRs of when I think of CDRs, when you pick up discovery from a prosecutor, oftentimes they'll give you CDRs, like CD-ROMs, and they want you to turn in blank CDRs to it's wild. And I don't know if they're still doing this. I think in some jurisdictions they are. They'll give you CDs and you give them back CDRs. They won't give you the CD unless they get one back. You're like, just give us it. So then as a defense lawyer, you have to carry around CDRs in your stupid briefcase to turn those, to exchange them. It's ridiculous. Okay, they cost like 7 cents. Can I just give you like $100 and you'll never ask me for a CDR ever again in my whole life? No. Bring the CDs. It's prosecutors, man. They're the worst. Yeah, anyway, so thank you for the clarification on that. Congress, we'll get to the bottom. Lisa PS is a new supporter. Welcome aboard, Lisa PS. Woodchip Bill says, just think this is the team prosecuting Trump and the 15 other defendants. There's hope in that. Yeah, because they're incompetent. And we've seen this from the very beginning. All right. Even before this relationship stuff started, we were calling out their incompetency when they executed diversion deals. We could see behind the curtain. They kept showing us conviction. No, first of all, they were diversions, not convictions. And we could tell it was a joke from the beginning. Senevies says Merrick Garland speaks just like Adam. It's so frustrating to listen to. Yeah, speak like you have a point to make, like you've been here before. Glenn Croy says, always remember to tip your waiter so he doesn't impeach you later. Great advice. Surfer Rick says, Your Honor, we contend that Bradley's testimony is inadmissible. He was distracted by defense counsel's giant areolas. Let me direct your attention to slide 6, depicting a low-cut, sheer-top Ashley Merchant, whatever she was wearing during their courthouse meeting. From Surfer Rick in the house. Holly K says, I sent a super chat and it never got read. Well, hopefully we read it, Holly. I think I read one from you earlier. So hopefully we're getting caught up on it. Hopefully I got you on that one. Squirpid Black Dragon says, can McAfee order state to produce Fani's CSLI? I suppose he could. I don't know that he will. But the call log stuff? Yeah, I don't know. And I don't know if he's going to do any of that stuff now. I mean, we're kind of post-hearing, post-evidence stuff. I don't know if he's going to even really accept new evidence, maybe other than those affidavits. Flash says, Rob, maybe I missed it, but have you discussed the Hunter Biden transcript yet? No, we have not. We've been all on the Trump saga over these last few days. We've got this one from Mark C. says, I've been very curious who granted Fani's time off and how many vacations like this she took prior to dating Wade. It's a great question, Mark. Yeah, and in other words, was this new behavior or was this similar behavior? And I think it was new behavior, right? They weren't traveling around until he got appointed. Then they started going on cruises because he had money and she appointed her lover. Holly K says, now I've sent 2 super chats that you didn't get. I think we got them. I think we're just a little bit backed up, Holly K. So we had about 200 of these to go through, and I'm very grateful for them, but hopefully we got them all. Kay Thomas says, hi, Rob. Hubby wants to see this on the screen. Great coverage. Shout out to Mr. K Thomas in the house. Got an amazing wife. Very generous, too. And we're appreciative of your support of the show at the K Thomas household. Shout out to Mr. and Mr. Thomas in the house. What's up, Linda H? Linda, a very generous one. Says, I love you, Robert. You are the best. God has a wonderful woman of God for you. Please pray and be patient and wait on Jesus. That's great advice. That is great advice. And I will do that. And I will pray and I will be patient. And it's all going to work out because it will. Thank you, Linda. I have a lot of thoughts flying through my head on that one. It's a very nice comment, and I'll take it to heart. Thank you, Linda. Very generous. We got Becky E. is our newest supporter. Welcome aboard, Becky. We'll see you in the morning as well. Jetstream says, thank you for your voice and your expertise, Robert. You are providing much comfort to people like myself that are concerned about what's going on in our country. God bless you and your family. Jetstream, man, so nice of you to say that. God bless you back, my friend, and your family as well. And can I just say, you give me comfort. Okay, we're exploring all of this together. And I've said this many times, but this is the best part of my day, to come here, learn, have fun, engage in this stuff, and to be met with other people who care about these same issues that I care about. And we're doing the right work. We're on the right side of history here, my friends, and we're just going to keep on going. Thank you, Jetstream. God bless you too, my friend. Surfer Rick says, seems like Fani lives alone and she eats out a lot. Yeah, I think there's some evidence of that. An audit of her Publix groceries might show less than $5,000 a year. She would have to go to Publix every 3 days for a year to collect $100 in cash back every time to make that 10 grand. Probably wasn't going frequently during COVID months, 2020 to 2021. Yeah, and so it just doesn't add up. Oh my gosh! James Mangini. Oh my gosh, James. My man. I don't even know what to say, dude. Wow. Oh my gosh. James Mangini with a super chat. Extraordinaire, man. James, thank you for that, dude. I don't even know what to say about that. So, James and Steven, man, you guys are just awesome. And everybody, man. All of your contributions are so appreciated. I don't even know what to say. James, thank you so much, man. And Steven, thank you. And everybody, thank you. We got a big vision for what we're doing here. And we're really trying to increase our impact, right? We're building the lodge out, and I'm trying to figure out how to juggle all the things that we want to do and accomplish here so we can really increase our impact. And I feel like there's an urgency afoot, right? We've got this election coming up in November. And so there's a lot of work to do, and there's a lot of people to reach, and we have a lot of energy that we need to generate in order to be successful here. And your support is just really appreciated. It's really, really humbling and humiliating. I mean, it's humbling, and it brings humility. It's like, oh my gosh, I don't even know what to say. So James, thank you. Steven, thank you guys. I mean, really, really incredible. And absolutely, we hit all-time highs today on Super Chats today. Just incredible. It helps all of us, right? It helps all of us. And so it gets reinvested back into the work that we're doing here. And I'm putting my heart and soul into this thing for the foreseeable future. And so to know that we've got support out there like this is just really humbling. So I'll try to get better at accepting things, but I just don't even know what to say. So James, thank you so much, man. Really, really grateful for you and for everybody. Thank you guys, right? It's contributing to the longevity of what we're doing here. And I couldn't be more grateful. James, thanks again. We got this one from Gabriel. Says, if the judge rules against the defense, can the defense have a good appeal case due to the judge being a donor or a supporter of Fani? It's a good question. I don't think that has come up here. So I don't know that that would be an appealable issue. I think they'd have actually better other things to appeal on. But certainly, if he rules against the defense, you might say maybe there's something to that. Otherwise, you might say it's just de minimis. It's not something that matters much because even the defense attorneys haven't brought it up yet. But it's an interesting question. This one from Dan says, Anna didn't pop up. She wasn't there. That was inside the PowerPoint that was recorded. Oh, okay. Yeah. And he skipped that, right? He had a video that he was going to play of Terrence Bradley, I think, or the Gabe phone call. And he skipped over that. So that's what Anna was there for. Yeah, I saw that. Quantum Thug Life is here. Says, oh, bringing in 5 new membos. Quantuming it out, thugging it out in multiple dimensions. Zanti Pelosi's coming in. Charlie M, Valerie W, The Real Hydro, and Beth M in the house. All coming in courtesy of Quantum Thug Life. Bringing in the newest of membos. Country MNC says, he's only been a judge since 2023 and the term is 4 years. I thought he was up for re-election. I thought I read that somewhere. I could be wrong about that, but I thought he was up. Maybe he was appointed. Yeah, I think he got appointed. And so this is this is his first election. But I think he got appointed by Brian Kemp. I think that's the distinction. Milo Phone Bill says, hopefully the judge will clean up his court and put Fani and Wade in jail. We got CDR. Thank you for the correction. CDR equals call detail records from phone billing records. Thank you for that, BH Williams, for correcting that. Yes, Rayla says, can the new info from the waiter be added to the judge's info he's using for his decision? So yes, so definitely they can submit it. Whether he incorporates it, I think is still an open question. But at the start of today's hearing, he did say, yes, you can't talk about it today because they haven't seen it, but feel free to submit whatever you want after we're done here. And if we need to reopen evidence, we'll reopen it. But in other words, the judge has said, if I've heard enough already, then I've heard enough already. And I don't need to keep hearing this stuff. If he's already decided to disqualify them, and that's not going to make him disqualify them harder, then he doesn't need to hear it, I guess. Truthfinder says, hey, Rob, will all these other ethics investigations in Georgia influence Judge McAfee's ruling? Probably not. Like is he going to, legally, no. Like legally, he's going to consider what's happening in his courtroom and what the law says. But in the court of public opinion, like if Georgia Senate is going after Fani, if Congress is going after Fani, and he's like, I better get out of this splash zone, out of the blast zone, then maybe it might have some impact, subconsciously, but not in the opinion. B.H. Williams says, compact discs make great improvised weapons. Just break one in half. Yeah, and they're kind of like little ninja stars. You can really, you ever hit somebody in the head with a Frisbee CDR? Or ever been hit in the head with a Frisbee CDR? It's not good. Doesn't feel good as a recipient of one. Maria K. says, Capsule asked me to send this for him, Capsule, because he doesn't have a credit or a debit card yet. He loves you and all the boomers in the house. Well, shout out to our friend Capsule. Capsule in the house. We love you back, Capsule. And thank you, Maria K., for facilitating a dono. And since you put it on your card, hopefully he pays you back in cash. See what I did there? Paul K. is here. Says, hey, thanks for your expert coverage. Without it, I'd be lost. And I learned tons about judicial proceedings because of your running commentary. Paul, thank you for that, man. Really nice compliment. And I'm glad you enjoyed it. I really enjoy it too. It's a journey that we're on together. Hey, Truth in Action says, so cool to see all the love, man. Everyone wants more. I agree. It is so cool, Truth. I'm very humbled today. Very humbled. We got Elizabeth Capone Cook says, thank you with a Shibu Inu. Thank you, Elizabeth. Thank you for sending that in. And shout out to our Shibu friends. Tony Hay says, we love you, brother, and we need you and we appreciate you. And I love the chat. Gives me a place to vent. We are all here seeking the truth. And I'm with you on that, Tony Hay. And, I'm not going to get it right all the time. And we're going to have some, maybe disagreements on that. But we're all, I think, trying to get there, like trying to sort this stuff out. And we're learning in public, right? Peeling the layers back in public, trying to unpack this all together. And we couldn't do it without you. Like none of this would exist. So I'm so grateful. Thank you, Tony. Ginger Ninja says, you all need to slow down all this encouragement and support. Going to give this grouch the feels. Ginger Ninja. I know, man. It's like, I don't even know what to say. I'm like, oh, it's really, really, really amazing. And it's just, it's a whole new, it's a whole new experience for me, like on a personal level. It's like, well, I don't even know what's going on right now, but I know that we're on the right side of history here, fighting for, these principles beyond everything else. And so it's just a beautiful thing. And so, Ginger, thank you so much. I know it. I know it. Okay, my friends, those were the incredibly generous donos today. And I mean it when I say it. I couldn't be more thankful for it. We wouldn't be able to do all of this without your support. And we're just getting started here. So thank you for all the love today. Before we go on over to watchingthewatchers.locals.com, let's say hello to our friends on the X platform. And then we will wrap it up. And so who is joining us on the X? We had some nice people coming in. 12 viewers. Hey, that's still double digits. We'll take it. Hey, look at this one. Hey, and Danny says, no, at one point you had 211 today. And we're wrapping up. All the legalese is over. What's up? Robin O'Donnell's here. Says, this has been so interesting. Says, he just proved their point. He dug himself into a hole on the other side's argument. Boom. Says, Wade cracks me up. Fred Petamonte says, Wade and Bradley, they met a few weeks ago, and Megyn Kelly saw that. Hey, look at this. Raven says, afternoon hearing in the classified docs case, both sides clashed over unsealing. And yeah, so Florida's going to be busy. Simply unacceptable. Says, fantastic work today. Super enjoyed it. Me too. Forgotten my name. Says, fantastic show today. Thank you, Robert. Equality Scout. Sandy Beach. Mike Longwell. Yeah, we got that Phil Holloway quote. We got Mike says, shout out to Megyn Kelly, man. Super true on that one. Equality Scout from UK says, was surprised that Sadow was not more precise or accurate about the phone records. Wade said he'd visited the condo no more than 10 times. And those records contradicted that. So good to see you. Sal's Million, Andrew Richer says, I had a difficult time staying awake during that closing argument. Brian's talking about Nathan's hot dog. Eric says, where did Fani go? She just got up and got out of there. Lon B says, yeah, what about Jenna and Sydney? We'll see what they do, right? If it's like a blanket disqualification, then if it's a major disqualification, maybe they'll both get, all the convictions or all the plea deals will be thrown out, but maybe not. We'll see. We got this one from Ruby, says your play-by-plays are epic. Don't forget to pack your files and your backpack up. And Moan Abe in the house. Man, some great comments over there. What's up, Fred Petamonte? We got Russ is here. And I don't know what the answer is on that one. Watson says, oh, Watson doesn't like the awful feed. I like the multicam feed. Some people don't like that. Some people want the other direct feed. I'm happy to do whatever feed you guys want. I just happen to like the multicam because you can kind of watch the judge as well. Anyways, those are our amazing supporters over on X, my friends. If you want to follow us and follow other amazing people, you can do that on the X platform at Rob Govea ESQ. And of course, we're very grateful for everybody who is on the X platform following us over there. But my friends, that is it for us on the day. We are going to go over to watchingthewatchers.locals.com and wrap it up with our members only after party and debrief. This person says, please don't announce my super chat. We're not going to announce it. Jerry G is here. What's up, Jerry G? Sending this one in. And Count Drago is saying, how can the White House demand that Fox retract the Hunter bribery report? I don't know. I haven't seen that story. The White House demands a lot of things. I don't think they really care what they're talking about. What's up, Rocky? Rocky Water on Local says, hey, Rob, don't mean to get all sappy and serious, but watching all these viewership numbers and the big donos today, it's such a good feeling. When I first saw your show, my reaction was, this content has to survive. And it instantly became one of my missions in life. Make sure your show thrives and stays on the air. My gosh, Rocky. It's heartwarming to see the support increasing. Revenue too. Cheers to every watcher. You all fill me with hope. Thank you all. Rocky, it's true, man. It's really true. And, we went through 9 months of the whole channel being demonetized. Okay. After January 6th, they demonetized the whole channel because of our content, harmful and dangerous. The whole channel, okay, for 9 months. It was wild. And, so it's always kind of on my mind. It's always like, well, what happens if this happens? What happens if this happens? What happens if they cut us out here or ban us on YouTube or demonetize us again, which would be a huge hit? What happens? I don't know. But I do know that the mission will continue. And the revenue goals, the money goal, all that other stuff to me is secondary, right? It will come after. I'm not worried about that. I'm worried about pursuing the truth, sticking to our values, which are accountability, transparency, and justice, all rooted out of a base principle of freedom. And we're going to figure it out. We're going to figure out how to do it, right? Figure out how to grow the show, to produce better content, and be more impactful. And money's just a part of it. Money's just a tool that we can use to accelerate that. But if you don't have money, then you don't have any of this, right? You got to go do something else. And so the fact that there is support out there adds to our anti-fragility, right? Being anti-fragile, being strong, robust in case something happens is very, very, I think, important to our long-term mission and honestly, our long-term survival. And so I'm very grateful for it, because we got work to do and we got a long road ahead of us, and we're going to keep this train on the tracks and the gas pedal pushed to the max. So thank you for that, Rocky. Such a beautiful comment, man. What a great day. Hey, Florida Constitutionalist says, thank you for all you do. Great channel and superb chatters. Godspeed, Patriots. That's the point. We got the best chatters. We got the best mods. We got the best entire community on the whole interwebs. And we're super grateful for everyone who is supporting us. And so Before we wrap it up, my friends, and head on over to watchingthewatchers.locals, we had another comment. Milo Phone Bill says, dang, after reading his text with the Scorpion lady, Ashley's brooch pin, that's what I said. Here's what Terrence Bradley said when he was reading the text messages. Oh, dang. And I think he did actually say that. He did actually say something like that. So, all right, very funny. Odysseus, thank you for that last one, skidding in here. My friends, before we wrap up, want to thank our amazing mods. And man, we had a lot of clipping today, so thank you to our mods. Donut, I see John Allen's clipping for us. We had John McGarvey's helping out. Man, amazing. So all of our mods and our meme smiths, including the Antikiss Prime, K-Bean in the house, Just Cause, we got Playin' Hooky, Ronnie Cole, our friend Zulu, Beyond Geo, Zach Nichols is here, John Allen, Janek 909, Dog Digger, and of course, Donut Mind Me, modding down the fort for us and keeping things nice and orderly there. We got Sleepy Dog Lee, Nathan N810, and Geegum Geegum as our meme smiths, all making this place beautiful as well. But my friends, that is it for us on the day. Hop Bryce says, would make a great I'm Not Fragile. Anti-Fragile is the name of a great book by Nassim Taleb. It's back there in that series called the Incerto series. It's a great concept. I love the concept of anti-fragility, one of the most important. And Odessia says, keep up the great work. Thank you, Odessia, for sending that one in. Now, my friends, that is it for us on this beautiful day. Of course, we are going to be waiting for a ruling from Judge Scott McAfee. Going to be a couple weeks, but we are going to be back here on Monday to get into it all again. Now, before we do, it's a good idea, at least for me, and maybe for you too, to get out and unplug from some of this madness. There's a lot of it going on in the world around us. And over the weekend, we have a moment to unplug, to get outside, to spend time with our friends, our family, to get some vitamin D, get some extra movement in, get some extra rest in, relax, recover, unwind, because we have to recharge our batteries, get them nice and full, rejuvenate our spirits, rejuvenate our souls, and come on back here on Monday to get into it all again, because there is a lot of business to attend to, and we need to get into it together. And to do that, we need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a great night, my friends, and a beautiful weekend. We'll see you right back here on Monday. Bye-bye.